diatribes these days.
Until they are removed out of our country and back to the country from which they came.
DHS has a lot of room to maneuver within that space. It was guided by a case called Chevron. And the Chevron case said, if the statute is clear, the government has to follow the clear language of the statute. H-4s are stealing U.S. worker jobs. Now, they lost, and it's not surprising to anybody who understands administrative law why they lost.
Hello and welcome to another compelling episode of the Immigration and Jobs Talk Show. I am Rivera, your host. And before I move ahead, I would quickly like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to another compelling episode of Immigration and Jobs Talk Show. I'm your host, Rivera, and today we are diving into a subject that could reshape the landscape for H-1B visa holders and their families in the United States. If you or someone you know is navigating the complexities of US immigration, especially within the tech sector or other high-skilled industries, this episode is something that you won't want to miss. Recently, the US Court of Appeals made a groundbreaking ruling that upholds the right of H-1B visa holders' spouses to work in the United States, a decision that has garnered widespread attention and sparked significant discussion. But what does this ruling truly mean for H-1B families, American workers, and the broader immigration landscape? To help us unpack these crucial questions, we are thrilled to have with us today one of the foremost experts in immigration litigation, Jonathan Wasden. Jonathan has been at the forefront of landmark cases that have shaped the future of US immigration policy, particularly around H-1B visas. We'll be exploring not only the implications of this recent ruling, but also diving into the broader context of the H-1B litigation and how his firm is leading the charge in defending the rights of visa holders and their families. So without any further ado, let's welcome Jonathan Wasden to Immigration and Jobs Talk Show. Okay, so John, welcome to the show. We are again thrilled to have you back with us today. So how are you doing?
Good. How are you doing?
I'm doing well, fine too. Thank you so much for asking. So, John, now, I would directly like to jump into the questions. And firstly, I would like to know the basic understanding of the ruling. So, my very first question to you is, can you briefly explain the significance of the recent US Court of Appeals ruling that upheld the right of H-1B visa holders' spouses to work in the United States? What do you have to say?
Yeah, so that case was brought by a rabidly anti-immigration group. And it was premised on the idea that H-4s are stealing US worker jobs. Now, they lost, and it's not surprising to anybody who understands administrative law why they lost. The structure of the Immigration and Nationality Act gives a blank check to DHS to determine which aliens, as the term that it uses, are eligible for employment authorization. And because that language is so broadly drafted, DHS has a lot of room to maneuver within that space. And the structure in place at the time was guided by a case called Chevron. And the Chevron case said, if the statute is clear, the government has to follow the clear language of the statute. If the statute is unambiguous or doesn't anticipate all of the issues, or is ambiguous rather, and doesn't anticipate all of the issues, then the agency's reasonable interpretation of the statute is going to be binding. And in this case, the statute was wide open. It didn't explicitly say H-4s, but it gave DHS wide discretion to grant the employment authorization to various people. And the court rightly said, it's not unreasonable to say that H-4s can work, especially in light of the fact that just about in every other industrialized country in the world, when you get an employment-based visa, your spouse automatically gets the right to work. And so it wasn't unreasonable in the court's view for DHS to come up with this regulation allowing H-4s to work.
Thank you so much for answering the question, John. And John, how does this ruling fit into the broader context of US immigration law? And how has there been a precedent for similar cases?
So I think it actually built on a prior precedent that dealt with OPT and CPT authorization. The same group tried to attack, the ability of students to work during their post-graduation or educational visa. So, when you look at that, those are dealing with the almost identical issue, which is what is DHS's power to grant authorization for employment. And it's pretty broad. They have a lot of authority to pick and choose who they want to give employment authorization to. In terms of its overall impact on immigration law, probably not that much, because as you look at immigration law, each individual visa category and each individual benefit category has its own statutory language. And the broader that language is drafted, the more power the government's going to have to make rules and regulations to fill in gaps. The more in-depth Congress legislates on an issue, the less freedom that the agency is going to have to create regulations. So, if you look at the H-1B program in particular, the statute governing the H-1B, there's two different provisions in the code. It's this section that's delegated to DHS is very general and very brief and just says that they determine specialty occupation. Then the meat of that H-1B statute is actually in a different section that goes to the Department of Labor. And the Department of Labor's authorities and the rules for the H-1B program are really in that section. And they're expansively drafted out and they're very carefully thought out. And every permutation has been considered in those statutory sections. And so, the government's ability to make rules under that section are severely limited because Congress has covered so many of the bases. So I guess the takeaway is in a visa category, say like an L1 or an EB1C, where the law is very vague, the agency is going to have a lot of discretion on how they determine the outcome of a particular case or a regulation. The more specific the statute is, the less latitude they're going to be given.
And also, I would like to know, John, given your extensive experience in immigration litigation, particularly with H-1B cases, how do you see this ruling impacting the strategies and defenses you may employ in future cases?
So again, this case was decided under the old Chevron structure. And Chevron was a case that said, if a statute is ambiguous, the government's reasonable interpretation must be deferred to by the courts. That's been done away with now, and now the court is given the authority to determine on its own, without deference to the government, whether or not a regulation or a final agency action complies with the statute and whether or not it's reasonable. So the whole landscape of administrative law has been altered as a result of that new decision called Loper-Bright. I think this case, the Save Jobs case, would have been decided the same way, regardless of if it was Chevron or Loper-Bright, because the statute very clearly gives DHS a wide variety with no limitations on who can work. And I don't really see any court ruling otherwise, regardless of the analytical framework that they're employing. So, that case would have turned out the same. So in future cases, it remains to be seen how Loper-Bright is going to impact us. I think it's going to the court and the judge that has the case is going to matter a whole lot more under Loper-Bright than it did ever before under Chevron, because it's the meaning of the law is in the eye of the beholder in each case, and right now that's up to each individual district court judge in the country that has a case land on their desk. So it'll be interesting to watch it develop, because I think there's the very high likelihood that different courts around the country are going to have different answers to the same questions, and how they resolve those differences is going to be fascinating to watch. And it's going to end up, again, with a new Supreme Court decision explaining how to do administrative law.
Thank you again, John, for answering this very important question. Now, I would like to talk about a little bit about impact on the technology sector. So, major tech companies have strongly supported the rule allowing the H-1B spouses to work, right? So, how critical is this ruling for tech giants like Google, Amazon, and Microsoft?
Yeah, so for those companies, I think the tech industry in general is benefited, but also the medical industries and education are also benefiting from the H-4 right now. There's a crazy number of doctors, dentists, nurses, professors that are all working on the H-4 right now, not just in tech companies. So I think the economy overall benefits greatly from the H-4. The interesting thing to me is the argument against the H-4 is that it's taking U.S. workers' jobs. The H-4 has no restrictions on it, right? You can work at McDonald's if you want to, or you can work as the CEO of Apple if you wanted to, theoretically. And so without those restrictions and without all the rules governing wages that H-1Bs have, what we see is oftentimes the H-4s are making far more in salary because they can negotiate on their own than their H-1 spouses. And so that tells me that in the economy, there is a high demand for their skills. And that high demand for their skills is because we don't have enough workers coming out of US colleges and universities that are qualified for those jobs. And because we are lacking people that can do the jobs, people that are on an H-4 that it can become more and more valuable and necessary to the economy.
Absolutely, absolutely. But John, as you mentioned, not just tech sector, but other sectors are also significantly benefiting from this decision. So could this ruling potentially influence hiring practices in other industries as well?
Yeah, I think so. I think, for a while there during the Trump administration, the H-4 was a red flag. You didn't want to deal with it because they were intentionally screwing around with the adjudication process and forcing people out of employment authorization. That's a situation that has been resolved now. And so, H-4s are back into a predictable employee model. And I think they're going to be more and more sought after the more certain their future becomes. And I think this decision made their decision far more certain and far more clear. And that just gives employers and corporations the comfort and security they need to hire people in that situation.
Okay. So, John, also in your practice, have you seen a trend of companies reaching out for legal assistance following such rulings? And how do you advise them to navigate the complexities of these evolving regulations?
So like I referenced earlier, during the Trump administration, when they were intentionally messing around with L2s and H4s and their ability to work, we had a lot of people coming to us. And so we filed a series of cases, and we had two class action cases actually on those issues. And the government settled those cases because they were going to lose. And they changed the way they do things for both L2s and H4s. The L2s were given employment authorization incident to status, meaning they can just work if they have an approved L2. They don't need an EAD. The H-4s, certain H-4s were given auto extension of their EAD, and the remaining population of H-4s were returned back to concurrent processing of their H-4 and EAD, along with the primary spouse's H-1B. So, those victories a few years ago have, really impacted, the employer's comfort and security in hiring H-4s and L2s. The uncertainty of whether or not you're going to have this person here in a few months because of USCIS's incompetent processing times is no longer there. And so, people are far more comfortable hiring H-4s and L2s. But, since that time, I don't think there's a whole lot of concern that, employers have had in terms of litigation. This case, the Save Jobs case, was, the plaintiff in that case was an activist group that is anti-immigration, and the defendant was the U.S. government. And they litigated the case, very well and quite easily. And there really wasn't any involvement from private industry in it, because I think it was a foregone conclusion that the plaintiffs were going to lose and the government would win.
And because now that you have mentioned Trump, I wouldn't want to miss this chance. Recently, when I think Trump was giving a speech, he said actually that if he comes to the office, there's going to be a deportation of around 50 to 60 million immigrants. So what's your take on that?
Yeah, the logistics of that kind of blow your mind if you think about what it actually would take. So, Trump says a lot of things. Very few of them are based in fact. And I think this is one that is just so wildly crazy that it's appealing to his base that are anti-immigration and xenophobic, but in reality, it could never happen. Because the Constitution gives everybody certain due process rights, and even if it didn't have due process rights, rounding up 50 million people and getting them out of their country to their home country is a logistical nightmare. And it's not something that could be done just with the sign of an executive order. So it's fanciful thinking, like much of Trump's diatribes these days.
Under my administration, anyone who illegally crosses the border will be detained until they are removed out of our country and back to the country from which they came.
So after you've answered this question, I would like to know a little bit about Wasden immigration litigation's role in immigration law. So John, your firm Wasden Immigration Litigation has made a significant impact in the field of immigration law. So can you share some landmark cases that have shaped your approach to litigation, particularly those involving the H-1B program?
Yeah, so the first case we did was challenging a Department of Homeland Security rule that prohibited OPT and CPT students from working for consulting companies. And so they did this rule change without following the law. They just posted it on a website and buried it in there, didn't let anybody know. And so we sued on that, and within 2 weeks, the government reversed course, changed the rules on their website, and the issue went away. The next issue that we started facing was these H-1Bs that were getting one-day approvals, or approvals that were granted after the notices, or prior to the notices being sent out. So it was already expired upon delivery of the 797. And it was just causing a lot of disruption. And it was based on a new policy memo that required that you have to have a contract for a specific project at the time you file the H-1B. And so basically what they're saying is you have to have a guaranteed work assignment for the duration of the 3 years and prove that you have that for 3 years in order to get your visa. And The other issue that was popping up started in 2010, which was the Neufeld memo, the employer-employee relationship test, which was explicitly targeting staffing and consulting companies. So we filed suit on that, and both of those issues were resolved. The Neufeld memo was invalidated by the court, and it said the law is clear. This is how you determine a employer-employee relationship. Your convoluted test is not based in the law, and therefore it has to go. And in terms of the guaranteed specific project assignment, the court sided with us and said, the law has in here a provision that says an employer can place an employee in non-productive status for lack of work. And because it has that provision that explicitly allows the employee to not work, your requirement to have proof of a project for 3 years is against the statute. And so all of those things got wiped out. And in almost overnight, what we saw was, H-1B processing times for the form I-129 went from upwards of a year down to a week, and that's without premium processing. So it really did streamline the system, and it made things much easier and much more comprehensible for the public.
Okay. Also, but John, how does your firm differentiate itself in handling high stakes immigration cases, especially when dealing with challenges like the ones posed in this ruling?
Yeah, so we're kind of in a limited space, really. Most of the large firms doing administrative litigation don't know immigration. And, if you're going to hire one of those firms, you're going to end up spending them a ridiculous amount of money just to make them smart enough on immigration to do the case. And then on the flip side, you've got the immigration law firms, and the immigration law firms are typically so used to just doing what the government wants just to get an approval that they don't really break it down and analyze and challenge, the basic ability of the government to make rules or make decisions. And so a lot of times they just lack the creativity to do it because their mindset is so focused on what do we need to tell our clients to do to get an approval as opposed to what should the law be. And so there's not a whole lot of people in this space doing this. So it's a small market. There's not a lot of differentiation to be done, I guess, because it's just such a niche. What's funny though is when I left the government, I worked at DOJ and then I went to USCIS. And when I left the government, I wanted to start a practice that was exclusively litigation and not do petition filing. And I talked to dozens of large immigration firms, and they all said the same thing, which is, oh, you can never make a practice of that because nobody's going to have an interest in litigation. And so I started my own thing, and within a month or two proved them quite wrong. But it just shows you that most immigration firms are just not thinking the right way about how to solve these issues. They're just focused on following their business model, getting things processed, getting things approved, and not making significant structural changes to the law.
Okay. All right. Thank you so much again for answering the question, John. I again would like to talk about Wasden immigration litigation, but in a while. So now I would like to discuss with you about the legal challenges and the Chevron deference. So, John, the legal challenge from Save Jobs USA argued that the 2015 rule displaced American workers. So why did the court dismiss this argument, and how did the concept of Chevron deference play a role in this decision?
Yeah, so Chevron just says that if the law is unambiguous, you have to follow the clear language of the law. But if it is ambiguous, if it's not explicitly clear, then the government can create a regulation to fill in the gap. And it's going to be upheld as long as it's reasonable. And the courts were required to defer to the government's decision unless it was, explicitly violating the statute. So in the Save Jobs case, the law was very broadly defined, giving the government lots of space to fill in those gaps. And, the court looked at it and said, okay, there's a lot of room here for them to move and make decisions and rulings. They went through the process, they created the rule, and we can't say that it violates the statute, and we can't say that it is, unreasonable. Therefore, the government wins. The Chevron case, again, like we discussed earlier, is no longer in play. It's been invalidated by the court. It's been overruled. I think this case, the Save Jobs case, would have the same result regardless if it was Chevron or its successor, Loper Bright. It's just such a no-brainer that the government can do this, that it, is somewhat surprising that they actually put together a frivolous lawsuit to challenge it.
Okay. And John, also, how has Wasden immigration litigation prepared for potential shifts in legal precedents, especially the changing interpretations of Chevron deference? And what should clients be aware of in these uncertain times?
So right now, what we're focused on is consolidating a lot of the wins that we've had in court and building on those. And really the focus that we're looking at right now is forcing DHS, which is the parent agency of USCIS, to follow the law. And, one of those areas that we're really focusing on is getting them to, play by the rules when it comes to penalizing or sanctioning people for immigration fraud. They have a tendency to do that in secret, not tell you, wait for you to leave the country. And only when you go for a visa stamp or only when you go to the port of entry to re-enter, do you find out that they've ended the fraud finding against you. And you have no chance to defend yourself then. So we're trying to get the focus back on to DHS to say, you have obligations under the law to give notice before you do this, to give an opportunity to respond before you do this, and to give a written decision explaining why you did this so that we can challenge it in court if we disagree. And we're slowly moving the needle on that and holding them responsible. And I think as more courts see it, they'll side with us on that. And what was your second question? Sorry.
So I also wanted you to also advise, what should clients be aware of in these uncertain times?
So I think you should always keep an eye on what should the law be, not what is expected by USCIS. If you're focusing on what USCIS wants, then you're just giving in on the core issue of what the law should be. So focus on what makes sense, what it looks like the law says, and when USCIS is doing something that is at odds with that, don't just roll over and give them what they ask for. Push back and fight, because that's the only way that you'll force them to maintain sanity in the system. What we saw for decades in the H-1B program especially was companies and law firms just rolling over and not pushing back on what the law should be. And it led to USCIS making increasingly arbitrary policies and rules because they knew they would never get challenged. In fact, when I worked in the government, I would highlight certain issues that I thought were vulnerable in litigation, and they would say, we don't have to worry about that because nobody's going to sue us. So changing that mindset within the agency makes them a lot more cautious, makes them, work a lot harder before they make policies and rules to make sure that if they do get sued, they won't be, ruled against by the court. So by being aggressive, by, pushing for what you think the law should be, you make the government more responsible and you make them more cautious. And I think the industry, and the country as a whole benefit from the government being more cautious before they do things and actually thinking through their decisions before they pull the trigger.
Wow. Okay. That's a really good advice. But John, does the law and USCIS, does they not go hand in hand? I mean, are they two different?
Very much so. And in fact, USCIS's history in following the law has been very spotty, checkered, maybe gray. So just because USCIS says something doesn't mean it's accurate, doesn't mean that's what the law says.
Wow.
A lot of their, especially when you read their decision letters, a lot of their conclusions are completely not based in law or mischaracterizing the law. And so, just because they have a policy or they have a adjudication trend doesn't mean it's backed up by the law. If they always were backed up by the law, I would not have a job. So the fact that I exist means there's plenty of places where they're screwing up and they're cutting corners.
Wow, that's a big revelation, I would say. All right, thank you so much again for answering the question, John. Now, I would like to talk about, DHS's authority a bit. So, John, how far reaching is DHS's power when it comes to shaping immigration policy?
So it really depends on which visa category we're talking about.
Okay.
So, some visa categories are very broadly defined in the statute. They're so broad that you don't really know what the standards are. When that happens, say like in an EB1C, the International Executive or Manager visa, or its analog, the L1, there's very few standards in the statute that let you know what is required to get an approval. So USCIS has filled in those gaps through policy and through some regulation and some decisions, some binding decisions. The ability to challenge those decisions in court when they deny an EB1C or an L1, it's very difficult because, my job is easiest when we can point to a clear rule that the government's violated or that they're contradicting, or point to a process that they failed to comply with when making a decision, and then we win. But when there's really no rules to apply, there's nothing for us to point to and say you're doing it wrong. And those broadly defined visa categories are tough. Now, when you look at the Immigration Nationality Act that Congress created, you have some sections that are very short, and then you have some that are very long, where they just go through and they analyze every possible situation, or they explicitly create tests for how to qualify for the benefit. In those visa categories, USCIS's and DHS's ability to make rules and policy are very, very limited because Congress thought through all of the issues already. So, it just really depends on the visa category you're looking at. I think the H-1B is thankfully a very well thought out program by Congress with a lot of rules that Congress has put into the law. And that really does limit USCIS's ability to mess with people. And that is as long as you're aggressive and you push back against USCIS. If you don't push back, if you don't fight them, they can do whatever they want.
Okay. But also, John, do you think there could be any legislative pushback against DHS's broad authority in the future, particularly from groups advocating for stricter immigration controls?
So, again, the new Loper-Bright decision that came out that overruled Chevron.
Mm-hmm.
It'll be curious to see how that plays out, because that makes every district court judge in the country the decider on what the law says and what the law means. And that creates the possibility that you could have a judge in Texas ruling, for an anti-immigration group on one hand, and a judge in Seattle ruling the exact opposite way on the same issue. And so, how that resolves and how that gets ironed out is going to be interesting to see. I think, as lawyers, we say anytime there's new law, there's new work. I think the, Loper Bright, post-Chevron era is going to create a lot of, litigation and a lot of work for lawyers that are in the administrative law space like me.
Wow. Okay. And again, John, thank you so much for answering the question. Now, I would like to talk about the impact of this ruling on H-1B visa holders and their families, because again, this is something very important. So, John, from a very practical standpoint, how does this ruling impact H-1B visa holders and their families, and what changes might they expect in terms of work opportunities and their overall experience living in the US?
So I think the good thing is it gives them a little bit more security. Okay. Now, you look at what a court's going to do now is look at the language of the law, but also look at the purpose of the law. Mm-hmm. And for the H-1Bs, the purpose of the law was to increase the number of highly educated, specialty occupation workers in the United States, because we were not creating enough of them domestically to fulfill the needs of the economy. And so coming into the case, a lot of factors are already on your side if the government denies your petition, your visa. So, the law typically is going to be on your side a lot of times. And then even when the law is not exactly clear, the purpose of the statute is going to be on your side. What the government is looking to do by denying your visa petition is exclude a highly qualified, highly educated specialty occupation worker from the workforce. Mm-hmm. And that really does go against the whole purpose of the H-1B. So it gives courts a lot more ability to be reasonable and come up with decisions that don't slavishly defer to a government's arbitrary decisions. And I think, that helps. Now, I say that, but it's important to remember, the government can screw up your life with the stroke of a pen, and that will take seconds. To fix it is going to take you a long time. So if the government does a stupid ruling or a stupid decision like they are prone to do, it takes months to fix that. And so that's frustrating, but at least there's, a light at the end of the tunnel, because the law has altered things to make it more favorable for you to challenge those stupid decisions.
Mm-hmm. Mm-hmm. Absolutely. So are there any potential pitfalls or complications that H-1B families should be aware of, even within this ruling, in their favor?
So I don't think there's any pitfalls that are out there. I think more than anything, it should concern the government that every single judge in the country now gets to look at the law fresh on its own. Because the government is a big, unwieldy beast that doesn't move very quickly, and it doesn't really have the ability to adapt very well. Mm-hmm. And USCIS in particular cannot function by looking at how, Texas views the law versus Washington State versus New York, and they can't come up with different policies and procedures for each of those different locations. And I think that what that's going to do is it's going to make them far more careful in how they create rules, just so that they create consistency across the country. Because if they start getting rules invalidated in one location but not in another, it's going to be a real nightmare for them, and they're just not going to be able to function. So I'm hoping that it'll force them to be a little bit more reasonable in the way they create regulations and make decisions.
Okay. So, John, an additional question. So, in your experience, what are some of the most common legal challenges faced by H-1B families, and how does your firm assist in navigating these issues?
So one of the more disturbing trends that we see is USCIS penalizing workers for errors or program violations of the employer. And what's frustrating about that is you as the H-1B worker have no control over anything during the petition process. USCIS, in fact, explicitly says that you have no role in this process. So you don't sign anything, you don't, give declarations to anything or the accuracy. Now, if the employer does something like not pay the full wage, that's the employer's obligation to do. It's not your obligation to get paid the full wage, right? Because that's out of your control. But what USCIS is doing now is they're revoking visas, denying visas, and saying you're out of status if you're not getting paid the full wage. That is such a clear violation of the law that they typically cave in on that when they get sued. But the fact that they're doing it is frustrating. And I think, you have to be very careful. Anytime you see an employee getting penalized for something the employer did, that's a huge red flag. That's something that, you really need to be aggressive and push back on and not just assume that the government did it right because they didn't.
Okay, and let's also talk about, a little bit about the potential repercussions on American workers. So, John, critics of this ruling, like Safe Jobs USA, they argue that it harms American workers. So, what's your perspective on this claim? And does the data support the idea that American jobs are being displaced by foreign workers and their spouses?
See, the argument in Save Jobs that they're stealing jobs from U.S. workers is kind of a symptom of the greater problem. They don't understand math. And the American economy in general is just not producing enough people that understand math and can do critical thinking. So if you look at the graduation diplomas that are coming out of U.S. colleges, very few of them are going into the STEM programs, the jobs that we need to make the economy function at a high level. Far too many U.S. kids go to school, waste time and money to get degrees in things that don't matter and don't make them employable. And so if we want to stay on top of the game, we need people who are highly educated to fill those jobs. And if we're not doing it domestically, we're going to have to import. And so if we want to stay on the top of the world economy, we have to attract smart people. So it's frustrating to see, people that should be smart enough to look at the data and say, we don't have enough of these people graduating, therefore we need to import, smart workers. Instead, they're just basically racist and they just want to exclude anybody that's, not from a Northern European white country. So it really has nothing, in my opinion, to do with jobs. It has everything to do with, their nationalist take on what immigration policy should be like. They really want to keep it just to those Northern European countries if they could.
Okay. So if the American workers are thinking like that, and if the claim, of job displacement lacks strong evidence, so John, what can be done to address the concerns of American workers who feel threatened by the presence of H-1B workers and their spouses in the job market?
So, if you look at the difference between, like, say, the EB2 and the EB3 visa categories that have labor market tests, those categories were created back in the 50s and 60s when there was a real concern about protecting U.S. worker jobs. And so they instituted the labor market test. And it's a product of history that we're kind of stuck with. When they created the H-1B, Congress looked at all the data. This was all the way back in 1989 and 90. they looked at all the data and they realized we got a problem. We don't have enough people. And so they eliminated the labor market test from the H-1B program because they realized it wasn't necessary because we just didn't have the numbers that we needed, domestically for those jobs. So, the reality is I don't think most H-1B workers have to worry about that. It's only when they go to the EB2 and EB3 categories for their I-140s and 485s that they start having to worry about some of these arcane and convoluted rules dealing with the labor market tests.
Okay. And John, also, how does Wasden immigration litigation approach these delicate situations where the interest of American workers and foreign visa holders collide? And what legal strategies do you employ to balance these competing concerns?
To be completely honest, I haven't seen a legitimate case where a U.S. worker has been harmed by an H-1B worker. I see a lot of people who are what we call bottom feeders that file lawsuits and file claims against companies for immigration violations just so they can get settlements out of the companies. Litigation, unfortunately, is very expensive. And so companies do the math and they say, just to get rid of this case, we'll give them a check. And, it saves on attorney fees. And so you have a lot of these people that are filing claims with the government of discrimination just to get those checks, but there's really no discrimination in the system. It's all frivolous lawsuits claiming otherwise. So, I just really don't see U.S. workers being harmed. Okay. I look at all of my friends that have, STEM degrees, and they work in the IT industry. They came out of college and they were worth gold because, they were an American kid that had one of those rare degrees. And they move up very rapidly within those companies because there's so few people like them. There's just not any harm that they face from other smart, skilled, talented people coming into the economy and working. So I'm not worried about U.S. workers being harmed by highly educated people coming into the marketplace. Wow,
great. Thank you so much again for answering the question, John. Also, now, let's talk about global talent competition a bit. So, this ruling is also seen as a way to make the US more attractive to global talent. So, in your opinion, how does the US currently stand in the global competition for top tier talent? And what role does immigration policy play in this?
Yeah, so I think, obviously our industry is probably the most attractive in the world. Mm-hmm. But the problem that we have is structural in that every other industrialized country, when you get a visa to work, your spouse also gets authorization to work. Right. And in the US, it's not the case. And so it's a huge disadvantage because, especially in the Indian community, you have two married people, both of which tend to be equally highly educated and ambitious and intelligent. And one of them doesn't want to just give up the hope at a career because their spouse has a visa. And so it's very easy for them to shop around and find countries where they can both work and they can both pursue a career. I think in the future, if the US wants to stay competitive, they're going to have to make some changes to the way they deal with spouses and make spouses, more flexible and more attractive to come to the US.
Okay. But do you think, because of this ruling, is there also a possibility of having a lot of scams? Because, just to get green cards, people also marry people living in the US, you must have seen cases like that, right, John? Right, John? So do you think more cases like that coming after this ruling?
I don't think so. I've been on quite a few cases dealing with marriage fraud, both within the government and outside the government. And I will say that marriage-based visas get probably more scrutiny than any other category out there. And, the the amount of inquiry they go into for a marriage-based visa is really impressive, actually. And the amount of data that they research on the individuals and cross-reference information, it's very impressive. There are some serious structural safeguards in place to prevent marriage fraud. And if you do commit marriage fraud, you are forever banned from the US, and you have no chance of ever getting a waiver or anything. And so I think the likelihood of marriage fraud popping up as a very frequent thing is very, very unlikely.
Okay. Thank you so much again for answering the question, John. And also, do you think, are there other countries also that have more favorable policies for attracting skilled workers and their families? And if so, what lessons could the US learn from them?
So I would say Germany. Not only do they have amazing beer, but they have very good immigration policy. I would say the Canadians as well. They look at the workers coming in as, valued guests, right? They're providing something that the country needs, and they don't, treat them as basically criminals that have to be inspected and scrutinized and suspicious of. And unfortunately, the way the U.S. immigration agencies have been trending is to view every single, applicant for a benefit as somehow, looking to commit fraud. And so their initial step in just about every application is, this is fraudulent, how is it fraudulent? As opposed to, all right, this is a very highly educated person, they fit their criteria, let's let them in. And so there has to be a mindset change within the government from everybody's committing fraud to, okay, we need these categories of people. Are they qualified? And that's a cultural problem that USCIS has, and hopefully in a new administration they put leadership in there that will clear that cultural problem out. But right now that's what we're stuck with.
Okay. Again, okay. Thank you so much, John. And let's talk about future of H-1B visa program a bit. So, given the ongoing debates around the H-1B visa program, so what do you think is the future of this program? And are there any upcoming changes or challenges that applicants should be aware of?
So the biggest thing on the horizon, I would say, is there's the modernization of the H-1B regulation. USCIS proposed a new regulation dealing with H-1Bs, and they took comments from the public, and they were supposed to release the final rule in June. That's been since postponed until December. I would not be surprised if it gets postponed again in light of the Loper-Bright decision that overruled Chevron, because the things that they proposed to do in the new regulation, some of them explicitly contradict the statute and are dead on arrival when they get sued. But some of them are just really unreasonable and stupid and counterproductive to the purpose of the H-1B program. So if they go forward with all of those proposals, it's going to be something that gives attorneys like me a lot of ammunition to fight, because they're just they're acting very crazy. And so I think that modernization rule with all those limitations on the H-1B program might be watered down quite a bit in the final release, I'm hoping. So other than that, besides that modernization rule, USCIS has always created more rules through adjudication trends than they have through regulation. So, you start seeing new templates of decisions and new templates of RFEs and NOIDs and NOIRs. And that's the product of internal rulemaking in the agency that's kind of done in secret. You don't really know what the rules are until you start seeing them ask for information and asking you to prove things in the adjudication process. That's always a moving target. It's hard to say where that's going to go. But I think right now, one of the things that we're seeing them really focus on is maintenance of status, and whether or not, you can extend status or change status based on whether or not you maintain status. And the way they're interpreting maintenance of status, quite frankly, is unhinged. And it's causing people a lot of problems, people who have done really nothing wrong, and it's causing a lot of issues. So I think that's one of the potential harms that we're facing right now in the adjudication trends.
Okay. Okay. And how does Wasden immigration litigation position itself in the face of these changes? And what should H-1B applicants consider when seeking legal representation, especially, with the increasing complexities of immigration law?
Yeah, so when you're in the petition process, it's important to keep in mind what the law is and what the law actually requires. And when you see them, coming up with a new adjudication trend or a new theory of ways to change and alter the rules, it's important to push back on that and say, no, this is what the law requires. This is what we provided. We're eligible for the petition to be granted. And when you're in the litigation stage post-decision, it's important not to just take whatever USCIS said as true, because you're going into court and the court's going to decide what is true and what's not. And so, you have to look at every aspect of the decision and poke holes in it and say, this is wrong here, this is wrong there. And don't just say, oops, USCIS said no, so I guess I can't get it. You've got to think creatively and, hold the government accountable.
Okay. Thank you so much again for that great advice, John. And now, advice for affected families. So, John, also, what advice would you give to the H-1B visa holders and their spouses who are directly impacted by this ruling, and how should they navigate the complexities of their work permits and immigration status?
Yeah, so the H-4 is a great thing, and it's just getting better because its future is far more certain and predictable at this point. Anybody that can get an H-4, I would highly recommend getting the EAD, just because it gives you so many benefits and so much flexibility, and it doesn't have any other restrictions that the H-1B has. And it honestly makes you more employable than the H-1 does, because the H-1B has so many limitations. So it's a good time to be an H-4, and I think it's something that everybody should try and get if they can.
Mm-hmm. Okay. And one last question before I let you go, John. How does your firm assist clients in not just understanding, but also leveraging such rulings to their advantage? Could you share any success stories or maybe examples where your firm made a significant difference for an H-1B family?
It's a long list, frankly. So a lot of our cases recently, like I had mentioned earlier, have been focusing on the employee being held accountable for the employer's mistake or error. And we've been litigating these cases quite a bit, and most of these cases, when it hits the U.S. Attorney's Office, the U.S. Attorney is defending the government in court. They look at it and they realize what USCIS is doing is crazy, because the way we present the arguments. And they lean on USCIS to fix things, and then we get a retraction of the denial and a new approval notice. And so those cases are rewarding, because you're really dealing with somebody who's done nothing wrong, but is facing all the penalties and all the consequences. And so, unfortunately, that's a growing business area for us. I wish it weren't the case, because it puts people in a lot of stress and a lot of uncertainty for something that they didn't do wrong. Mm-hmm. But it's rewarding when we get those good outcomes for them.
Okay. Okay. All right. Thank you so much, John. It was a great episode. Thank you so much again for being here. I always love doing these shows with you. Your answers are always so insightful and so in depth. So thank you so much again for a great episode.
Thanks for having me.
Thank you so much. And guys, if I hope the session was helpful to you as well. And if you want to reach out to Jonathan Wasden, you can give him a call at 844-592-7336. I would like to repeat the number 844-592-7336. His email is john@wasden.law and his website is wasden.law. So don't forget to write an email to him, and also don't forget to check his website out. Thank you so much again, John. It was a great episode. Hoping to see you next week.
Thank you. Take care.
You too. Hey everyone, welcome to another special live discussion on immigration and jobs talk show. I'm your host Rajni Bharara, and we have got a special treat lined up for you because we are diving into not one, but two fascinating cases with our guest, Jonathan Wasden. John represents clients on strategies to overcome immigration denials, including bringing cases to federal court under Administrative Procedures Act. For a majority of his career, John worked as an attorney for various US governmental agencies where he defended immigration regulations and decisions under the APA. His last position in the government was with the Administrative Appeals Office, focusing on employment based legal issues and advising on litigation in these areas. He is now a partner at Wasden Banias, a Washington, D.C. metropolitan area law firm specializing in employment based immigration and Administrative Procedures Act litigation. All right. So, today, first up, we'll be talking about a case where Jonathan and his team scored a big win, a mega win. Okay, so picture this. A group of folks with special work visas called H-1B visas were in hot water because their employer were accused of doing something shady stuff. But guess what? Jonathan swooped in like a legal superhero and fought tooth and nail for these people's right. And guess what again? He won. Yup. The court ruled in favor of these H-1B visa holders, saying they deserve a fair shake and in the government. And the government can't just yank away their visas without a fair fight. Now, on to our second case, which is still hanging in the balance. It's all about a guy named Sridhar Alavala. He's in a bit of a pickle because his old boss got in some trouble for something sketchy ages ago. And now the government's threatening to take away Sridhar's visa because of it. But hold up. Sridhar didn't do anything wrong. So Jonathan, on this case, trying to make sure Sridhar doesn't get the short end of the stick. So buckle up, folks. We are in for a roller coaster ride through the twists and turns of the legal world with Jonathan as a guide. So let's get started. And before we move ahead, I would like to read out this important disclaimer that is on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Now, John, welcome to the show once again.
Thank you. It's good to be with you.
Thank you so much. And firstly, congratulations on your recent win in the H-1B visa case. And if you can please share some of the messages that you got on social media. We were tracking your account. I mean, we were looking into the accounts and people were really congratulating you and on your big win. So if you can also please show it on the screen for the viewers, we would like to.
Yeah. So a lot of the cases that we're working on right now have a common element, which is the government didn't give the interested party in the case notice and an opportunity to respond prior to issuing what amounts to be a punishment, or what the law calls a sanction. So in the Narambalada case out in Seattle, in the Western District of Washington, it was one of those issues where the employees had all been selected in the H-1B cap lottery, been assigned a cap number, were working, and then the government yanked the rug out from underneath them and said, your employer did something wrong, we're taking away your cap number. And so it's important to recognize that when you get your initial H-1B approved, there's two different benefits going on. One is the benefit to the employer, which allows them to hire you and make money off of you. And then the other benefit goes to you, the employee, which is your right to change jobs, your right to extend indefinitely if you have an approved I-140. And so what they do in these cases is they take away the employer's right to employ and also try and strip the innocent employee of their cap number. And so very quickly in that case, in Narambalada, like early on, the government conceded the employees did nothing wrong. They're not the ones that are, alleged to have committed fraud. It's all the employer. And then they said, even if that's the case, the court shouldn't hear this issue and they should dismiss the case. And our argument has always been that the interested party in the cap number revocation is the employee, and they're the only people that get noticed because it's all on them. It's all the negative impact is all on the employee. And so that was our argument pushing, and there was a couple of other arguments, but that was our lead argument. And so the court says they are good to go forward and press their case in federal court.
Okay, great. Well, before we move into and before we dive into the details of this case more, I would like to actually show our viewers those congratulations messages by people on your big win. If you can please share those screenshots or those images here, please.
Me?
No. I'm asking my team, not you. I was just talking to my team. I'm really sorry about the confusion.
That's all right.
So, yes, but John, meanwhile my team shares these screenshots of these messages, I would like to know from you, how did the win feel? I mean, how did you feel?
It was nice to know that the clients have hope and they're not doomed forever and losing their H-1Bs. It's also nice to know that you're right. So one minor correction to what you were saying earlier. So I'm not in Wasden Banis any longer. I'm just at Wasden Law, but I'm doing the Narambalada case with Jesse Bless, and he's another immigration litigation attorney.
Okay, all right. Thank you so much for clearing that out. And okay, and yeah, as people can see on their screen, see these messages from people, and can we also have more? You are fighting the good fight, and then if we can also. Thank you, Jonathan, for your support. And this is about the Sridhar's case, actually. And if we can also show more. See, too many messages actually for John. Congrats on the great work. Make them pay. And this is awesome, John. Thank you for sharing. What a win. This is incredible. So a whole lot of messages from the people, actually. So, and now, John, coming back to you again. And now I would like to talk more about the case. If you can please, also walk us through how you and how you and your team actually stumbled upon this case in the first place, and what actually made you notice it.
So in the Narambalana case, it was all about the multiple registration issues that were, endemic in the 2022 and 2023 fiscal year lotteries. And I guess the 2024 as well was a hot mess. Mm-hmm. So what we saw is people getting selected in the lottery, working for the employer. A lot of times they didn't know that they had been entered in by multiple companies. They thought there was just one offer of employment. Mm-hmm. And the reason for that is manyfold. Sometimes the employers would get the list of employees that they wanted to hire. They would share with some other company, and then they would apply without the employee knowing. They also were using recruiting companies back in India who was mm-hmm. selling the same list of employees to multiple different employers. And that really ratcheted up the number of duplicate registrations that were going on. But what we noticed is that, when they were revoking all of these H-1s, most of the time, the employee had already moved on. They'd already transferred their H-1B to a new employer. And so the old employer typically does not respond to the notices of intent to revoke because USCIS has said they're going to criminally prosecute people. And so nobody wants to say anything. And those go unanswered. And the only person that really is impacted is the employee, because they're the one whose cap number is getting stripped. Yeah. The initial employer's already lost their right to employ. Mm-hmm. And so, they get blindsided by this at their new employer with a new notice of intent to revoke the second visa. And so if you were selected in those years that were tainted by the multiple registration, you should probably be checking your case status page regularly on the visa just to make sure that USCIS hasn't revoked it without telling you. So you're not similarly blindsided. But the employees that came to us, they were obviously they had done nothing wrong. They were frustrated with the system. And so we looked into it. The first thing right off the bat we noticed is that under federal law, the statute, the immigration mm-hmm. statute, you cannot strip a cap number away from an employee for fraud unless they're the one that commits fraud. And in these cases, the government was very clear early on. Their initial defense was there's no fraud on the employee's part because we're suing them, challenging fraud findings against the employees as well. So very quickly, they backtracked on that. Mm-hmm. And so under the statute, the employee didn't commit the fraud, so they really shouldn't have their cap number stripped away for the actions of a third party. Mm-hmm. The other issue I think that is more interesting from a nerdy lawyer perspective is that the anti-collusion rule that is being used to justify all of these revocations was never published the way the rules are supposed to be published. Mm-hmm. So USCIS went through this long rulemaking process where they provide notice to the public, they take comments, they analyze comments, and then they publish the final rule. They mm-hmm. did that when they recreated the new lottery back in 2019. And they changed the structure of the lottery. So they went through the rulemaking process, and a lot of people commented, very well-known people within immigration commented that if they didn't change the structure, it would lead to massive duplicate registrations and frivolous filings that would cause unused petitions. Mm-hmm. And so people just wouldn't have enough work for the number of employees that they got selected for. Mm-hmm. USCIS's response to that was, we're not worried about it. What we'll do to solve that problem is we will just require them to make an attestation that they will file a petition. Now, notice there was no attestation about unfairly, working with another employer, nothing like that. Mm-hmm. So the first 2 years, the lottery goes off without really much of a hitch. It's not that crazy. And then the numbers started to get crazy. Mm-hmm. USCIS realized they had screwed up. But instead of going back through the process that they're required to under the law to fix it and create new rules and put the public on notice, they essentially just put it up on their website, and that was the extent of their notice. So we're challenging that because they really did not follow the process. The federal courts are pretty clear. When you create a rule like that, you have to give the public notice in a very particular way, which is publishing it in the Federal Register. Mm-hmm. That's the only way that people know officially what's happening and what the agency is going to be doing. And they didn't do that. Mm-hmm. And so I think they have a rulemaking procedural problem. Almost all of the cases I do come under the Administrative Procedure Act, and that's the handbook the government has to follow when they make any type of decision or rule. If in my line of work, if we're arguing about facts, it's going to be a rough case. Mm-hmm. But when we're arguing about procedure, that's when we're at our best. And pointing out the procedural flaw in the rulemaking, I think, is ultimately going to be what wins the case.
Okay. All right. So, John, I'm definitely, you mentioned USCIS, and definitely I'm going to talk about the government, but a little later. But before I move into that, I actually would again like to ask my team, because I'm sure you are very busy, and also I don't know if you get enough time to read all those comments that you get on your social media and also from people all over, basically. So if you can please respond to them right now. So if I can ask the control again to please post the screenshots of those messages and those comments, and we would like to get a reply for them from you.
Sure.
Great. So there is, I can't see the name actually. Okay. Okay, so William said something. He said, "You're fighting the good fight, indeed, Jonathan. Keep up the good work." And I encourage others in that situation to reach out to you. What would you like to say to William?
Yeah, so Bill Stock is somebody I've known for a while. He works at a great firm in Philadelphia, mm-hmm. and he's one of the brighter minds in immigration law. So it's good to hear from him.
Amazing. Let's move to the next comment, please. Okay, this is about actually Sridhar's case, so maybe we can take it later. But if we can please move to, so Charles is here, and Charles also says, congrats, great work, make them pay. And what would you like to say to Charles?
And Chuck's another person I've known for a long time. A great guy down in Atlanta. Has a really good firm down in Atlanta. But we've been working against stupid government decisions for a long time. He does some litigation in addition to his petition practice. And so a lot of these issues that we're fighting, will bounce off of people like Chuck.
Mm-hmm. Okay. And Roman also says that this is awesome news, Jonathan. Thank you for sharing. What a win. So, and then I would like to read the next comment also. He says, this is incredible, Jonathan, way to go. And so if you can, basically everyone is congratulating you on your big win. And you're going to get these a lot more because you have also had a recent win where you posted, I think, a couple of hours back. So you're again going to get a lot of messages. So if we can get a message for all those people from your side.
Yeah, I mean, it's just don't give up hope is the main thing. Is that, like I said in the post, the government can screw up your life within seconds of making a stupid decision. It's going to take you a long time to fix it, but you can fix a lot of these problems. Yeah. And that's what we do. We're problem solvers, and so don't give up hope would be the big takeaway, I would say.
Okay. Thank you so much. Thank you so much for the lovely message, John. Now, I would like to come to my next question, actually. So about the H-1B case that we were discussing, before we took the comments. So if you can please talk about who are the plaintiffs involved in this case and how did you decide to represent them? And are there other attorneys also involved in this case?
Yeah, so you're talking about the Narambalata case in Seattle for multiple registrations?
Yeah. Mm-hmm.
Yeah, so I'm doing that case with Jesse Bless. Jesse also worked at the Justice Department. We're there at the same time.
Mm-hmm.
And then he got out, was in private practice, and became the litigation director for AILA for a while. And then we've been collaborating on cases now for 2.5, 3 years. And so we looked at the issue together, and we thought we had what was the better argument and the winning hand, and just went to work on it. The plaintiffs are all just recently selected H-1Bs
Mm-hmm.
that had their cap numbers revoked, and they're all from all over the country, really. But the lead plaintiff was in Seattle.
Okay. All right. Thank you so much for giving the information about, the other attorney and also, John, can you hear me?
You cut out for a second.
Okay. Am I back? Can you hear me now?
Yeah.
I'm so sorry about the lag. We have a lot of things going on. I don't know why it's happening, but I'm really sorry about it. Glad to be back. So, so I was saying about, thank you so much for talking about Jesse and also about, the case. So now I would like to know from you that what specific legal grounds did you base your argument on this recent H-1B case that you won?
So the Administrative Procedure Act, like we were mentioning before, is the rule book that the government has to follow. And when they make a rule that they intend to use to punish people or sanction people, there's a very particular process they have to go through, because you've got to put the public on notice of what they want to do, what their proposed rule is. And then they have to let the public have enough time to analyze it and provide thoughtful comments. After they receive the comments, they go back and they they go back and analyze them and decide if they should change the rule in accordance with some of the comments, but they have to respond to the comments as well. And so they went through that rulemaking process when they created the new system in the lottery. They went through that rulemaking process when they tried to change the way the lottery was structured to give better chances to people with higher wages. And then that one obviously got kicked out of by the court, and so is no longer in effect. What was interesting though is in both of those cases they were very clear that they had to go through rulemaking, and if there were additional changes that had to be made, the agency said, we will go through rulemaking. But they didn't. And so what they did is when they realized that they had kind of screwed up, they made a quick fix. They cut some corners, and they made this rule that they knew full well that they would be using to punish people and sanction people. And they didn't do it the right way. They didn't give public notice. So if you think about it, the only people that really saw this was the admin staff that were filing all the registrations. If collusion would occur, presumably it's going to be at the executive level. And so the admin staff filling out the forms isn't going to know. And so they're not on notice of what happened. And the executive staff who, made the decisions never knew ahead of time because the agency never published it in the Federal Register. So I think that violation of the notice and comment rulemaking is going to probably what gets us there.
Okay, okay. But this must have taken a lot of strategy and a lot of planning from your and your team's end, right? From your and Jesse's end, especially. And so, how did you and your team actually prepare for this battle? If you can also walk us through that. And were there any like key legal concepts or strategies you relied on, or were there any precedents from past cases that influenced your strategy?
Yeah, so one of the interesting things is the Supreme Court 2 years ago came out with a ruling that said merely posting something on a government website is not an adequate substitute for notice and comment rulemaking. So that case for us is very helpful, put it that way. But in terms of the meat of the argument, a lot of research. I couldn't tell you how many hours I spent looking through old versions of the regulation, looking at the comments that were made during the rulemaking process for multiple different rules that impacted the lottery, and just looking for those small nuggets that will help the case. And we put in the time, we put in the work, and I think we have a good case on this issue.
Okay. And now that we are speaking about the preparation, so was it like putting together one-page complaint, or was it more like sorting out through those thousand pages of legal document? What exactly goes into preparing a case like this?
I wish it were a one-page complaint. My life would be so much easier.
Right.
I think this one ended up being 40 some odd pages.
Okay.
So what you have to do is you have to look at the facts for each individual plaintiff, collect all their documentation, go through it, make sure that everything lines up, and then you have to go through and you write your arguments. You put the facts of what happened, you put the details about the plaintiffs, then the background for the law, and then why the government violated the law. And it is a lot of work. I'll be honest.
I'm sure.
It's a lot. And so, it's something that, when done right, it takes a lot of effort.
Wow. And how much time did it take for you to prepare those 40 pages document?
Well, so if you include the research going into it,
yeah,
probably 3 or 4 weeks.
Okay. Wow.
Yeah.
That's a lot. Okay. And now that we are speaking about the timeline, can you also talk to us about how much time did this case actually take from filing the complaint and everything, and then actually winning it?
So there is one thing in the timeline of litigation that we can guarantee or predict with some certainty. And that is, once you file the complaint, the government has 60 days to review it and decide what they're going to do. A lot of times in that 60-day window, they will change their decision, issue a new approval notice, and go on their way. That has happened in one of the multiple registration cases so far. So if it doesn't resolve by the 60th day and they don't settle the case, then they do one of two things: file a motion to dismiss or an answer. In the Rambalata case, I filed a motion to dismiss, saying that the court didn't have the authority to hear the case, basically. And so we responded to their motion to dismiss, and then they filed a reply brief, and it was with the judge for probably 2 to 3 months. So from the start of filing the complaint to a decision on the motion to dismiss was probably around 6 or so months, I think, as I recall. So that timeline is long. Now we move on to, they have to file an answer, and they have to produce the administrative record in all of the plaintiff's cases. And so we will brief summary judgment using those administrative records. And summary judgment is how the court's going to make its final decision.
Okay. All right. Okay. And John, also, if you can talk to us about what actually motivated you to challenge the government's action, in this specific case.
You know, it really kind of offends my conscience that they would punish people for the actions of another person. And we see that happen over and over again. They blindside the employees and make the employees pay for the actions of somebody else. I noticed that when I was working in the government, when it comes to H-1Bs, the entire enforcement mechanism is geared towards hurting the employee, and they really don't have any plan or coherent strategy for dealing with employers. And so, it just, to me, it just seemed unethical and wrong that they would be doing this. And, anytime you get annoyed or pissed off, you tend to work harder. And so that kind of helped dig into the case.
Okay. But then, John, also I would like to know from you, you have been on the government side for, defending them for the longest time also, right? So, but then now you have taken the plaintiff side. So what actually made you decide this shift?
So frustration, really, just
Okay.
frustration dealing within the agency. Looking at the law saying we're wrong, if we get sued on this, we're going to lose, and the agency really not caring. They were more concerned about the efficiency of their processes than they were about getting it right. And this whole issue of notice to beneficiaries who are about to be punished highlights that issue. It would be too much work for them to actually follow the law and give notice. So they do shortcuts, and they think that they can get away with it by not giving the person notice that deserves it and save some money and time by doing it that way. And hopefully that will change as a result of these suits.
Okay. But then, John, also I would like to know from you, it's no secret that taking on the government in a legal battle can be, intimidating for many people, right? And so there's often a fear that, they might get into trouble or face repercussions, right, for challenging the authorities. So if you can also talk to us about this common concern that people normally have, and what advice do you have for those individuals who may be hesitant to take the legal action against the government?
So the first thing to keep in mind is anytime you're suing the federal government, the rules are stacked in their favor. So you start off right off the bat with the government having a head start or a lead in the case. And so you really have to outwork and outthink them in order to win. So I would say probably the government wins more than 60 or 70% of cases that they litigate fully. So just understand that it's not a guarantee, it's not a lock, it's something that's going to require a lot of work to get done. But in terms of the actual employees, I think the best way to answer that is with an experience from when I was in the government. I would look at potential litigation cases at USCIS and the AAO, and there would be nothing in the file that would suggest that the petitioner was going to sue or do anything in court. It's just what's that?
Yeah. No. Please go ahead.
Oh, so with the AAO, I'd get these potential litigation cases, and there would be nothing in the file that would suggest it was a potential litigation case. It was just a regular appeal. And what made it a potential litigation case is the company had sued before. At that point in time, there was like 12 lawsuits a year on H-1Bs. And so it was very rare. And somebody had sued before, it was everybody's memory of that happening. And so a potential litigation case was code for, don't deny this if at all possible, because we don't want to have to do the extra work the litigation causes. And so I know a lot of people think that the government will retaliate against them or like seek them out and punish them. For the most part, I don't see that. For the most part, I see if you're annoying to the government, they try to leave you alone because they don't want to deal with the extra work.
Okay. But John, I also would like to know that is it even legal to sue the government? Because, it sounds like a plot straight out of a legal drama.
It's not illegal to sue the government, but it's illegal for the government to retaliate. And so if they do retaliate, there's things called Bivens actions, which allow you to sue whoever was responsible for that decision. If you can prove that it was done illegally. And that's one of the few areas where you can actually get money damages as a result. But typically, it's very difficult to find that type of evidence that they targeted somebody. I think empirically, just looking at it, I don't really see it happening. I see most of the time when the government loses an issue, they change their decision, they issue a no approval, and that's the last we hear of it. And so I'm not terribly concerned about retaliation for people that sue the government. If you think about it, I know cultural differences exist.
Yeah.
Our American culture is far more confrontational, and we are far more disrespectful of authority, and our law kind of reflects that. The Administrative Procedure Act basically just invites the public to sue the government if they don't like what's happening. And so lawsuits for government employees, it's not a personal issue for them. It's just the cost of doing business. It's the way the system was set up. And it's something they kind of expect.
Okay. And, now that you have mentioned cost, so I would like to talk to you about cost as well, because many viewers, I'm constantly getting these messages from people on LinkedIn, YouTube, and also on my WhatsApp as well. So people are really wanting to hear some suggestions and answers from you. But before we move into viewers, I would like to actually, take all of my questions. So, yes, I was talking about cost because you mentioned that. So, many viewers here might be wondering the financial implications of taking legal action against the government, right? So if you can please break it down for us.
So the downside is that when you sue the government on these cases, you can't sue for damages. You can't sue for money to recoup the loss that you suffered because of their stupidity. So that's unfortunate, because a lot of people have to wait months and months and months without a visa, without work, before they get restitution. But they never get full restitution. They just get their visa back. And they pocket for living expenses for months. The only way you can get money back out of the government is if they fight the case tooth and nail all the way to the end and lose. And then the judge has to find that they were unreasonable in their defense of the case. If that happens, then you can get your attorney fees back. Probably, depending on how much is spent and how much the court awards, you may or may not cover all of your costs. So that's the expense. On the plaintiff side, it really depends on the type of case. If it's a case that we've seen and done before, that helps. Gives a little bit of a head start, and it makes things a little more cheap. But on a case that comes up that's an oddball issue that we've never worked on before, those are going to be a little bit more expensive.
Okay.
Yeah, there's also a difference between group cases and individual cases. Those oddball issues tend to be individual cases. And then the group cases are things where we're taking on a practice, procedure, or policy of the government that's impacting a whole bunch of people. In a group case, we can put them together and get economies of scale and then bring the costs down. For the individual cases, there's really no economy of scale, because we're probably going to work that issue and never see it again. And so that's why those ones are more expensive.
Okay. All right. Got it. So, you also said that the government chances of winning is 60 to 70%. And, but then people, if you connect with John directly, so maybe the chances of government winning goes down, and your chances of winning, gets high. So if you directly want to reach out to John, so what you can do is you can give him a call at his number, which is +1 703 2168 8148. His email is john@wasden.law, and his website is wasden.law. And yes, you can reach out to him through these details. And John, also, I don't know if you got a chance or not, but there were a couple of articles also written about this. So I saw Times of India writing an article about this, and also Economic Times. So if I would like to ask my team to, if you can please show those two articles here on the screen, so that people can also have a look at those articles. Yes, here they are. One is from Economic Times, and there were so many actually, but I chose these two articles, Economic Times and Times of India actually. So they covered this whole case, and they talked about it. So John, Lubna Kalbi was the journalist who wrote, I think, on Economic Times. So I'm sure you must be really busy, and I don't know if you got time to go through these articles or not. But do you have any message for them?
Yeah, so I've dealt with Lubna on several cases where we've talked about our court wins and court developments, and I read her stuff all the time. She does really great reporting.
Great. Thank you so much. And also, John, but there are many viewers who also must be wondering that how exactly is this case going to benefit the H-1B community and our viewers? So can you give some insight into the broader implications of your this recent victory?
Yeah. So assuming it catches on nationwide, we will probably have to fight the same issue in multiple different courts across the country in order for it to be a fixed and binding situation. But what it means is that they can't go after your cap number. These teams that are around looking for reasons to revoke a cap number a few months before your visa's current, that's not going to happen, because they have to give you notice and an opportunity to respond if we're ultimately successful in this issue across the country. And you won't get blindsided by that. And that'll be a big benefit. It'll be a lot of extra security for everybody that's in the situation. And so, yeah, the frustrating thing is for those folks that get blindsided with a cap number revocation, even if they were to have found out about it ahead of time, the government wouldn't allow them to respond. They won't accept anything from the beneficiary. And then, a lot of these things are 12, 13, 14 years old. And, good luck getting information or evidence who keeps things that long to show that, the government's wrong. So it's a very stressful situation for folks. I think the fact that the government has to give them notice, or will start to have to give them notice, means the government will be doing less of this because of the workload.
Okay. But does this also have any relevance to the companies? In the interim, there was another problem, John, where companies have put start dates beyond October 1st. So for the viewers, let me tell you, when the H-1B is picked, they have to file. When the H-1B is picked and they have to file, it starts from October 1st. Even we have done, one starting January 1st of the next year, and they have denied the application actually. And later they came up with a new rule stating that no, it was incorrect, and whatever. So for those who may be facing similar challenges or need legal assistance, how can they reach out to you, and how can you help these people? And also, what kind of support can you offer to individuals in similar situations? And okay, maybe I can take this second part of my question after you answer this first part.
Sure. So anybody that's in the situation where they're facing an adverse consequence because of government action or procedure can challenge it in court. So then the screw ups in the mailroom that you're referencing, the the denying cases because of the date incorrectly. And also another thing that we see kind of commonly is USCIS revoking things, saying that they sent out a notice of intent to revoke that was never responded to, but the employer never got it, the attorney never got it, nobody ever received any type of notice. Mm-hmm. And so a lot of times also the flip of that is they get the notice, they send in the response, and the government loses it and says, you never responded. Those cases are very easy to win. We file suit on that, and they usually resolve very quickly, especially when the employer or the attorney has, shipping confirmation that it was sent. And so that's a common scenario, unfortunately.
Okay, but then what are the services for the companies? And then,
So for companies, we do site visit defense. We train their employees on how to deal with FDNS. It's no shock to anybody on H-1B that FDNS has become more and more aggressive, and one might say rude as time goes by, and their numbers have been increasing. So, in 2018, they had 800 employees at FDNS, and now I think they're getting close to 3,000. And so, we train the employees to handle site visits that are almost certainly going to happen. But the employers, when they have an issue that affects them all, they will go to court, usually under the IT-Serve organization, because IT-Serve can sue the government on regulations and clear, explicit policies that are out there on the behalf of their companies. And that's usually the most efficient or streamlined way to do it.
Okay. All right. Thank you so much for that, John. Now, before we, move into our second case, which is about Sridhar Aluwala, I would like to take a few comments from the people because I'm getting a lot of comments, actually. People are really looking for your guidance here. So let's just take Oluyinka. I hope I'm taking the name right. And he has posted on LinkedIn. And Oluyinka says, what guidance can you offer to Nigerians in the field of software engineering who aspire to relocate to the United States, particularly those who have faced multiple visa denials at the embassy? What do you have to say?
You got to find a petitioning employer that wants to hire you and have them put in for the lottery for the H-1B. I mean, that's really your only option. Once you get an H-1B, you should be fine, because one of the big problems that they have from people coming from Africa on other visa categories is the intent. You have to have a non-immigrant intent when you get that visa, meaning it's a temporary situation and you're going to come back to your home country. Far too many people can't show that they have a non-immigrant intent and that they don't actually want to permanently immigrate. The H-1B doesn't have that requirement. It's a dual status visa, and so a dual purpose visa. So the H-1B would be your really only option, I think, or your best option for getting into the U.S. IT market.
Okay, so Oluyinka, I hope you've got the answer for your question. If you have any more questions, please let us know. Please post them. And thank you so much for joining this live session. So John, now let's take another viewer question. This is from a viewer called Empire, and Empire wants to know, let me get the rules straight. So they can revoke the employer's petition for fraud, but can't revoke the cap number that was gained from the fraud once the employee is not involved.
So yeah, that's our argument, is they can't revoke the employee's cap number unless the employee is the one that committed fraud. And the government has to establish through evidence that it was the employee that actually committed the fraud.
Okay, and he also has a follow-up. So he is asking, I think, 2 or 3 questions. Let's take all of them. So second, he wants to know, unfair to lose your cap number because of someone else's bad action. It's also unfair that those employees benefited from this at the expense of an employee and employer that has done it correctly. I think there is a second part to it. And he says the government needs a better system because someone else lost the opportunity because of that employer's fraud. What do you have to
Yeah,
say?
they did come back and they changed the way they did this year's lottery. And so what's funny is the way they restructured the lottery for this year is almost identical to the way that it was suggested in the comment process back in the 2019 rule. And so the government could have avoided this whole thing if they hadn't been in such a rush to push out a new regulation changing the lottery. But because they were in a rush, they didn't really want to do any work at the last minute to change their rule and their regulation. So the new regulation that came out went through the rulemaking process, it didn't really prohibit multiple filings, but it took away any incentive for multiple filings.
Mm-hmm.
So now if you have 20 different companies registering for you, mm-hmm. you're still only going to be in the lottery that one time. And so that has really kind of made things more fair, and it hasn't it's killed the situation that was in the news so much the last few years of the lottery.
Okay, all right. So, John, I'm constantly looking on my WhatsApp as well because, I'm getting a lot of messages from our viewers on WhatsApp too. But before I move into the WhatsApp viewers, I would like to take this next viewer question, SPK24. And he says, how will that work? They may start giving the employees notice, which they can't respond. What do you have to say?
So, it would just depend on the notice and what they're alleging. If mm-hmm. they're alleging that the employee did something wrong, that's something that's easily addressed. If they're alleging that the employer did something wrong, well, that's on the employer. They can lose their right to hire and employ you, but you still keep your cap number. And that's what we're shooting for.
Okay. All right. So SPK24, I hope you have got the answer. Thank you so much for your question. And also, please let us know where you're watching this live session from. And thank you again. And don't forget to subscribe to the channel. And let's take next question. And this is from Anushka. And she says, what proactive measures can individuals and employers take to minimize the likelihood of encountering legal hurdles in the H-1B visa application process?
So the first thing I would say is be very, very careful anytime you're dealing with FDNS. Mm-hmm. And honestly, I would say you shouldn't talk to FDNS unless you're doing it through your attorney or your attorney's present. We've heard all kinds of horror stories about FDNS people coming in, yelling and screaming and threatening, making threats they really can't make good on, but telling people you have to, give me a statement saying you did this or you're going to get your visa revoked. And so people get scared. People sign away their life basically in that situation, and they get taken advantage of. But the FDNS officer gets to write a great report and look like he's a hero. So if your attorney's there, that whole scenario is avoided. If your attorney's on the phone or they're present, the FDNS officer can't be an aggressive ape, basically. And so they have to control themselves, and that helps you. The other thing is, don't respond to their emails. Have your attorney respond to the emails. Anything that you say to the government could conceivably be used against you in a fraud finding. Anything your attorney says on your behalf mm-hmm. attributed to you. And so you want to definitely avoid any type of fraud finding against you, and you want to avoid any communication that would lead to a revocation of your visa.
Okay. All right. So Anushka, I hope you've got the answer for your question as well. Yeah. So, Anushka, thank you so much for your question. I hope you have got the answer for your question as well. So, thank you so much, all the viewers, for your lovely question. I know I still have a lot more questions that I need to take. But before I move into that, John, let's quickly shift our focus to the case of Sridhar Alavala, and which is truly a tale of injustice and confusion, right? Because firstly, John, okay, before I talk about anything else, I would like to know what exactly is Sridhar is being accused of, and from what we understand, he seems to be caught up in a mess that he had no part in creating.
Yeah, and the government's even admitted that. The
Okay.
government in court has admitted he didn't do anything wrong. And so it begs the question, why are we still here? Why are we
Yeah.
still fighting?
Right.
I think that's another case where I'm optimistic of our chances for success. We've briefed some judgment. Now we're just waiting on a court to make a decision.
Mm.
What happened in that case is they revoked his initial H-1B without giving him notice. And 12, 13 years down the road, they try and kick him out of the country because he doesn't have a visa. Thankfully, his spouse is an H-1, so he's able to switch to H-4. But that's kind of their game plan, is they want to eliminate as many H-1Bs as they can. In his particular case, what they were alleging was that the work location on the LCA, that initial LCA, didn't match with where he actually worked. So you can have multiple LCA or multiple locations on one LCA and work at any of those locations, and then the employee has to be paid based on that location. What they didn't provide us in the evidence was that initial LCA that could have corroborated that he was actually working in the right location. So all the way back when he was on OPT, he had a project. He is working for, it was a major bank in the US, and then he gets selected for the lottery and then keeps that project with his new employer. So it's entirely likely, and I would say more likely than not, that when they filed the petition, they listed both the company headquarters and the client location on the LCA. And the government never provided the evidence that they didn't. And so that, I think, is going to be an area where they're going to have some problems.
Okay. All right. I mean, if the government, they themselves accepted it, so, we can only be hopeful that you're also going to win this one. But John, also, I would like to know that, it's puzzling to hear that they are digging up records from as far back as 2010, when Sridhar wasn't even involved in any wrongdoing. And can you please explain why they are going so far back, especially when there are no legal requirements to keep records beyond 7 years?
Yeah, it's something that started under the Trump administration. So, the Trump administration really kind of kicked off the explosion of FDNS. And they needed work for these guys to do. What they actually did is they went back and they rehired a whole bunch of old employees that had retired as contractors to go through all of these cases and look for any reason they could to eliminate people's cap numbers. The weird thing about administrative agencies is the president comes in, he gives a little bit of direction, but what the president does, the policies he creates, tend to outlive their presidency. And so Trump came in, he really weaponized USCIS. He tried to make it more into an immigration Gestapo. And that mentality within the agency has not shifted back, even though there's a new president. And I don't imagine it will shift back anytime soon.
Okay. All right. But, thank you for answering the question, John. But also, it's mind-boggling to think that Sridhar's entire life and career are being upended over something that happened over a decade ago, right? And
Yeah.
with this visa now at risk of revocation, what does the future hold for him? If you can please also talk about that.
So luckily, his spouse has an I-140 and will be able to apply for a green card relatively soon. So he can stay on H-4. But
Yeah.
I've had other clients that have had to leave the country because they don't have any status to go into. So it's really unfair that you've got somebody working in a government office who has no understanding of what you're doing for your job. You know, basically taking pot shots at you and your history on things they don't really fully understand, and they have a lot of ability to mess your life up very quickly.
Yeah. But is he protected in this situation? And how is your team ensuring that his rights are upheld?
So I think we'll be successful in getting his initial H-1 reinstated, or the government will be enjoined or stopped from saying that he doesn't have an H-1, an initial H-1. So I think we'll win on that issue because the record just doesn't support their decision. And if he has his cap, no problem. As long as he has that cap number, he's fine.
Okay. All right. Well, I'm glad to hear that. But here's a burning question on many people's mind, John. So, while this legal battle is being fought, can Sridhar continue to work? And how are you planning to assist him in obtaining a work permit during this uncertain period?
So ordinarily for plaintiffs, if they don't have another status that they can change into that allows work authorization, once they lose their status, they can't work, which is obviously a huge strain on them because they've got to pay out of pocket while the case is being resolved. So if you can move into, say, like an H-4 that has an EAD available, there will be a temporary disruption in your life while you're waiting for the agency to process the H-4 and EAD, but you'll still be able to stay in the U.S. legally and work legally while the case is being resolved in court.
Okay, understood. But John, also given Sridhar's cooperation with the government and his innocence in this matter, could he potentially fall under another visa category that provides him with some form of protection? Like, for example, does he qualify for the U visa considering his cooperation with the authorities?
Yeah, so there's the U and the T visa that conceivably he could qualify for.
Wow. Okay.
Yeah, the T visa is an interesting one. It's for victims of labor trafficking. And what the government's alleging basically in his case would potentially qualify as labor trafficking. So it's possible, but my guess is, just knowing the agency, those types of petitions for H-1B workers will face a lot more scrutiny than any other type of petition.
Okay. All right. And John, also, I saw your LinkedIn post about Sridhar's case, and there, when you mentioned the whole thing, at the end of your post, you wrote, it is going to be a long wait. And, you extended on the word, you actually emphasized on the word long. So I would like to know from you, can you elaborate on what factors contribute to this prolonged wait, and how do you and your team plan to navigate through this extended period of uncertainty for Sridhar?
Yeah, so right now we're at the stage where all we can do is wait. So all of the work on the case has been done, and we're just waiting for the judge to either hold a hearing and ask us questions or make a decision. And one of the nice things about being a federal court judge is you have lifetime tenure and can't be fired. So they can move at their own pace. And so, there's really no prediction on when the court will actually make this decision.
Well, hopefully soon. let's hope for the best. And I mean, given that the court has already said that he's innocent and he has nothing to do with it, so maybe let's hope for a victory of yours soon on this
Yeah.
case as well. Okay, so lastly, John, about this specific case, can you share any insights into the broader implications of this case for other individuals, facing similar challenges with their visa, and how can individuals in need of legal assistance reach out to you for help in navigating through, such turbulent times?
Yeah. So the first thing I'd recommend that everybody do is keep everything. Keep all of your records. Be very meticulous, because if you need them in a crunch, unexpectedly you get a notice of intent to revoke, you'll have the information that will be helpful in responding to that. So just document. Right. Should have everything you scan it all and have it on someplace on the cloud that you can access it for the rest of your life. In terms of working with us, my website has a scheduling app. If you want to schedule a time to talk, you can do that.
Okay, and everyone, his website is wasden.law. So if you want to schedule, you can do that by clicking on his website, which is wasden.law. And if you want to give him a call or send him a text or even WhatsApp message, his number is +1 703 216 8148. And you can also write to him on his email, which is john@wasden.law. All right. So, John, also, there are a few questions I would like to take before I let you go. I know you must be really, really busy, but I just would like to take, one or two questions before I end this session. So, Ashwin Daljit is here and he has a question. Can you discuss any recent precedents or trends in H-1B visa litigation that applicants should be aware of?
So the main thing that we're pushing right now is notice to the impacted person. It's coming up in a couple of different ways. One is the multiple registration cases. One is the revocation of the initial cap number years ago. And then the other is the OPT scam companies, the scammed employees or students into paying them for training and then never doing anything to get them a job. So all of those cases share a common element, which is the government never gave them notice before punishing them, basically. And what we're fighting for is to give everybody a fair shake and a fair shot at resolving or answering the agency's questions before they get punished. And I think we're on our way there. The case in Seattle, I think, is huge because it says that the employees can sue, and if they can sue, really they're entitled to notice and an opportunity to respond at the administrative stage.
Okay, all right. Thank you so much for answering the question, John. And Ashwin, I hope you have got the answer. And one more question I would like to take is of Rajesh. I actually had taken screenshots from Reddit and Quora so that I can ask you questions from, people commented actually a lot about these H-1B frauds. So I just wanted to take that, but because I know, you're really busy. So maybe in another episode, maybe. But for now, this question, how Rajesh is saying, how can you effectively challenge the government's exercise of discretion in denying an H-1B petition, particularly when the denial is based on a subjective determination that, can we have the second part, that the petitioner does not meet the specialty occupation requirement? And what legal arguments and evidence can you marshal to demonstrate that the government's decision was arbitrary and capricious?
Yeah, so when we're dealing with specialty occupation cases, that was an issue we fought years and years ago, and it's been successfully resolved. It used to be you would file your petition, and these USCIS employees who had no understanding of IT, software engineering, or any of that would make a decision as to whether or not your job qualified as a specialty occupation. Now, keep in mind, most of these people couldn't figure out how to map themselves to a printer. And that's how computer illiterate they were. but they were making these decisions that, you don't qualify. So they were really twisting some language in the Department of Labor's resources that kind of define occupations within the United States. The arguments in court went pretty well for us, which were, the Department of Labor said this occupation requires a degree in this specialty and this knowledge.
Mm-hmm.
The job that they offered requires that same degree and that same knowledge. Therefore, it meets the criteria for specialty occupation. The court really almost mocked USCIS's analysis and rationale for their denial on those cases. And now it's become much more simple and much more streamlined on the specialty occupation analysis. I think USCIS is trying to muddy those waters again with a new regulation, the modernization of the H-1B. I think they're trying to bring back a lot of those murky standards. So we'll probably be fighting the same fight all over again.
Okay. All right. So thank you so much, Rajesh, for your question. Don't forget to subscribe to us. But one last question, John. One last question. I don't want to, miss out on this opportunity because I know you're really busy. So one last question I would like to take from the viewer. So Nancy wanted to know something, and she said, in what ways can skilled immigration contribute to addressing labor shortages in specific industries or regions? What role do social networks and support systems play in successful integration?
So, I think the answer to a lot of the country's problems is increasing high-skilled immigration. I personally want to live in a country that has the smartest people in the world, and we're starting to slip on our lead for that. And we need to bring in people. The frustrating thing is Congress is not going to do anything to fix a well understood problem. The immigration is broken for high skilled people. It's just not working right. And USCIS, for its part, has zero desire to change anything that they're doing. And so, you can advocate for change, that's great. But until Congress actually gets their stuff together and comes forward and does comprehensive immigration reform, it's just going to be ugly.
Okay, well, thank you so much, Nancy, for your question, and thank you so much, John, for answering. And there are a lot more questions, but I know you're really busy again. I would like to say this again and again because, this show was supposed to be for an hour, but then we extended. So thank you so much. Yeah, thank you so much for that. And unfortunately, viewers, that's all the time we have for the questions today. But don't worry, we will try to bring John back for another episode, and where we can discuss more about, these cases, because you also have, like I said in the beginning, you had a recent win where you posted a couple of hours back about that. Right. So maybe we can discuss about that too. Thank you so much for your time, John, and everyone. If you, if your question if we didn't take your question, and if you directly want to reach out to John, what you can do is you can connect with him on his number, which is 703-216-8148. His email is john@wasden.law, and his website is wasden.law. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my email, which is rajni@higheritpeople.com. My number is +1 732 707 9151. And you can also visit our website, higheritpeople.com. Remember, we also sponsor H-1B visas and green cards. And that's a wrap for today's show, folks. So we have covered a lot of ground exploring the triumphs and challenges within the legal world with John by our side, from victorious H-1B visa case to the ongoing saga of Sridhar's fight for justice. And it's been an eye-opening journey. So before we sign off, I want to extend a heartfelt thank you to you, John, for sharing your insight and your expertise with us. Your dedication to upholding the justice is truly, truly inspiring.
Well, thank you. It's good to be with you again.
Thank you so much for saying that. And to our lovely viewers out there, thank you so much for tuning in. And remember, if you find yourself facing legal hurdles or seeking guidance, don't hesitate to reach out for help. You already have John's number and his contact details. So we'll be back with another episode and another live session at 12. So just don't forget to stay tuned and don't forget to subscribe to Immigration and Jobs Talk Show. But for now, I'll have to take your leave. I'm Rajni Bharara signing out for now. Let's meet soon.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone, and welcome back once again to Immigration and Jobs Talk Show. I'm feeling great to be here today on a Friday and looking ahead for a very, very long weekend. But before we get to all that excitement, I would like to tell you that I'm Nipasa Pradhan and I'm going to be your host for today for an hour or so from now. And I'm thrilled to have you join us, whether you're watching us on YouTube, LinkedIn, Facebook. Thank you so much for joining. And let me tell you that this is going to be a very participative session as well. So feel free to put your questions in the comments. And
oh no.
you agree and understand that the information, including comments and replies from users, is not legal advice. Use of information is at your own risk. So thank you once again, friends. Thank you for joining us. And yes, this is Immigration and Jobs Talk Show. And I think without further ado, like I was telling you, we're going to have a very intriguing session today as well. So our topic for today is curious about H-1B visas. So if you have any questions about H-1Bs, you are on the right path, on the right track, because we are going to have our guest join us today, none other than attorney Justin Rivera. Please help me welcome him back here. How are you doing, Justin? Thank you so much for joining us.
I'm doing all right. The weather's a little bad here, so I'm just giving you a heads up. So if there's any connectivity issues or anything like that, it's because of there's a thunderstorm rolling through right now. But hopefully that doesn't create any problems. But other than that, I'm having a great Friday.
Me too, and I'm excited for the long weekend.
Mm-hmm. Absolutely.
All right. Yes, yes. And so, Justin, dear friends, he is an employment-based immigration attorney. And, he has been working with Wasden Immigration and Litigation. So how has it been so far, Justin, with Wasden?
It's been great. I think finally settling into the role, which is nice, and really enjoying it. working on different cases from what I used to work on at my former employer. So it's nice to see a bit of variation, and everything's different. At least I feel like I get a lot of different kinds of cases to work on, and I'm enjoying that. And I'm enjoying the challenge.
Great, great. So good to have you here today as well. And I'm looking forward for this whole intriguing session full of exciting discussions and I'm sure questions also. So let me tell you that this is an Ask Me Anything session. So friends out there, you can ask Attorney Justin Rivera anything that you have, especially with regard to the topic, and that is H-1B visas. So before we dive into the discussion, it's important to also acknowledge the latest updates in the immigration world. So, Justin, maybe if you have anything to give out before we start off with the questions.
Yeah, I mean, not a whole lot, and for me at least, I would just, just kind of speaking on what I've been working on recently. I've definitely seen quite a few issues coming up with people's STEM OPT applications, with issues with violations of their OPT status at their former employers. So, obviously you need to be cognizant of those 90 days of unemployment for your OPT status and how failing to adhere to that can render you ineligible for the STEM OPT extension. I've been seeing a couple of those cases come in. And a couple other things I've been working on, just generally speaking, and really this actually kind of ties into the H-1B stuff today. So I very recently saw someone, and I think that this is important to discuss because they were actually all the way at the end of their immigration journey, where they're scheduling the I-485, where they're attending their I-485 interview, and during that interview, they actually ended up telling admitting, because it's what happened, the officer, that they had actually been working from home. And the issue with that was that home address was not covered on the labor condition application. It was not in the LCA, and it unfortunately was not in the same what's called metropolitan statistical area, meaning that it was not technically permissible employment. So this person, they didn't realize it. I mean, this person was completely guiltless. They never got a copy of their LCA from their employer. And they never realized that their end client, when authorizing them to work from home, had not talked to the employer about it. So this person had been working for years, 4 years, a full H-1B and an extension, not realizing that they were completely violating the LCA. And so they go for their I-485 interview, and they ended up getting a notice of intent to deny on their I-485 based on the idea that they had violated their H-1B status for a period of more than 180 days. And it's crazy to think about. Imagine you wait all that time in that backlog to get to this point. And, the process can be messed up as a result of a mistake that you didn't even realize was a mistake. And so that was just something that really makes me think that we need to do a better job of ensuring that the non-immigrants here in the U.S. that are going to be on H-1B status, that they are aware of these pitfalls, of these issues that could occur. So, I mean, always you're entitled to a copy of your labor condition application as a right. Failure to do so is failure to comply with DOL. By the employer. So always make sure that you have a copy of your LCA if you're an H-1B employee, and make sure that you are working in the area that you say you are, because it can come back to bite you. I mean, this person had no idea this was going to be a problem for them. They were just saying what they've been doing for the last few years, and now they're staring down the barrel of a notice of intent to deny that adjustment of status.
It's crazy. And you deal with all these sorts of complicated cases very regularly, Justin. So I wonder, what do you do, to keep yourself sane, mentally? I mean, apart from your own life and everything, you also have these things to solve. So what do you do?
Just long walks with my dog.
That's lovely.
It's a way to think.
Discuss your cases with him.
Yes, we frequently discuss the cases, my dog and I.
That's sweet. That's sweet. Well, friends, this is an Ask Me Anything session, and the topic today is curious about H-1B visas. So I think, Justin, I am ready. Are you ready to take up questions?
Sure. Yeah, absolutely. I know we're on a tight schedule, so.
All right. So we have Priya with the first question on YouTube.
Mhm.
Hi. While booking for H-1B visa stamping, I answered no for a question whether I held any previous visa other than B1 or B2, which should have been yes. For this, I was not given Dropbox option, but the portal took me to interview option and I was able to book one. I know that it's not possible to change it in the application now. Is there any way I can write to the consulate of this mistake, or will it be a problem while going for an interview for this wrong answer?
So I think if you want to be super careful, what you can do is fill out another DS-160,
Mhm.
and just fill out and bring another DS-160 and explain that you're correcting a mistake in a prior submission. I think that's being as careful as possible. Consulates can vary based on what they want someone to do, so you can also try contacting the consulate first. But I definitely think that I think that the safest thing to do would be just go ahead and do another DS-160, correct the error, bring it with you to the interview, and admit it up front that you made a mistake on a selection of something, and then say, "Here,
Mhm.
it was my fault. Here's this." And then that's all, because I really don't think it's that big of a deal, especially if you're admitting up front that there was a mistake that you made in the DS-160. I don't think it's necessary. I mean, don't cancel the appointment and make a new one just based on that, because then you're paying the fees again and everything. um,
True.
so I definitely think that that would be the easiest course of action. Just or take a new DS-160 to the interview, because I don't think they'll let you
Mhm.
submit it.
Okay, but it's always important to update, I mean, it's good that you are admitting the mistake and updating it as immediately, I think is always good. That way you're safe no matter what.
Yeah, and
I
I mean,
mean,
it's a
instead of
B1
just,
B2 visa doesn't carry work authorization with it or anything, so I
okay,
wouldn't think it's that big of a deal. But at the same
okay.
time, you do want to be upfront. Consulates are different, but for the most part, the consulates I've dealt with, the officers aren't there to get you, to put you in a situation where they're going to give you a 221G or deny you.
Okay.
They're more so just looking to figure out whether or not you qualify and that you've answered truthfully. So I think it goes a long way to just admitting the mistake up front and then providing a new document to replace the old one.
Cool. So, Priya, thank you for your question. I hope you got your answer. And thank you so much, Justin, for
Mm.
taking that out. Uh, we have short. What does the student studying on USA on F1 visa require to convert the visa from F1 to H-1B visas? Is that the
Um,
question?
So I think that if I could kind of generally spin this in, like, what is it that you should look for if you're an F1 going to H-1B? I think
Mhm.
for the most part, that's going to be people who've been selected in the lottery. So if you're selected in the lottery and your petitioner's filing an H-1B for you, they file it one of two ways. They can either do change of status or consular notification. So change of status is going to mean that you convert to that H-1B status on 10-1 typically, because that's going to be the first date of eligibility for the status. When you file a change of status, that means that, sorry, emails. When you file a change of status, that means that your time spent in your current non-immigrant status is going to be reviewed. And so what that means is if USCIS determines that there has been a violation of that status, then your change of status can be denied. Now, the change of status being denied means you can no longer change status to H-1B. You now have to depart the United States, go abroad, attend a visa interview, and come back in with an H-1B stamp. So it does mean that you need to look out for certain things. If you're on F1 and you're on OPT, you need to look at your
Mhm.
unemployment dates to make sure that it hasn't exceeded the threshold, which I believe is 90. And then when you go into STEM OPT, it's a larger number. Don't quote me exactly. I believe it's 120. But you need to look out for those dates, because if you have violated that, then you may want to consider filing consular notification rather than risking your change of status being denied and carrying with it any penalty as a result. That's usually the big hurdle that I've seen for F1 change of status. The other thing that I have definitely seen is the day one CPT issue. And just kind of generally touching on that, that's where someone will maybe have exhausted their OPT and they enroll for a second major, maybe at another university. There's a lot of universities that I won't specifically name, but I feel they're definitely on a list of day one CPT schools. They're kind of, if I remember right, in Kentucky or around that area. But there are schools that kind of seem like they're day one CPT hubs. So when that comes up, if you're a day one CPT person who's at the same degree level, you might see an RFE where USCIS alleges that you violated status because you shouldn't be doing CPT after OPT at that same degree level. So those are two issues I think that you would need to look at when you're filing your change of status. Hopefully you're working with an immigration attorney that's well-versed and is able to pick up on those issues at that time so that they can maybe advise you against filing a change of status. I know that people sometimes want to hedge and file a change of status and see if they get an RFE and then maybe try to convert to consular notification then. I've seen that work. I've seen it not work. It's really just dependent on what your risk threshold is. I would always say, the safest course of action is the one that carries with it the highest probability of a positive outcome. So I would probably lean towards just doing whatever's the safest. But each person's different and you're going to look at those factors. I think that was a very long-winded answer, but I did my best to kind of make an answer out of that.
You did cover, and I'm sure, short, that was very helpful. Please comment if you have more questions. And even if that was something you resonated, please comment. It'll be good to know. Moving on, let's go on to the next question we have. This is Akash. I have a query regarding attending H-1B visa interview for the 2024-25 round. Currently, I live and work in Germany. So can I attend the interview from here and the stamping done? Or shall I have to visit my home country? Also for dependent stamping, which would be the preferred one? And what are the pros and cons for getting done together or separately?
Okay, so I think as a general rule of thumb, the easiest place to go for your visa interview is your home country. Almost always. It's going to be the easiest, the most simplistic course of action is going to be going through your home country. Now, is it possible to go through another country? Yeah, it typically is, and they're likely going to let you schedule an appointment. Third-party nationals, so someone who's not a citizen of that country, they may be kind of put at the back of the queue for scheduling purposes. So you may see an issue when you try to schedule an appointment that it's going to take you much longer than it would in your home country. But you can do it. Now, what is the pitfall of it? The only risk or the scary idea is if your visa gets denied, right? And if you're stuck in that country and it's not your home country. I assume this individual who's living and working in Germany, they're authorized to be there. They have a German work visa or something. I don't know German immigration, so I won't speak to it. But their pitfall would probably not be as big a deal. I think the people who I always recommend going to your home country for are people who are maybe like, I'm visiting country X and I'm going to go for my visa appointment. And it's like, all right, well, if you get denied, what are you going to do? Are you going to end up stuck in that country? So I would say, yeah, you can schedule. I always recommend doing everyone's appointments together. I don't recommend separating people's appointments. Just get it all done at the same time. I don't know if it's a psychological thing or what, but I just feel like when you bring your dependents with you to the appointment, you kind of show, I don't know, maybe the officer's going to be a little more like, oh, okay, inclined to approve that person. So yeah, I mean, I would do them together when you can. I just really don't see a reason not to. If you have to do them separately, it's possible. Obviously, you've got to get your H done first before your dependents. So I would think you'd have to take that into account during scheduling. But yeah, if you can all go together, just all go together. It's much easier to do it. Now, that being said, there are some countries that actually allow people to not bring children that are a certain age, under a certain age. The children are not actually required to attend the appointment. So I would look at the instructions on your visa appointment to see if your kids might qualify for not having to actually physically appear, and you can just bring their passports with you.
So cool. So
Mhm.
Akash, I hope you figure out, and thank you so much, Justin, for taking that up for Akash.
Mhm.
Let's move on now to this next question we have from Shruti on YouTube. She's asking for a friend. H1 was filed by current employer. A job is not directly related to the major of study. Would there be any issue during H1 transfers?
Yeah, I mean it all depends on the officer
So,
reviewing the case. But if you have a position that has not had what I like to call a nexus tied between the employment and the degree of the individual. There's no connective tissue
okay.
there. Um, when that's not apparent, then you can get what's called a beneficiary qualifications RFE. So that's going to be a
Okay.
request for evidence from the service where they're basically asking, how does this person qualify for the position based on their degree? Um,
Mm-hmm.
Hopefully you've sussed this out at the outset as a possible issue. The first thing I would recommend, if possible, is look at the actual specific courses taken by the individual and maybe try to explain how those courses give the person the qualifications for the position. Perhaps the position is a hybrid, something that
Mm-hmm.
crosses different fields, IT and accounting,
Maybe.
business and science, something like that. So that's one way you can tackle it. Another way is what's called a combo eval. So that's where you're looking at
Mm-hmm.
combining education and employment experience into an
Okay.
evaluation that shows that the person has, based on the combination of their academic experience and their real life work experience, they have the equivalency of a degree that's in a relevant field.
Mm-hmm.
Usually for that, you're probably looking at, it really depends on the case, not to be too specific, but you'd like to have 3 years of work experience, I think, traditionally. Sometimes you may even need as much as 6 based on what the degree is. Again, that employment's going to need to make sense too. It's going to need to be rationally related to what the person's doing. When you
Yes.
request the evaluation, you should have experience letters from an authorized
Mm-hmm.
representative of the company who's willing to speak to not only the position and the duration that you held the position, but also, if possible, explain maybe the job duties or projects that you worked on. Because really, what you don't want to do is allow the officer who's reviewing the case to look at that
Mm-hmm.
evidence that's supplied and be able to poke holes in it and say, well, this is, you said you worked 3 years at Google. You have a letter with a sentence that says this guy worked at Google. What was his position? How long was he there? What were his job duties? Who was his supervisor? There's all
Yeah.
these things that they could look at. And you have to understand, with the H-1B, once there were the third party placement memos, once those got revoked, which, just for a quick understanding of that, is, there were memos that came out during the Trump administration saying, if you work at a third party, you got to show proof of contracts, employer, all this stuff, right? When those got revoked, it
Mm-hmm.
really kind of made it to where USCIS can only look at, for an H-1B, the H-1B position. Does it qualify as a specialty occupation? And the beneficiary's qualifications. Does the employee qualify? So they're going to look at those hard because it's really all they can poke holes in at this point.
Mm-hmm.
So again, I would definitely say, look into getting an eval. Some employers like to wait and see if the case gets approved. That way they don't have to worry about getting an eval unless there's a request for evidence.
Mm-hmm.
That's an option. I like to present the strongest case possible up front to minimize the cost of an RFE. I think most firms probably operate in the same vein, where the filing is probably less than the RFE, because the
Okay.
RFE is going to be more tedious and time consuming. Um, so, yeah, I would say, look into getting that eval. I do definitely think that if you're working with an immigration attorney, that's going to be identified prior to filing. I mean, it's not likely that they're going to be surprised when they get the RFE that
Mm-hmm.
your degree in business management did not qualify you to be a data scientist. you know. So
Mhm.
yeah, that's it really. Those are really your only two courses of action, and then hopefully one of them works. If you don't have that requisite, I'm sorry, my nose is itching. If you don't have that requisite work experience, you're gonna have to try and tie your education. And if you have a master's and a bachelor's degree, you utilize the totality of it. Pull everything out of both of those degrees to create that nexus, and hope for the best with USCIS.
All the best, Shruti. And thank you for your question. Thank you, Justin, for taking that up.
Sure.
Now, this next one is from Mahinder, also on YouTube. I am a Canadian PR and Indian citizen, but my H-1B got picked and approved. Do I need to travel to India to get it stamped from US consulate office, or can I look for an appointment in Canada's US embassy, say Toronto, Vancouver, Ottawa? Also, I have USA visitor visa. Can I travel to USA on a visitor visa next month and do a change of status to H-1B after October 1st?
So I wouldn't recommend the second course of action, just generally speaking. I would, since you're outside the U.S., I would just go ahead and get your H-1B visa stamp taken care of. The same issue I think that comes up with the individual who's in Germany, I think applies here to the Canadian as well. I would see if you can schedule a visa appointment in Canada, and if possible, see if you're able to schedule one. I think you should be able to. And then I would just go to your appointment in Canada. My one thing would be I'm not super familiar with the wait times there, and I
Mhm.
don't know if there's going to be a difference for you as a result between how long it takes to get an appointment in Canada versus in your home
Yeah.
country. So I would just look at that. But I think I would just go ahead and try and schedule a visa appointment in Canada and see if you can get it done. Unfortunately, what's frustrating about scheduling your visa appointments is you can't look at the schedule until after you pay, which has always annoyed me because it's very frustrating to be like, no, you have to put the money down and then we'll open the books and show you how long you got to wait for your appointment. I always feel like you should be able to look beforehand, but I don't think they're going to be making that change anytime soon.
Seeing is believing, they say. And
Right. Well, I mean, because you want to ideally be able to forum shop. Like, if you think about it, if you're somebody who's stuck in Canada, if you're like, oh, in Canada it takes 5 months to do a visa appointment, in India it's in 2 months, then I'll just schedule it in India and pop over there. But it puts you in a situation where you have to pay the fee in Canada to see those appointments, and then you have to pay the fee in India to see those appointments, because you also have to
yes,
factor in that all of these consulates in different countries are operating on different websites. Like,
hmm
you're not really using the same universal system. And just to give you guys a peek behind the curtain, as someone who did a lot of visa appointment scheduling over the past year, I have no problem saying that India has the absolute worst one.
okay.
I'm sorry, you guys have the worst website for visa appointment scheduling. I have never struggled more with getting kicked out, with having things not go through, than I do with that website. It is just atrocious. It is horrible. Anyway,
I really hope
that's
they have some good updates and upgrades. Yes, that's much
Oh, I
needed.
mean, they
But
knock it down for maintenance like every 2 weeks, or at least it used to feel like it when I was scheduling visa appointments. It felt like they kicked it for maintenance every 2 weeks. You couldn't do anything for 4 or 5 hours because they were working on it, and then you'd go in and it
that's
would be just
disappointing.
as, yeah. It's very frustrating. Like, the idea that if you're from India, you have to deal with a lackluster website just by virtue of that being your home country. It just frustrates me. I remember scheduling for people in South America, like Brazil, Argentina, Mexico, 15, 20 minutes to schedule an appointment, if that.
Okay.
Versus
How long do you take
sometimes
for India?
sometimes an hour and a half. Because it's just, you get kicked, your information doesn't save, and it's just so frustrating. I don't get why there's not uniformity to it, and everyone just doesn't have the
Mhm.
exact same type of system. But anyway, that's my rant for today.
Well, we'll take that, but I do hope that there will be good upgrades very soon. And Mahinder, I would like to say that sorry, am I? I would like to say that you can contact Attorney Justin Rivera directly as well if you want to have a one-on-one with him. Why not
Sure.
call him instead? And call you can call him on this number. You can note it down. 844-592-7336. That is his number. You can even email Justin at support@wasden.law, and definitely go visit wasden.law to get to know more about Justin Rivera and, of course, Wasden Immigration and Litigation. Well, Justin, now I think we should move on to another question from our audience. Let's take
Mhm.
up Rahul. I'm seeking clarification on H4 visa travel regulations. A family member's spouse is in India with an H-1B visa, while their wife is also in India with an H-4 visa. They both recently traveled to India for urgent matters, but now the wife wishes to return to the United States alone. Can she travel back to the US on her H-4 visa independently without her husband's accompaniment since he remains in India?
So this is there's a heightened level of risk in that you typically want the primary to travel with the dependent or the primary to already be physically present in the United States. So I definitely think that there's an added risk to that. Is it impossible? It shouldn't be, but I do think that you need to take extra steps from a documentation standpoint. So what does that mean? I would go so far as to carry a copy of the spouse's H-1B approval notice, maybe even a copy of their petition, and maybe even an updated letter from their employer stating that he is coming to work imminently in the United States, but he's not able to be in the United States right now due to X. Urgent family matter, business matter outside the country, something like that. So I would do that just to make absolutely sure that you're okay with coming back, especially if they've come in and out of the U.S. already a couple times, then it's easier. But if it's a first entry on a new H4, then you
Mhm.
really should have the primary with you. And if not, take all those extra steps and hope for the best. If you want to be as conservative as possible, though, I would travel together.
Great. So, Rahul, I think definitely they should travel together. Thank you for your question. And thank you, Justin, for taking that up. I think it's time now to take a short break, Justin, if that's okay with you as well.
That'd be great. Thank you.
All right. So, friends, don't go anywhere. Today, we are discussing if you are curious to get to know more about H-1B visas, drop your questions. It's an Ask Me Anything session, and we'll be right back after this short break. So, don't go anywhere. Stay with us on Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higherightpeople.com or visit our website www.higherightpeople.com.
Hello, everyone. Welcome back once again to Immigration and Jobs Talk Show. And this is the second half of the webinar we are having right now on this topic. If you're curious about H-1B visas, get your questions answered by the attorney, who is none other than our guest for today, Attorney Justin Rivera. Thank you so much for joining us all the way from Wasden Immigration Litigation. And friends, it's lovely to have you here with your questions as well. It's been interactive, and you can keep commenting wherever you're watching. We are streaming live on YouTube, LinkedIn, and Facebook, and it's been great having your questions. So recently, we've seen an increase in RFEs and NOIDs or NOIDs for H-1B applications, especially in the wake of the heightened scrutiny under the current administration as well. So, but then also we also have the new fiscal year that's coming up starting October 1st. So a lot of you may have questions. And before we start off, maybe Justin, do you want to say anything on that too?
I would love to if you wouldn't mind giving me a soapbox. So yeah, a lot of you are going to be changing status on 10-1 to H-1B. That carries with it different requirements and conditions than you're used to probably on your old status, which I know for a lot of you is F1. Maybe it was something else. But I would definitely say for those of you that are going to be moving over to H-1B, make sure, like I said, kind of at the top of the call, that your work is in compliance with your labor condition application. Make sure you're working where you're supposed to be working. Make sure that if you move work sites, that you inform your employer, or your employer, speaks with you. You guys come to an agreement, and you make sure that you guys determine whether or not you need to file an amendment. A lot of factors go into whether or not an amendment should be filed, all the way from the work location to the wage level to the SOC code. So there's a whole bunch of new considerations that you're going to need to deal with as a result of moving to H-1B. But for the most part, it's a smooth transition. You should start off right there on October 1st in H-1B status. It's never too early to start thinking about perm, if that's something that you're thinking about once you max out at that 6 years. So I would definitely take that into consideration too. Once you're starting working. Another thing, just kind of generally speaking, on that kind of has come up over the past couple of years that I see in things like consultations and stuff like that. Sorry, my email's absolutely blowing up right now. I apologize. Something I do see come up, transfers, H-1B, change of employers. Sometimes you join an employer and you start working with them on H-1, and it's a couple weeks in and it's not what you wanted or expected, and you think, can I move employers? You can transfer, but just remember, if you're transferring and you just started an H-1B, you have to show that you maintained status. And typically to do that, you have to be able to provide pay stubs. So I always recommend at least having 2 to 3 pay stubs available when you move employers. So I would definitely say be cognizant of that in the event that you start working with your H-1B employer and you don't like the situation and you want to move. Is it possible to change employers sooner, than the 2 to 3 pay stubs? Maybe, but I wouldn't take the risk if you don't have to. And so that's kind of the things that I think about most often is those quick change of employers, maintaining H-1B status, and then just making sure that you're in compliance with your LCA. Making sure, again, that you're working where you're supposed to be working, performing the duties that you're supposed to be performing, and being paid the correct wage. Obviously, the point of that labor condition application is to ensure that you're being paid with what you're supposed to be being paid based on the type of job you're doing and where you're working. If you're not being paid the wages you're supposed to be paid, you do have the option to report the issue to the Department of Labor, to the DOL, and the Wage and Hour Division can open an investigation as needed. Hopefully that's not the case for anybody, but it is something that can be explored, because obviously we don't want bad actors in the H-1B program. We don't want employers that are not paying people what they're supposed to be paid or trying to circumvent the rules.
So true, so true. So thank you so much, Justin, for the update. And also, like friends, I'm sure you also have questions. So, and if these changes are going to impact your H-1B status or your plans to apply, you might as well ask your questions, because we're going to be here for some more time. And yes, we are discussing about H-1B visas. So I think quickly we will take up this next question now from Shri. Shri is asking, I'm currently in India as my H-1B 6 years maxed out, term awaited. Company will be filing 7th year extension next week. Question is, can we file H-4 EAD with 7th year extension from outside the United States of America?
I don't think you can file an H-4 EAD without an I-140, and it doesn't sound like you have an I-140.
Okay. So do you have an I-140, Shri? Tell us.
It doesn't sound like it if his perm's pending.
Mm-hmm.
So, no.
So does he have any options?
Not for an EAD for his spouse. He has to wait for the I-140, his I-140 to be approved.
Okay.
So I mean, it needs to be
You need to
filed.
get that done.
Mhm.
Thank you, Justin. Now, this next one is from Imran, also on YouTube. I raised FOIA request. USCIS conducted search for I-129 document and didn't find it. They provided me a note saying no records found. My H-1B got approved recently on April 25th, 2024. I requested them to provide I-129 and I-797. I provided my receipt number and they replied they can't find any documents. Does it mean my employer provided me someone else's receipt number?
I have no idea, man. That's,
Crazy,
I
right?
mean, look, what it sounds like is your employer just gave you a receipt number. There should be receipt notices. You should have received a receipt notice, and if your H-1B was approved, you should have received an approval notice. If you don't have those things and they weren't supplied to you by your employer, I don't know, man. They may have not filed an H-1B for you in the first place.
Sounds
Um,
suspicious.
yeah, absolutely. That seems very nefarious. And especially if you're claiming that you submitted a FOIA request and the government wasn't able to turn over that information because they're saying it doesn't exist. I've gotten FOIAs back where they'll redact portions of information saying, they can't provide this for this reason, this reason, this reason. But I don't think I've ever seen somebody come back and say, we just flat out can't find this record. Yeah, man, that's a new one for me for sure. And I definitely think, sorry, I don't mean to laugh, but it's so ludicrous to me that the
I
employer
know.
would have given you a fake receipt number or the receipt number of another person. That seems bizarre. But yeah, I would definitely say if you didn't get a copy of your receipt notice or your approval notice, I would be very worried about whether or not you have work authorization right now, or whether or not you're in the correct status if you're in the country. And if you're out of the country, I would wonder whether or not your employer actually filed for you in the first place. I think I would love to know more facts about this because, if this is someone who registered in the CAP, can they show that you had a registration notice that was selected?
Mhm.
Do they even have the ability to produce that? And to show that they even registered for you in the first place. And then I would go, if they can't even produce that, no, they never filed anything for you. So yeah, that's wild. I
Yeah,
mean,
sad to say. Yeah.
what's crazy about that is, I guess I'm kind of just spitting like hypotheticals. I mean, why would you do this? Maybe you have this person working on F1 status on OPT or STEM OPT, and you want to keep them employed.
Mhm.
And you're claiming you're filing for them, but then you didn't really. But to take that lie and extrapolate it out to the point where you're giving them another person's receipt notice is bizarre. That's a case of first impression for me. I have never heard of an employer doing that before.
Imran, I would say it's a little unfortunate right now, your situation, but I think you should go do a thorough investigation, find out all these things which Justin just mentioned and
It sounds like
see
he
if it's
tried.
really, yes.
I mean, if they're yeah, I just from my experience, if you're coming back saying your employer's not providing you anything and you did a FOIA request and they're claiming that there are no records available, then that's why I would say, have you tried putting the receipt number into the My USCIS case status, maybe, and seeing if that's an option? That would be my thought process. I don't know.
Okay, Imran, maybe we need more information about you. You could tell us more, or better
No,
even just contact
send an
attorney.
email.
Yes,
Yeah,
best
send an
best to
email.
send an
That's
email.
such a nuanced case that I wouldn't even want to discuss that in more detail on the call.
There you go. So please mail him at support@wasden.law. Thank you for your question, by the way. All right, let's move on now to this next one. This is from Ishwar. Ah, okay, from Drive 10. Hi, Justin. Do you think the court ruling allowing H-1B spouses to work could hurt American workers? What's your take on this concern?
I've heard that idea, that posited the idea that allowing allowing H-4 EADs can be harmful to the U.S. job market because, you know, the H-1B visa has more stringent requirements. You know, you have to go through a lottery. You have to have a specific degree type. All this stuff. But H-1B, it's a different burden. And H-4 EAD is, you can do anything with it. An H-4 EAD, you can be self-employed. You know, you can go work for a business. You can open your own company, whatever. I don't think that the H-4 EAD is harmful. I actually think that, first off, you're not just entitled to an H-4 EAD. The H-1B holder has to get an approved I-140 first. So there's already hurdles that exist. I think I've talked about it before here, but I will once again tell the story of someone who I actually had a case for, who was Canadian, and he and his spouse were going to come to the U.S. He had been selected in the lottery and got his H-1B approved. And once he found out his wife was not entitled to work just on the H-4, they actually didn't come. They ended up staying in Canada and working because his spouse made more money than him. So it literally didn't make sense for them to come to the United States. They would have harmed themselves financially by coming to the U.S. So I actually think that it can be a hindrance to not permit that immediate work authorization. You look at it as opposed to the L1, the L2 dependent spouse for the spouse, the visa carries with it automatic work authorization upon entry. You're able to just begin working once you come into the country. It's incident to status. So I think that there are already kind of like hurdles in place to even get the H-4 EAD in the first place. I just don't see how it can be that problematic for the U.S. economy, for American workers. I can understand some of the argument. The whole point is the H-1B is governed by a labor condition application. The LCA exists to make sure that people aren't working on low wages replacing U.S. jobs, right? And then the H-4 EAD doesn't have that on it. But I think that it's important to ensure that there's an avenue to employment for people's spouses, because if there isn't, you're going to have like situations like my case where you have people from other countries who don't come to the U.S. because then they don't have that opportunity for their spouse to work. And I think you want to keep, my opinion of immigration has always been, you want to keep people here that have utilized the institutions here. People that have come in here and gone to school here and gotten education here, I think you want to keep them here, because what's the point of educating them if you're not going to utilize what they've learned, and put them into the job market and put them into the labor force? I really don't think it should be harmful. Do I think it will limit opportunities and raise anti-immigrant sentiment? I don't. Sorry, I'm looking at his follow-up statement. I really just don't think. I really don't think that the H-4 EAD is the end-all, be-all on which people are willing to die on as to whether or not they are anti-immigrant. I think it's something people maybe can point to if that's an issue that they have with legal immigration. But overall, I don't think that somebody is. I don't think. Long story short, the H-4 EAD is a good thing. I think it's a benefit. I think it's a way to keep people here in the United States while they wait in a backlog when their I-140 is approved, while they wait for the opportunity to adjust status, as an avenue for them and their partner to continue working in the United States. I don't think a country like America that was founded on the ideals of, having a competitive workforce, having a melting pot of people, I don't think that there's any problem created by that just because you're letting an H-1B holder's wife work. I really don't see the drawback in it whatsoever.
Thank you so much, Drive, for your questions, and I hope you got your answers. Thank you, Justin, for elaborately taking that up as well and answering to Drive.
It's okay. I mean, I think about it because I started practicing immigration law about 2016, 2017, around that time, and I think during that time, I have almost on a yearly basis seen some sort of animus exist towards the H-4 EAD. And I just don't see the logic in it. I think it's ridiculous. I think, well, what is the alternative? You would rather that person's spouse not be able to work in the United States. They're already living here. Why not give them an opportunity to contribute to the workforce? I'm sorry. I'm done with that. All right. Sorry.
That's cool. But thank you so much for your answers and for elaborately explaining every situation. So, Drive, thank you for that interesting question. Let's move on now to this next one we have. This is from Gilela. ISM on L1B expiring on September 2025. I got H-1B selection and opted for consular for change of status. Can I request start date on 1st January 2025?
I'm sorry. I don't think I understand that question.
I
Because
am
first
on
off,
L1B.
if your L1B is maxing, then your H1B is not going to work because, well, no, because you could have that extra 1 year. So you could have 1 year left. Okay. Change of status for same company. Okay. Yeah, sorry, I'm a little confused by this question. I'm going to take it in the way in which I think it is going to be, which is where you're trying to kind of use that extra 1 year for your the H going from the L1B to the H1B. If you were selected in the lottery, your first date on H1, I believe, is 10/1. If you're changing status. I don't think you can delay the change of status, but at the same time, I could be wrong. I've never seen that happen. I don't think it will. I think if you were trying to delay your H-1B time, you should have filed consular notification and then, leave the US, go get a visa stamp, and then come back in because you're trying to maximize that time in H-1B status, if that's what you're saying. So yeah, I think you're going to be changing on 10/1, but you know what? I could be wrong. That's not something I've tried before, so don't quote me on it.
Okay. Galila, all the best. And if you have more questions, I think it would be best to email Justin. You can mail him at support@wasden.law.
Yeah, please.
Right,
I mean,
moving.
if I could look into it more, it'd be great. Might be able to give a better response.
Yes, for sure. And now the next question we should take up is from Anabia. What are the consequences of a layoff or job termination for an H-1B visa holder? And what are the options for maintaining legal status?
Yeah, this is a great question. It comes up a lot. Unfortunately, layoffs do happen, terminations do happen. In that circumstance, with the H-1B visa, you have options. It's not an immediate issue where you're immediately out of status. The regulations allow for 60 days to either change status, find a new employer in H-1B status, or depart the United States. Now, I do want to give a caveat to that because I don't think that this is explained enough. That 60 days, it depends on how much time is left on what's called your I-94. It's either your I-94's expiration date or 60 days, whichever's longer. So what I mean by that is because I had a case recently that I was looking into where the person was terminated on, I believe, August 17th or 18th. And they were talking about using the 60-day grace period. And I realized their I-94 was actually only good till the end of September. So they had less time than they realized. But traditionally, best case scenario, you get the full 60 days because, you've got time left on the I-94. So that's where you have the opportunity to look for new employment, change status to another status, or depart. Best case scenario typically is you find a new employer. You have them file the H-1B for you. Again, always factoring in that it takes 7 days for a labor condition application to certify. So being cognizant of that and realizing, like I tell everyone, 60 days is really 50 days because you need to bake in time to get that case filed and receipted by USCIS. So you have that period. You have that grace period to use, but remember that it's shorter than you think it is. The other option, changing status. You can change maybe to a dependent status if you have a spouse that's on maybe an H1 or an L1, an F1. You have those dependent statuses as an option. The other options are moving to F1 as well. You could also maybe look into, if you have to, filing a B2 extension to give you more time to maybe try and locate an employer. You will get into a messy situation where you're going to have to file,
Okay.
change of status to B2, change of status back to H-1B. And, you basically ask the service to adjudicate those in tandem, to approve and then approve. But it's always at the discretion of the service. You could see a situation where the service denies the adjudication of the B2 to H1 because the B2 hasn't been adjudicated yet, and maybe you end up having to go abroad to actually utilize the H-1B. But those are all options for you. I would, I think I've said before, if you're tiering them, I think at tier 1 you've got finding a new H-1B employer. At tier 2 you've got changing status, and then at tier 3 you've got departing the United States. But at the end of the day, even if you do have to depart the United States, you've already gone through the lottery and had an approved H-1B. So you're not having to deal with that. So you should have an easier time finding a new employer and coming back into the United States. The biggest thing I would say, do not violate status. Don't stay longer than you're entitled to, and don't perform unauthorized work. Those violations are serious violations that carry consequences, especially in the future when you're applying for a visa abroad. But that's pretty much it. If you guys have more questions on that or a specific situation, please feel free to send an email. We can even go so far as to set up a consultation if needed.
Absolutely. So thank you, Anabia, and I hope that was very helpful. I like how you put it, Justin. Thank you for taking that up as well. Now we have Megha. What are the implications for my immigration status and future work authorization? Okay, but she's telling us more about her. I am an H-1B visa holder, and I've recently gotten married to a US citizen. Can I apply for a green card while still working on my H-1B visa, or do I need to switch to a different visa category?
No, I think I don't see any problem with being on an H-1B visa. That's fine. It's a dual intent visa. You can have the intent to immigrate permanently on an H-1B visa. So I don't think you have any issue whatsoever. I think it's a very common thing for people on H-1Bs to get married to U.S. citizens. So yeah, I don't see any issues. If you want to file in the future, I think general with filing adjustment of status going for a green card. I try to tell people stay on your non-immigrant status, even if you get that EAD. It's just a rule of thumb. I like to think that just in case something bad happens, you don't marry yourself to the EAD. But anyway, I'm getting really into the weeds. Basically, I'm telling you, I don't think there should be any issues. I think you should be fine.
No issues, Meghna. You can go ahead. All the best. And now we'll take up, I think, Ishwar's question. We haven't taken that up. This is, I have a visa interview in Chennai in September 2024, and I will be traveling along with my 4-year-old kid. I don't have any friends or relatives in Chennai to take care of my kid. Can I take my 4-year-old who is a US citizen with me for the interview?
I mean, I think you would have to look at the rules that the consulate's posited. There are definitely consulates that say they're not supposed to be kids below a certain age there. So that's all dependent on what the rules of the consulate are. I can't pretend to know the rules of every consulate. I definitely don't know Chennai's by heart. So I would just check. And I think even if there's, let's say hypothetically, there's a rule saying, you're not supposed to bring kids under a certain age, I would assume if you're able to contact the consulate, they might make an accommodation for you in the event that you have no other options. I mean, if you literally have no one else available to watch your child, then what's the alternative? You can't attend the visa interview. So I would say just talk to the consulate, try and work with them, see if there's a workaround if they say kids aren't permitted. As long as there's no rule that says kids aren't permitted, then I don't think there'd be an issue. But again, it's consulate specific. I've seen consulates say like, you don't have to bring kids. And I've seen consulates where, if I remember right, the language is more akin to like, don't bring people under age of whatever. You have to talk to the consulate specifically. Sorry. If I ever do learn the answer to that, I will share it on here though.
Okay.
Because
Thank you so much, Justin, for that.
But yeah, just talk to the consulate.
Cool. Ishwar, thank you for your question. And Justin, thank you for taking that up. And we have Anabia, who you just answered, saying, thanks, Tony. Got my answer. Thank you, Anavia, once again. And Justin, I think we are coming to an end. We have taken up, I think, all the
Yeah,
questions from my audience as well. So we
I
should
think I'm
wrap up.
talked out.
Yeah, all right. But thank you so much. It's been great chatting with you and for all those. I mean, it was a great discussion. We had very interesting questions as well. And
Mhm.
what do you have to say to wrap up? Anything about H-1B?
Um, that was a pleasure being on. I don't think we really talked about concurrent H-1Bs at all. I mean,
Okay,
it just
so
didn't
why
come
not
up.
say a little bit?
There were no
Yes,
questions about it, but not concurrent. I'm sorry, cap exempt employers.
cap
Um,
exempt.
but
Yes.
yeah, cap exempt employers is another avenue for H-1Bs if you're not selected in the lottery. Just something I've been talking about recently. Concurrent employment H-1Bs. Concurrent employment H-1B, like if you're going to a cap subject. I'm sorry, I'm talked out. Long story short, look into if you did not get selected into the lottery, possibly working at a cap exempt employer. Those are typically going to
Yes.
be research universities, healthcare that's affiliated with schools and universities, nonprofit organizations, stuff like that. And that's pretty much all I got.
Okay. Thank you so much, Justin. I think, you totally deserve this long weekend. You seem to have worked a lot, and I'm sure, like we discussed earlier, you have these very complicated cases. You do a great job. So congratulations, and thank you for joining us once again. It was great having you here today on this discussion.
Yeah, thank you so much for having me. It's always a pleasure. You guys all have a great weekend, and I'm sure I'll be back on again in the near future.
Me too. Hoping to see you in the coming week. Bye bye,
All right,
Justin. Have a
bye.
happy weekend. Bye
You
bye.
too.
Thank you, friends. And you feel free to contact Attorney Justin Rivera. His details are on the screen. You can call him on this number, 844-592-7336. Once again, let me repeat, 844-592-7336. You can email Justin at support@wasden.law and go check out wasden.law to get to know more about Wasden immigration litigation and also Justin Rivera. And also, don't forget to follow Wasden Immigration Litigation on LinkedIn for more immigration updates. And also us, we are Immigration and Jobs Talk Show. If you resonated and you are into an immigration enthusiast, why not subscribe to our channel, hit the bell icon, and you will always be notified when we have discussions like these. Furthermore, you can also contact me if you have any questions regarding immigration or jobs. And also remember that we also sponsor H-1B visas. So feel free to contact us. My number is 408-335-6444. And my email address is neep@higherightpeople.com. And to get to know more about us, check us out on www.higherightpeople.com. This is it for now, but don't go anywhere. Stay tuned to our space because I'll be joining you again in another hour with another webinar and uh, another guest. So it's going to be very interesting. Thank you so much for joining us. Bye-bye for now.
Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at neep@higherightpeople.com or visit our website www
Hello, everyone, and welcome to Immigration and Jobs Talk Show. And before I move ahead, I would like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and today we are tackling a topic that is both timely and crucial for countless international students pursuing their dreams in the United States. Whether you are about to embark on your academic journey or you're already navigating life as an F1 student, this episode is one you cannot afford to miss. Well, imagine this. You have done everything right. Secured your F1 visa, packed your bags, and prepared yourself for an exciting future. But upon your arrival in the US, you're stopped at the airport, questioned, and before you know it, you're facing the possibility of being sent back home. This nightmare scenario is unfortunately a reality for some students who fall afoul of US immigration laws. So, what can you do to avoid falling into this trap? And also, what are some common pitfalls and how can you safeguard your future? To discuss about all this, we have today with us none other than litigation attorney Jonathan Wasden. So, without any further ado, let's welcome him once again to our show. John, welcome back once again to Immigration and Jobs Talk Show.
Good seeing you again.
Thank you so much. Likewise. And to our lovely viewers, I would like to tell you that we are live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any question that you would like to ask from John, so please keep commenting them in the comment section. Keep asking your questions. We'll be glad to take them. And now, John, before I talk about, today's topic, which is F1 students, how to avoid deportation. Before I talk about that, I also would like to ask you about the H-1B second round of lottery, which was announced yesterday. So if you can, please provide a brief overview about the second H-1B lottery announced by USCIS, and why do you think it was necessary?
Yeah, sure. So up until a few years ago, the way they ran the lottery was they would run everybody through the first round and then get to that 65,000 bachelor's cap. And then they would run the master's cap. So they flipped that, and now they run the master's cap first, and then they run the bachelor's cap. So this year, what happened is the master's cap was full after the first round of the lottery, but the bachelor's cap still was not full. They didn't have enough petitions filed after selection. So they're running the bachelor's cap again. Now, it's kind of a confusing way to phrase it because the people with masters, PhDs, and bachelors all get run through the bachelor's cap all together. So it's for a master's degree or higher, it's really your third bite at the apple. And, bachelor's, it's your second bite of the apple. So to me, the reasons for it, just they didn't get the volume of petitions that they needed to, fully fill up their 85,000. And so they're going to redo the draft. It should happen relatively soon because these visas have to be awarded prior to the end of the fiscal year, and that's September 30th. So I would anticipate we'd be seeing the new lottery in the next few weeks, maybe a month at the most, and then selection notices will be coming out then.
All right. So, and what about the applicants? I mean, what can they expect, and what is that they should be looking out for?
So just updates from USCIS about the lottery being run, and then checking their online account to see if they were selected.
Right. And now that the second lottery has been announced, do you think there's a possibility of also having a third lottery?
I don't think so. I think the second one will probably fill it up. I mean, we're already at August, so we've only got 2 months left in the fiscal year. So I don't know that we have actual time for a third lottery even. So I would expect this would be the last one.
Okay. All right. Thank you so much for answering the questions related to H-1B second lottery, John. Now let's come to the topic that why we are here. discuss the topic that we are here for, which is F1 students and how to avoid deportation. So my very first question about this topic is, so John, there has been a specific section of US immigration law, section 212A, 6 and C, that has been causing a lot of concern basically among the F1 students. So if you can please explain what section 212A, 6 C covers and why it's particularly relevant for F1 students.
Yeah, sure. The 6C finding is what the commonly referred to in immigration world is a fraud finding. It covers fraud or material misrepresentations that were knowingly made by the foreign national in an attempt to get an immigration benefit. So all of those things have to be met in order to substantiate a 6C finding. When USCIS makes a 6C finding in, say, a petition process, that's something that's very easy to challenge and take to court because there's no protections for USCIS going to court. One of the most frustrating things, though, in immigration law is that the law makes decisions at the port of entry bulletproof to judicial attack. And so it's very frustrating because you have very low information CBP officers making decisions on people's lives that have a far-reaching impact, and sometimes they're not doing it with all the best information or best motives at heart. So port of entry is an inherently dangerous situation for anybody coming to the country on a non-immigrant visa.
Okay. So, it sounds like this section covers some serious grounds on inadmissibility, right? So,
Yeah.
So, how often do you see these cases where students are unaware that they violated this section? And do you think more awareness could prevent some of these issues in the future?
So it's really scary because I've seen cases where, the famous one was the Atlanta case a few months back, or maybe actually a year back now, where there was a group of students on a flight coming from India,
Right.
and they all got stopped, sent to secondary, and sent home with fraud findings saying that their F1s were shams or frauds. These students, many of them had evidence on their phones that they had acceptance letters from universities, they had paid for tuition, they had lined up housing, they had done everything in the world to show that they were actually going to school. But some yokel CBP officer decided that, that was fraud. Really, it's just a way to hassle people at the port of entry. I'm not a big fan of CBP. I don't think they do a great job, just full disclosure. And I think they have way too much power and authority for what they do and for the level of knowledge that they have. So it really comes down to protecting yourself from these low information government bureaucrats at the port of entry. One thing that we commonly see happen at the port of entry is your constitutional protections are lower at the port of entry inherently. So unlike a traffic stop or something like that where they need a warrant to search, the rules are more flexible at the port of entry. They can take your electronics, they can take your phone, they can go through your bags. So, you see oftentimes they'll go through somebody's phone, looking through all their old email accounts or WhatsApp messages, looking for anything that they can to, substantiate their theory of what's going on.
Right.
So, you got to ask yourself, is it worth it to carry your phone? Is it better to go without your portable brain for a couple of days, FedEx that to yourself, and then get it when you get here, instead of just exposing yourself to CBP rifling through your private information on your phone? So, that would probably be, something advisable if you're worried about this, just to FedEx your phone to yourself, just to avoid the potential problem that could happen.
Right, but what according to you should be their first step? Because in a situation like this, when you have no clue about anything, and your phones are taken away, and other things. Mostly you are left with nothing, right? And you are
Yeah.
in a country where you don't know what to do and whom to contact. So in a situation like this, what do you think the students should do?
So for F1s, I think it's important to know your contacts. People at the school that you've been dealing with, have their phone numbers, have their emails, have their names. So when you're asked any questions, you can give that to CBP, and they have somebody that they can contact to verify information. So I would take all this just in a folder, just paper copies. That way you can just hand it over to the CBP people. Your acceptance letters for university, all of those types of things, proof that you've got housing lined up. All of that would be helpful to have in a tidy little folder that you can just hand over.
Right. Okay, thank you so much for answering the question, John. Also, John, I would like to know from you that what are some of the most common mistakes that F1 students might unintentionally make, that could lead to issues of fraud or misrepresentation under this section?
Sure. So there's maintenance of status issues, and then there's fraud issues.
Right.
What USCIS considers to be fraud, I think the biggest thing we're seeing right now is people that were scammed by fraudulent employers who were preying on recent college graduates with F1s, telling them that they were going to hire them, place them on a project, but you just need a little bit more training before they can put you on a project. And oh, by the way, we do the training and it's going to cost you. So that scheme is relatively common, or was more common recently. And anybody that was caught up with one of those companies, eventually at some point or time in the future, you're going to get, sent to secondary. You're going to have problems with, DHS with this issue. It might be at the State Department of the consulate, might be at the port of entry, but those fraudulent scam employers are the biggest threat probably right now that I see to people on an F1.
Mm-hmm, mm-hmm. And are there any support or help available for these students?
So you can request that you be able to call an attorney. Again, at the port of entry, your rights are very limited. If you do carry your cell phone, or if you do carry a dummy phone or a burner phone with you through the airport,
right,
I would just ask them if it's okay if you can record the conversation so that you have, make sure there's no language barriers or problems with understanding, so you have a clear record of actually what was said. If they have a problem with that, that lets you know you're not dealing with an honest officer. If somebody's afraid to be recorded, that's a red flag. The other thing that I would say is, excuse me, let me grab some water.
sure.
Now I lost my train of thought. But yeah, I would say, ask them if you can record them. If they say no, be very suspicious of them at that point in time.
Right. Thank you so much for that great advice, John. And also, John, given how easily these mistakes can happen, so would you say these issues are mostly due to lack of understanding of the visa requirements, or are there other factors at play too?
So I think a lack of awareness on students' parts about the scam employers is probably the biggest problem. USCIS didn't really help anybody out in this regard either, because they were aware of these scam companies out there. They had identified them, they had blacklisted them and flagged them in the system, and then just waited for people to get caught in the scam. So what a legitimate law enforcement agency should do is alert the public that there's a problem out there and to be aware of it. But USCIS almost fanned the flames here. They knew these companies were in existence. They didn't decertify them from E-Verify. They let people blindly walk into it and then held them accountable for the fraud that the company perpetrated. So you gotta really advocate for yourself in these situations and really thoroughly vet anybody you're taking a job from to make sure there's no problems. As a general rule, I would say anybody that's asking for payment for training or a letter or anything, you should not only stay away from, but run away from.
Mhm. Right, right. And any specific advice you would like to give these students to avoid these pitfalls? I mean, so that they don't get into these things. I mean, because
To the extent you can, I mean, social media is a great thing. To the extent you can, contact people that have worked there. Go off referrals from friends. Make sure that if you're on STEM OPT, that you're following all the requirements for STEM OPT, or that company is actually following them. Because if you have a STEM OPT employer and you're not following the training plan or any of that, then if there's an RFE on whether or not you maintain status and you don't have that information, you're going to be in the world of hurt, and you will be found to have not maintained status because your employer wasn't documenting correctly, and then that'll mean you have to consular process. And as anybody knows, consular processing right now is a nightmare. It's the number of 221Gs going out is just astronomical right now, so you want to avoid that as much as possible. So you really have to advocate, and if your employer is not complying with the rules, you should probably look for a new employer. And just to protect yourself, consider reporting it to DHS, just so you have a documented history of saying, hey, there was a problem, it wasn't my fault, I'm finding a new employer. So you may have to be a little bit more proactive. Now, that said, if you're going to go that route, highly recommend talking with an attorney first and maybe having them do the letter and them do the correspondence for you, just to make sure that you're not inadvertently saying something that's going to hurt your future.
right. And is there a way to also find the right attorney for such cases?
Again, word of mouth, people that you trust, just Google reviews, that just look for somebody that has experience in this area that you can trust.
Right, right. Also, John, so beyond misrepresentation, what are the other main reasons, international students might face deportation? And again, how can they avoid finding themselves in, such situations?
So there's two different things. One is non-immigrant intent, and then the other is not having the right travel documents. The travel document one is, I think it's an A7. It's kind of disingenuous for them to give you an A7, because typically what they're saying is, you show up with a valid visa and the CBP officer says you don't have the required documents because we're revoking your visa, but they're revoking it because of A6 for the fraud finding. And so, you're getting an expedited removal, and it's for not having documents, but really it's a lifetime bar because of the fraud finding. The maintenance of status issue is something we're starting to see more commonly recently, where they start, looking into whether or not you're going to be returning home at the end of your stay. We see it a lot on B2 visas, especially, but F1s as well. So they will, be constantly probing to see if your intent at the time you enter the US is to stay permanently, or if your intent is to finish your program and leave. And so, you just have to keep in mind what your non-immigrant intent is. One other thing before I forget, when you get pulled into secondary, if they're going to remove you, to a 235 removal, sometimes they will give you the option to withdraw your application for admission. If they ever give you that option, that is the best course of action to take, because that avoids having any bars against you from reapplying for admission. You can go to the consulate, you can do a trip report, you can try and fix whatever the problem is that CBP believes there was, and then reapply for admission. But if you get that expedited removal, it's much, much harder to get back into the country.
Right. And also, it is said that the visa officers also see your intentions. What are your intentions? So how can the student, show their correct intentions to the visa officers?
So for the students, it's a tough one, right?
Right.
Because you're young, you don't own a home, you don't, have a lot of substantial business ties or anything like that.
Yeah.
So it's tough. You just have to, say the truth. You're just coming to get an education. This is the best place for it. And, you probably will, look for OPT to get experience to solidify your education.
Mhm.
For the B2s, what we typically see them looking for is, proof that you have a residence in India that you're going to return to. Again, if you're younger, that's going to be tough to
Yeah.
do, because if you're going to be gone for 6 months, you may not maintain an apartment. So, those are the types of things that they're looking for. Again, the system is set up to give CBP a lot of discretion on what they decide. And it really comes down to the eye of the beholder. What does that individual CBP officer think or want to find?
Mhm.
And so that's why I said earlier, if you can record them or request to record them, if they say no, you're not dealing with an honest broker. You're dealing with somebody that wants to just find the facts to support their assumptions.
Right.
Along those lines, a lot of times they'll have you do a written statement, or what they'll do is they'll interview you. They will type up a summary of the statement, and then they'll put your signature on it.
Mhm.
They get your signature electronically before the beginning of that interview. And then they affix your signature to that written statement after the interview without letting you see that written statement. And that becomes the official record. So I would not sign anything when you go into that secondary. If they give you that digital signature pad, I wouldn't sign it. I'd say I'll wait until I see a written statement before I sign anything, because I want to make sure it's accurate, and demand that you see that written statement before you sign it. Read through and make sure it's accurate. Make annotations to it if it's wrong. So you really have to be assertive. You really have to protect yourself and advocate for yourself in that situation.
Right. Thank you so much for such great tips, John. Also, I would like to discuss, about this case. I think I don't know if this was the same case that you were also mentioning about the 33 students who were deported at the USA Chicago airport on January 15th this year, 2024. So, this incident has understandably caused a lot of concern. So, how can such cases be prevented in the future?
So the biggest things that I would say is never go through Chicago. Chicago's CBP is notorious. They
Okay.
are, without question, the worst airport in the world to travel through for abusive law enforcement tactics.
And why is that?
It has to do with leadership for that particular office, would be my guess. But it's been bad. I think the people that are working there just have a bias. And it's just someplace I would avoid like the plague if I could. So I would make your port of entry someplace other than that, or Atlanta. Atlanta's also got an overly aggressive CBP office that, they shoot first and ask questions later, so to speak. So I'd avoid those two places as your first line of defense. Even if it means taking a few extra hours to get to your destination, it's probably worth it.
Okay, and what role can universities and immigration advisors play in preventing these unfortunate events?
So that's a frustrating question, because some of these people, I talked with some of those students, and there is nothing in the world, there is no more information that they could have possibly had or presented to that officer to show that they were a legit student, that they were going to be engaged in a program of study, and everything lined up, all their documentation lined up, but it didn't matter. They just, did the expedited removal and said, you're not coming here to study, and sent them away. Now, these are people right at the beginning of master's programs, these at legit universities, like University of Chicago, some of them, like very, very solid, well-known, reputable colleges. And they had paid tuition, but it didn't matter. They had housing lined up, it didn't matter. So for those people, it's frustrating because there is nothing in the world they could have done to alter the outcome other than possibly change the airport that they flew through.
Right. Okay. And, also I would like to take a moment to also discuss about, when students first enter the US. So how do these immigration officials at the port of entry determine if an F1 student is inadmissible under section 212, AC6? So, and what are the key factors? Are there any key factors they consider doing this?
So there's a database that's called the Consular Consolidated Database. And the Department of State, the consulate, can upload information to it and access information. CBP can access the information and upload to it, as well as USCIS. For the OPT scam employers, what they're doing is USCIS is identifying who is associated with these companies. They're going through their records, they're matching up, they rated the companies, they took their list of employees, and then they started matching up names. And so then they uploaded that to the CCD, that database. Now, some of these people stayed in the country, got H-1Bs, extensions of H-1Bs multiple times, and never heard a word from USCIS that there was a problem with their OPT experience. It's not until they go to the consulate or they go to the port of entry that they learn about this. Because the first thing that happens at both the consulate and the port of entry is they get your biometrics and they pull up your file in the CCD. And if there's any flags or any hits in the system, you're immediately going to the secondary, or you're getting focused and attention. And USCIS is flagging people in the system and then waiting for them to go to the port of entry or go for stamping at the consulate. And that's where they're hitting problems. That's the very first thing that happens is they notice that flag and they're pulled in.
Right. And let's say that if the immigration officer suspects something is wrong, then what happens next? And how can in a situation like that, how can the student respond during that moment? That can impact their situation.
Yeah. So the first thing to remember, if you get pulled into secondary, by and large, these people are bullies. They are basically mini little Trumps working around and just trying to throw their weight around in their authority. And so it is not uncommon at all for them to try and bully you, intimidate you, yell and scream at you, keep presenting you with a scenario or facts that they believe and demand that you agree with them. And if you don't agree with them, for them to lose their temper and basically throw a tantrum like a toddler. So just be aware that is their MO, that's their process that they go through. And when it happens, don't get flustered. Just stay calm, disagree with them where you need to. Again, ask for recording and refuse to sign anything, because if they're throwing a tantrum like that and making wild accusations, their summary of your conversation is not likely to be accurate.
Do you have a case, where something similar happened that you would like to discuss with us and the audiences?
Yeah, I mean that's such a common scenario where you get pulled into secondary and somebody starts yelling and screaming at you and accusing you of having done something wrong.
Right.
And no matter what you say, no matter what evidence you bring, in support of yourself, they keep on screaming. It's almost like they have a quota of people that they have to reject at the board of entry. So they're, maybe at the end of the month, you see this happen more as they're hitting their time for their quota. But, it happens all the time. Like I say, some airports are worse than others. But it's not exactly the way you'd want a reputable government agency to behave, but it's how they operate.
Right, right. All right, thank you so much for answering the questions, John. And I can see people have started commenting their questions. So I would like to take a couple of them from the audiences. Okay, let's take maybe Ramesh's. So Ramesh is here and he says, I know this session is for F1, but related to H-1B fiscal year 2023. My petition was revoked and back to India. What are my chances to secure my cap number back where there no fault of mine and issues for fiscal year 2025? What do you have to say, John?
So this is an issue we've been suing USCIS on, and we're not at the end of the process yet, but so far the signs are positive. What we're trying to do is, for people in that situation, is to recapture their cap number that they initially were assigned. Now, when we first started suing USCIS, what was happening was people would be going to the consulate for a new visa category, and they were told that they had a fraud finding applied against them based on their employer's multiple registrations. And so that was game over. They had a fraud finding in the system. We started suing and challenging that issue, and USCIS almost immediately realized that they were doing it wrong, and they changed their policy and the way that they were handling that situation. So now if you're the employee who was, the subject of a multiple registration, you are no longer getting penalized by USCIS. And that's a huge change, and that's a huge, benefit to you. So what that means is on future H-1B lotteries, it shouldn't have any impact on your ability to get a visa.
Right. And he also has a second part. He says, my H-1B petition for fiscal 2023 was revoked due to multiple registrations. Even though I wasn't involved, I had returned to India. What are my chances of getting a cap number for 2025? Any advice?
Yeah, there's not going to be anything, ideally nothing that is going to follow you or impact you from that multiple selection. If you get an RFE on it, we should talk and strategize for how to respond to that, because USCIS is on record in all kinds of court documents saying that they will not penalize the employee for the employer's alleged misconduct. So it shouldn't have any impact on your 2025 petition. I think you should be fine there.
Right. Okay. So Ramesh, you don't have to worry. And yes, thank you so much for your question. Let us know if you have a follow-up or if you'd like to know an answer to another question. Thank you so much for posting your question. Let's quickly take RK's question also. So RK is here and he says, is there any truth that attorneys litigated against USCIS asking employers proof having a project before approved, because few employers use not requiring to show proof to take a genuine cap and bench their workers while looking for a project, while genuine students miss out? We know it's wrong what they are doing, but last chance students are losing out.
The structure of the H-1B lottery system is very flawed, I guess, to say it in a very kind way. The lottery is held in March. And if you're working for a staffing company, the industry standard for a lot of these companies is to operate on 6-month projects. So the best case scenario is if you get selected, you get approved, and the stars line up and you get a visa stamp and you're able to enter the country by the beginning of that visa period, you're already past 6 months. And so it's almost impossible to have a project that's guaranteed at the time they file your registration. And really, no employer in the world is going to sign a legally binding contract for an employee to work at a client site when they don't even know the outcome of the lottery yet. And so it's really impossible to have that project requirement. And more importantly, that's just not my view of it. It's what the law says that Congress created. So the Congress, when they created the H-1B restructuring, what they said is that you can legally bench people, but you have to pay them while benched. And so that's the protection, that's the trade-off, is that employers can take that risk. But once you're in the country and available for work, if they're not paying you, they have a substantial legal liability. And so that's the system is flawed, but that's the best remedy that people have. I think his question is really going more towards the people that were selected in the lottery still in India and are not able to get visas. That's a tough one, because if the employer doesn't have a project and they are not going to bring you, there's not much you can do there. But it's really more a flaw in the system than it is in the employers doing something wrong.
Right. He also has one more question. I would like to read that out. He says, how is it that they selected 130K with a 20K for the master cap, which was filed, for the remaining 110K, they weren't able to get 65K? Does this indicate employers just registering applicants?
Yeah, probably. There's a gap there. They registered, then business situations change. We're now, like 5 months past the initial lottery. A lot changes in 5 months. If you look at the tech industry, there's a lot of layoffs going on. And I think the rate of filing petitions kind of tracks the greater tech industry in general. So as the tech industry is shedding jobs, there's really not a need for those H-1Bs you'd anticipated coming into the country and working on H-1B. So, a lot of things in the business world can change and impact filing rates. And I think that's probably what we're seeing here.
Right. Thank you so much, RK, for your question. I hope you've got the answer. We still have a lot of questions from the viewers, John. But before I take them, I would like to go for a short break. And after the break, I would like to take these questions from the viewers, if that's okay to you.
Sure.
All right. So, guys, it's time to go for a short break. But you guys don't go anywhere, because post the break, we are going to take up questions from you. So, yes, keep on watching Immigration and Jobs Talk Show and stay tuned with us.
Consultant seeking a new opportunity? We offer job placement. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards.
Welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and today I'm here with none other than immigration litigation attorney Jonathan Wasden. And today we are discussing about F1 students, how to avoid deportation. And yes, we are getting questions from you. So now, without any further ado, let me take another question. So the next question that we have is from Vishwa Das. Let's take Vishwa's question. He says, currently on F1 visa and my program end date is in 2 months. However, I need more time to complete my thesis. Can I apply for a program extension? And if so, what documentation do I need to provide?
So if you're still working on your program, theoretically, you should be able to get an extension of that. Now, the caveat being is you got to know your limitations. My limitation is I don't file these petitions. Yeah, I litigate on the fraud findings, I litigate on denied petitions, and kind of try and fix things that were broken in the process after the fact. So I would say talk to an immigration attorney that actually files this type of petition, because they're going to have standard formats that they've done this 1,000 times, and they can run you through it, and they can give you that information, and they can line up your package to make it as strong as possible to get what you need done.
Right. Okay. So Vishwa, I hope you've got the answer. Thank you so much for your question. Let us know if you have another one. Meanwhile, let's take Imran's question. So Imran says, I am on F1 visa and got married to a US citizen. Can I apply for a change of status to a spouse visa, CR2, or do I need to leave the US and apply for CR1 visa?
So if you're married to a US citizen, you would be looking to adjust status, and you should be able to do that while you're here in the country. So, I don't know that you would need to leave the country. Again, the caveat being I don't file these. It's not my area that I practice in on a regular basis, the family petitions. But my understanding is you can stay in the country while you make that application.
Okay, and he also has a part 2, John. He says, what are the benefits and drawbacks of each option, and what are the required documents and filing fees?
So if given a chance, seeking immigration benefits for marriage to a US citizen is always your top choice. There's really no easier or better way to get that. Now, with US citizens marrying foreign nationals, there's a lot of scrutiny that they give your application. They look for evidence or indicators of marriage fraud, things like that. So you're really going to want to go through and just show that the marriage is bona fide, and probably pictures of dating time, pictures of weddings, lists of who was at the wedding, things like that, just to show that this was a legit marriage and it's not just for the purpose of getting immigration benefits. Signs of cohabitation, shared utility bills, shared leases, shared addresses. Just anything that shows that you are a married couple is going to be very useful for your application. And the filing fees, like I said, I don't file these, so I don't know off the top of my head what the filing fees are. But you can just Google that on USCIS's website, and it'll pop right up.
Right. So you can check that out on USCIS's website, Imran. And thank you for your question. Let us know if you have another part or a follow-up or maybe another question for John. Let's take Dipesh's question in the meanwhile. And he says, I have received an RFE on my F1 visa application stating that my bank statement doesn't show sufficient funds. However, I have since deposited more money into my bank account. Can I submit an updated bank statement, or do I need to reapply entirely?
So if you haven't replied to the RFE yet, you can provide the new bank statement. If you've already replied to the RFE, you can try and do a supplemental. A lot of times, USCIS will not accept the supplemental filing, but you can try. There's nothing that says you can't do it. So, I would say if you're past the point where you're outside that window of the normal reply time, maybe reapplying would be the way to go.
Right. So, Dipesh, I think, like John said, you should reply then. Then Paul is also here, and Paul says, I was on F1 visa and worked part time for 6 months without authorization. I have since stopped working and want to apply for OPT. Can I apply for OPT, or will my unauthorized work impact my eligibility?
If USCIS knows about the unauthorized employment, it will definitely be a problem. And that is one thing that they are, when they have that information, they don't always have it. A lot of times there's no way for them to know. But if they have that information, it's definitely going to be a problem for you. Unauthorized employment as a student can, create a 3-year bar to re-entry into the US. So it definitely will be an issue. My guess is if they have any information about that, they'll be giving you an RFE or an NOID. And so you'll be responding to that.
Right. So, Paul, thanks so much for your question. I hope you have got the answer. Ramesh's question, I think we already have taken. Vishwa's question also, I think we already took. RK also, I think we already have taken. Alok is also here, and he says, I have been on F1 visa for 6 years and have completed 2 master's degree. I want to apply for a PhD program, but I'm concerned about the impact on my F1 status. Can I apply for a 3rd degree on an F1 visa, or do I need to change my status to an H-1B or J-1 visa? What are the rules and regulations regarding F1 status and multiple degrees?
So typically as long as you're, advancing, making progress up the educational ladder, you should be fine. So a PhD, it's kind of a natural progression. You go from bachelor's, master's, PhD. So I wouldn't expect that to be a problem for you. I would expect if you filed for a 3rd master's degree to get a lot of scrutiny in the application process. But for the PhD program, I think you're fine. But if you have the option of an H1, why not go for that and then do your PhD in the part-time. The one thing I will caution about PhD programs is just make sure that it's from a legit university, because they have a list at USCIS of colleges that are suspect, and degree mills, things like that, places that only exist to issue CPT. And you don't want to be involved with one of those colleges. You want to be with a no kidding university that has a PhD program that has some legitimacy.
Right. But John, is there a reason behind the lot of scrutiny that you said?
Sorry, say again?
So is there a particular reason about the scrutiny that you mentioned?
Yeah, because it questions whether or not you're really looking to get an education, or if you're just really trying to stick around to work. And so if the immigration agency looks at it as you're just trying to game the system to work, they will inquire further into your application.
Right. Thank you so much for answering the question. And Alok, thank you so much for your question. Let us know if you have another follow-up or maybe another question. Meanwhile, Biraj is also here, and he says, I'm on F1 visa and was recently arrested for a DUI. Will this affect my F1 status, and can I still apply for OPT or a green card in the future? Okay, let's
So
take
it could impact your F1 status.
Mm-hmm.
So typically the way these things work is your arrest record gets reported to DHS. DHS uploads that to the consular consolidated database, you're flagged. Then it goes to the consulate, and the consulate decides whether or not to revoke your F1 visa. If they send you an email, and I would keep an eye on your spam folder, I would keep an eye on your email inbox. If they send you an email contacting you saying that your F1 is revoked, what that means is you don't have to leave the country right away. You just won't be able to come back into the country once you leave. So it shouldn't be, a problem for finishing your program. I doubt it's something that will come up in the OPT process. They could RFE you on it, but it's not one of the things that they would typically, focus in on an OPT.
Okay, and he also has a second part, and he says, what are the potential consequences of a criminal record on my immigration status?
Yeah. So, the real problem is going to be going for stamping, or whether or not you maintain, if they're going to find that to be some type of violation of your non-immigrant status. USCIS may deny a change of status or an extension of status. Probably not the most likely outcome. The most likely scenario is going to the consulate and the consulate making a decision on you because of your criminal, conviction for DUI.
Right. Okay, so Viraj, thank you so much for your question. I hope you have got the answer. Malika Arjun Rao is also here. Let's take his question. So he says, I am currently on an F1 visa and want to transfer to a different university. Can I transfer my service record to the new university, or do I need to apply for a new F1 visa?
So again, limitations are I don't file these, but I believe you can transfer to a new university without having to file a new F1 visa. So, talk with your DSO, the designated school officer or the DSO. They know this process backwards and forwards. So, get an appointment to go in and speak with them about how to do that. Now, if you're transferring universities, again, the caution I give everybody on F1 is make sure the university you're going to is not a degree mill. It's not a CPT mill. It's a legit university that's offering legit course of studies that it's reputable. And that's, very important for avoiding problems in the future.
Right. And he also, again, has a second part, and he says, what are the requirements and procedures for transferring my service record?
Yeah, again, you want to talk to your DSO, and the DSO will be able to walk you through that whole process.
Okay, so Mallikarjun, I hope you have got the answer to all your questions. Thank you so much for posting them in the comment section. And John, I also have questions from the viewers actually on my WhatsApp. So let me quickly read these questions. I'm so sorry, I'm taking a bit time. Okay, so here it is. The question is, will I be deported if I say that I'm staying at my friend's place because the university is close to his locality?
You mean, I guess they're asking if when they're coming through the port of entry, if they're asking where they're living. That wouldn't necessarily be a deal breaker. But if you have a lease or you have some type of documentation of where you're going to be living, that would be best. If you have some type of agreement with your friend to split costs, if you can get that in writing, that would be a great piece of information to have. But just staying at a friend's place isn't going to be a deal breaker. People have roommates all the time, so.
Okay, all right. Thank you so much for answering the question also, John. And again, okay, so I have one more question for you. And this question is actually from a guy, and he says, I already got my F1 visa, but just after, where is it? I already got my F1 visa, but just after it was issued, my I-130 filed by my stepmother got approved. Will this be a problem at immigration?
I've never seen that scenario come up. It shouldn't be. Although typically when you have an immigrant visa petition and a non-immigrant visa petition, they focus on your non-immigrant intent. What are you going to do? I don't know how long the wait period is, for a I-130 in this situation, but you're just going to want to make clear that at the end of your F1 program that you plan to return back home until your priority date's current. You can get a visa on the 130. And that's really going to be the issue. What is your non-immigrant intent coming in on the F1?
Right. And I also have one more question. And the question is, where is it? Okay, what should I do if my F1 visa got revoked and I received a 5-year ban? Can I go to the USA for my studies again?
So it really depends on why it was revoked. If it was revoked with a fraud finding, no. You're going to have to deal with that fraud finding before you can get another visa. If you're still within that 5-year ban window, you're going to have to, get a waiver for that, or figure out a way around that. But if it's not for fraud and you're outside that 5-year period, theoretically you should be fine. Now, when you go for stamping, or you go for, the port of entry, they may ask you questions about it, and you just have to, answer that as best as you can. I'd say consult with a, immigration attorney before you go to the consulate or before you go to the port of entry, just to get some, pointers on what the questions will be based on your specific facts, and how best to answer that based on your history.
Right. And, these are some questions posted in some groups. So we try to look for these questions also. And one last question for this episode. I got my USA visa on 12th January, and I'm going to the University of South Dakota in July. I have paid my enrollment deposit and first semester fee, and all my documents are legit. However, I'm afraid due to the recent news about deportation involving students from South Dakota. Any suggestions?
So I hadn't heard about students in South Dakota facing issues. My first suggestion would be buy the warmest clothes you can possibly find, because South Dakota is the coldest place I've ever been. In terms of documentation, same rules apply. Just make sure that you've got proof that you can pay for the tuition, or you have paid for the tuition. You've got housing lined up. Correspondence back and forth between the school, if you've got it. Have a contact at the school that can vouch for you and say, yes, they're coming. Yes, I've been discussing with them. Just make sure that you have all of your bases covered when you go through the port of entry. And again, Chicago might be convenient to South Dakota for the port of entry, but I would avoid it. I would, look for a different place to go as your initial stop in the U.S.
Right. Okay, so John, one last question before I let you go. Any last feedback or any last suggestion for the F1 students, who might be worried about their deportation at the moment?
Yeah, so I would say you have to be your biggest advocate. You have to be assertive, and you have to look out for your future. So, when it comes to picking a university or a college for a program, make sure they're legit. Make sure they're reputable. They're offering real courses of study, and it's not just a degree mill. When we're talking about post-employment on OPT, make sure that they're following the rules. The employer's following the rules. Watch out for people that are asking to, receive money for you to work for them. Avoid those types of situations, and make sure. There are worse things than being unemployed and having to return back home because you don't have a job. And that worst thing is never being able to come back into the U.S. again if they find you have committed immigration fraud. So, be very, very careful with your choices on F1, and you've got to protect yourself that way.
Right. Thank you so much again, John, for coming and doing the show. It was, again, a great episode. And to our lovely viewers, I would like to say that if you want to get in touch with John, so you can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. You can email him at support@wasden.law. Is that right, John?
Correct, yes.
Yeah. And you can also visit his website, which is wasden.law. So you can also check that out. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is +1 732 707 9151. My email is rajni@higheritpeople.com. And our website is www.higheritpeople.com. Remember, we sponsor H-1B visas and other work visas based on job availability and regulations. All right. With that, thank you so much again, John. Hoping to see you next week with another great episode and great topic.
It's good being with you. Thank you.
Thank you so much. And to our lovely viewers, thank you so much again for turning in such huge numbers and continuously posting your questions, asking your questions. It really means a lot. If you like the episode, don't forget to like it, share it, and also comment down below. And yes, keep watching and keep subscribing to Immigration and Jobs Talk Show. We have 2 more webinars coming up at 12 and 2, so don't forget to check that out. And for now, I will have to take your leave too, and I'll be meeting with you soon. But yes, for now, I'm Rajni Bharara signing off. You guys take care and keep on subscribing.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome everyone to Immigration and Jobs Talk Show, and I'm very happy to have you all join us today. I'm Napasa Pradhan, and I'm going to be your host for this session. And before we move ahead, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, it's really very fantastic to have all of you join us today. We are streaming live right now on YouTube, LinkedIn, and Facebook. And I'm very excited to tell you that this could also be a very participative session. All you have to do is type in whatever questions you have in the comment section, and we'll be very, very happy to take them up in this session later. For sure. And today we are going to dive into this very important discussion on this topic. Can product managers and software engineers qualify for the EB1A visa? And it's a topic that is especially relevant for highly skilled professionals out there in the tech industry. And of course, I am very, very excited today because we are going to have one of our very special guests back with us, joining us after months, really. I think we met last before summer. So please help me welcome attorney Prashant Dubey once again back here on Immigration and Jobs Talk Show. Prashant, really happy to see you after a real long time and really good to have you here. Thank you for joining us.
Yeah, no, thank you. Thank you to the Higher IT team for welcoming me back, right? And having me on another episode, another webinar. Thank you, Nabasa, Zayed. Thank you for all the technical work you do in the background. I'm sure I'm going to have one technical difficulty at least. Otherwise, it would not be a webinar where I have participated. So if I pivot to my phone, don't be surprised at some point. But glad to be back.
Very glad to have you back with us, Prashant. And so, yes, today's topic, what can folks out there expect from us today?
Yeah. So today, one of the reasons why I think this webinar specifically around the EB1A is highly relevant, right? I know we've done a series of webinars before on this topic specifically, and it was very high level, right? Can folks in IT qualify for the EB1A, for example? And we talked about the EB1A process, application requirements, how people qualify. And I think this is a really good opportunity to start double clicking on very specific profiles, right? So, for example, for today, we're going to be discussing how product managers, how software engineers specifically qualify. And I know behind the scenes, we were discussing, doing an episode for like cybersecurity folks, data engineers, that sort of thing. And over the last several months, one of the reasons why I kind of disappeared from these webinars is because this part of my practice has really started to scale. And the reason was pretty straightforward. So since October 2022, EB1As have become a very hot topic, right? Ever since the retrogressions and priority dates happened. And I was working with one or two clients at a time over the last couple of years to help them get their EB1As approved. What happened earlier this year around the May, June timeframe, one of my clients who got his EB1A approved, he works at Meta. He went and posted internally in a Meta forum about his success with our firm, and then things just kind of exploded from there, right? So over the last, I would say 5 or 6 months, I've probably done twice as many EB1As as I did in my first, my last couple of years, where I've noticed this become a trend. Lots of consultations, calls. And so it's a really interesting time, at least for me, and I think the EB1A community, because there's a lot of best practices that I feel like I'm now uncovering as I'm doing this at a much larger scale, and with many, many more types of clients and different profiles and different case studies that I can bring to the table today, right? And of course, there have been some changes as of October in how USCIS is going to be looking at the EB1 criteria, and we can get into that. And then, of course, I know there's a lot of anxiety around, the presidential election and the recent results,
Right.
and we can talk about that too.
I was just coming to that, and I think before we head on to today's topic, maybe you could tell us how Donald Trump being elected the 47th US president is going to affect even this category of visas. And it'll be great your point of view on this as well, Prashant.
Yeah. So there's a couple things to that. One is just like my personal experience, right? So like the very first EB1A I ever filed was for a dentist. And it was during the height of the Trump administration about 4.5 years ago, right? And he got approved just fine, right? I think when it comes to the next administration, what I saw previously between 2016 and 2020 was that there was impact for EB2 and EB3 candidates, right? Even H-1B candidates. Reason being that there are different areas of that process where they can really influence what's happening, right? And what I mean by that is in EB2 and EB3, you have things like the prevailing wage determination, right? So they can slow that down. You have things like the recruitment process, right, which can really come back and hurt you. Let's say at the I-140 stage, they have the perm application itself, in which they can increase their audits, right? And those are the types of things that we saw the Trump administration do previously, right? When it comes to EB1As and EB2 NIWs, I think any administration has a very keen interest in keeping the best and brightest people here in the US, right? And if you look at his rhetoric, it is all about, potentially changing rules, regulations as it relates to maybe asylum seekers, people illegally entering the country, right? But when it comes to these merit-based applications or these merit-based benefits like the EB1A, like the EB2 NIW, he really that's not a part of his rhetoric, right? I don't expect there to be a whole lot of impact for my EB1A and EB2 NIW clients because this is a self-petition, right? These applications go directly to USCIS. You have nothing to do with the Department of Labor, so there's nothing they can influence there. It's just you and the officer and the case you present, in front of them, right? So I'd say from that perspective, I hope people aren't as anxious as maybe they might be coming off for EB1As and EB2 NIWs.
But definitely, I think everyone is anxious, especially immigrants out there, like what's going to happen. Some are really maybe even taking up actions before things get worse for them.
Yeah.
I mean, that's what their thought process is, I guess. So a lot of things are happening. I think people are still processing the whole information, Prashant.
Yeah, and I'm seeing it too, right? Like I've got clients who are like, can you take my case now? And I'm like, the earliest I can take it is at least January, right? Like I'm working with a cohort of people, that sort of thing. And I'm seeing a sense of urgency where people want to try and apply right away. And like our timelines are just not matching up, right? And that's okay. But I am seeing that sense of urgency where people are worried. But I think it might be a little overdone.
For sure. But let's head on to today's topic, and I got some questions prepared. So, Prashant, if you could just tell us, how might product managers and software engineers qualify for the EB1A visa? And this requires evidence for extraordinary ability in their fields. And what impact might Trump's previous stance on merit-based immigration have on their chances?
Yeah, I think that second piece I kind of covered in the first response, right? I think based on his rhetoric, whether it was the previous, from 2016 to 2020, or let's say 2024 or 2025 and, moving forward, I don't see an impact on merit-based applications, right? Especially not EB1As and not EB2 NIWs. Again, any administration has a very high interest in keeping the best and brightest here in the US. Now, when it comes to qualifying, right, for the EB1A, for example, for product managers and software engineers, let's take the product manager profile first, right? Product managers are very interesting individuals because they sit at the intersection of IT and business, right? So one advantage that product managers have is that they can very easily and often, do very easily communicate the business outcomes that are driving their projects, right? The KPIs associated with it. What is the organizational impact? What kind of impact is my work having on the industry, right? And when you sit at that intersection, it's really important for at least two of the criteria: critical and leading role for a distinguished organization. Second one is original business contributions, right? Because we want to be able to prove that the work that somebody's doing is important at an organizational level, right? We want to be able to prove that the work that they're doing is innovative and also influential in the industry. So I think for those criteria, right off the bat, product managers are really well situated to satisfy those requirements. I recently had a product manager that I worked with. He's at Meta. He works specifically with networking technologies. Okay. And for him, we argued on four criteria: critical and leading role, original business contributions, judging the work of others, and then salary, right? And I often see for product managers, those are the four criteria that they are satisfying, that they are hitting, right? Most commonly. There might be others like memberships, awards, authorship, depending on the makeup of the profile. But at a baseline, those are the four that I typically see come across my desk, right? And, it's important, I would say, for critical and leading role to raise your projects that you've worked on to an organizational level, right? What was the organizational impact? What was the dollar amount impact? How much cost savings did you achieve? How many manual labor hours did you reduce, for example, right? And then for original business contributions, one of the things I want people to think about is raising it to an industry level. So not only, what you worked on was innovative, but how was it adapted maybe by other organizations, other companies out in the field, right? And for that, one of the best ways to showcase it is expert opinion letters. So recently, one of my new best practices is to kind of urge my clients, go and find one or two individuals out in the industry who are experts in their field. And an expert can mean many different things to many different USCIS officers. For some officers, an expert is somebody who has a Google Scholar profile with over 1,000 citations. Go find that individual. They might already be in your network. They might already be in your chain of command. An expert can also be somebody who is a thought leader, right? They pop up frequently in news media for comments about what is happening in the industry. And what I'm finding is, as my practice has scaled over the last 5 to 6 months, the individuals that, the one or two individuals that, received an RFE for whom I filed versus the individuals who had comparable profiles, right, that we filed and got approved, that was the difference. Those 1 to 2 letters of recommendations from renowned industry experts is what pushed those approvals over the edge, even though the profiles were similar, right? Didn't matter if it was a product manager, didn't matter if it was a software engineer, but that is something I'm seeing is really helping to set people apart, is having those strong letters of recommendations for your original business contributions criteria. For software engineers, it's very similar, right? We still need to prove that your work is critical at an organizational level. We still need to prove that the work you're doing and it's innovative, right? And you can do that in separate ways. Some clients of mine, they have patents. Some of them have papers, research papers or conference papers associated with those projects. Some of them have open source work, right, that they can point to and say, hey, the work I've done is laying the foundation for other developers to build on top of it, right? I sometimes have clients who come in who have done code reviews, right? Technical reviews out in the industry. I've had clients who will maybe go to freecodecamp.org and they will write blog posts about best practices, for example, in C++ programming, right? So there's different ways that you can come at the criteria that are kind of outside the box of just your traditional research, academic, PhD background. So that was kind of the TLDR of that answer.
Thank you so much, Prashant. I mean, that was pretty detailed and what we really need. Thank you so much for walking us through all these highlights that we really need to keep in mind. And at this moment, Prashant, we've got some friends who've joined us and who are commenting. So I'll just quickly say hi to them. It's my channel says, good morning, Prashant. And then we have Kavya's questions. We have Amarjeet. Folks out there, please stay with us. We are going to touch up on your questions very, very soon. And yeah, thank you so much. Okay, Amarjeet. No, okay. Let's head on with our questions. I have one more question for you, Prashant, and that is, what level of professional achievement or recognition is generally required for software engineers and product managers to be considered for EB1A eligibility?
Yeah. And this is kind of a sliding scales question, right? And what I mean by that is in terms of what qualifies somebody from a recognition perspective can mean many, many different things, right? Recognition can be somebody that has multiple papers and research articles published. It can be somebody that has multiple conference papers, multiple blog posts. It can be somebody that has a very robust GitHub repository, for example, somebody that is very much involved in the Android developer community, for example. And recognition can also be thought leadership. And I like to call thought leadership basically like your speaking engagements, right? I do have clients who are invited to speak to DroidCon, right? Or they are invited to speak to at AWS reInvent. These really big industry conferences. Cisco Live is another one of them, right? So recognition can take many different forms. Recognition can also be how is your work being adapted in the industry? So if you don't have patents, that's fine. But if you have somebody that is talking about how they've taken, your technical work learnings from you and adapted it in their own workplace or in their own organization, all of a sudden that becomes very impactful, right? But I always recommend, like, if you want to get recognition in the field, think about in your industry, what podcasts can you be a part of, right? And for product managers, there are multiple podcasts. There's some at the product school. There's one called Exponent. There's a podcast that's done by an individual over at University of Washington. You can participate in those sorts of avenues, if you're a product manager, to really get your thought leadership and your recognition out there, right? And that will help you from a final merits perspective. If you're typically, what I see my developers, what they've done is they're typically speaking at these industry conferences, or even academic conferences about the work that they've done, right? And that will help you build your thought leadership, right? And the type of conference you present at is going to depend on your profile. For example, I had an Android developer who presented at DroidCon, right? I had a machine learning engineering manager from Pinterest who presented at AWS reInvent because he built their machine learning platform in partnership with AWS, right? So it made sense that he was presenting there. In addition to that, he had about 3 or 4 other conference speaking engagements within his industry, within his specific line of work, right? So this is going to be very relevant and kind of particular to the makeup of what your EB1A profile is and the story that you're trying to tell, right? It doesn't make sense to go and present in a conference that's about graphics technologies, for example, if you don't work in that space, right? Or if you're a data engineering doing AI/ML work on recommendation systems, right? Has to be very relevant. You have to find those opportunities that make sense for your story.
Definitely, without any doubt. Thank you so much, Prashant. And, I would really like to take it's my channel's question for now. So let's go for it. 2 design patents, one IEEE paper publication, reviewed or judged 3 technical papers. Can I still qualify in the expert category, or what is your suggestion to make this profile more stronger? And what are
Yeah.
the areas that I can add?
Yeah. So I think with the design patents, right, we would need to learn hey, do you have any citations associated with them, right? That's going to be important. Same with your IEEE paper. If you have 2 patents and 1 paper, but you have 50, 60, 70, 100 citations, that shows that it's very impactful work, right? So your next step should be the people that have cited your work, cited your patent, cited your papers, identify the individuals that are, really renowned. And what I mean by that, are they academic experts? Is somebody there who has, cited your paper that has over 1,000 citations on Google Scholar, or has a lot of media attention, for example, for the work he's done? And can you potentially get a letter of recommendation signed from that individual, right? I think reviewing and judging 3 technical papers, that's fine. I would always urge you to do more, right? Because, I'm seeing my clients and they're reviewing 30, 40, 50 conference papers, right? So if you think about it, that is who you're going up against, right? So I would say do as much as you can when it comes to the technical review work in as many prestigious conferences as possible. And you can very easily find the prestige of a conference by going to research.com, right? And searching, for example, within the field of computer science, what the ranking is. If they're not even on research.com, you should seriously consider whether it's worth pursuing that opportunity. In addition to that, one more thing I want to mention, don't be disheartened by the fact that you only have a couple of patents, right? Because I had a CRM engineer from Salesforce, 1 patent, 4 citations. That was it, right? But what we went and did was we drafted a letter of recommendation from an individual that cited to his patent, that talked about how they took inspiration from his patent and the work that he did, right? So if you can get a letter of recommendation like that, obviously the patent proves that your work is original. We also need to prove that it's influential, right? And so that letter helped us show that his 1 patent was influential in the industry, and he did end up getting the EB1A approval. So not somebody that had a robust patent or research background, but somebody who was able to prove that the one thing he did in the way of a patent was influential. Somebody did take inspiration from it, right? So just something to think about in terms of how you build your profile moving forward.
Yes, very much. Thank you so much for highlighting that, Prashant. And I think it's very important to make your profile stronger and as attractive as possible, I think. So thank you
Yeah.
for that tip, Prashant. And thank you. It's my channel for participating. Please keep commenting if you have any further questions. And now I think we should take up another question, and this is from Kavya. Kavya is saying, my contributions are mostly collaborative, working as part of a team rather than leading solo efforts. Can I still qualify for EB1A? And does the process amount for team-based achievements, or do I need to show individual recognition? And there's
Yeah,
another
good
question,
question.
but we will take that later.
Yeah, good question. So no one is a one-man army, right? Like none of my clients have ever operated in a vacuum, right? Like you're either a software developer or a data engineer or a cybersecurity person or a product manager, but you're not everything, right? And so you have to keep in mind that what we tried to highlight in an EB1A is your specific contributions, your specific technical tasks, your specific original contributions or innovative contributions, right? Um, if you're an author on a paper, you might be a co-author, right? But that doesn't mean that you didn't contribute to it just because you were in a team-based or collaborative environment. 99% of the time, that is absolutely the case, right? And that's okay. But what we like to extract by way of letters of recommendations is your specific contribution to that project, right? And my job is to make it seem like you did everything, right? As your attorney, as somebody that's going to represent you, right? I'm not here to talk about what your team did, right? I'm here to talk about the impact you had, your specific technical contributions, and then connecting it to an organizational level impact, connecting it to any news publications, any media, anything of that sort that has, like the project you've worked on, if it's gotten that attention, then we leverage those as exhibits, right? And I'll give you an example here. I work with many clients from Meta's AR/VR team, right? Meta's Reality Labs team. You can find a lot of news publications out there about how, you know, Mark Zuckerberg has basically created like a 10-year roadmap or a 5-year roadmap for the Reality Labs team, how it's important to Meta's organizational goals and strategies, right? So automatically we know that if you're working on a project for AR/VR at Meta, it is organizationally important. It is important at a CEO level, right? And we've got news publications to prove that. If you are working specifically, let's say, within the wearable devices vertical of Reality Labs, right? I've had a client who does that. There's news publications out there, right, about the innovative nature of the wearable devices strategy that Meta has, right? So we automatically, can connect it to something that's newsworthy, talking about the fact that your work is innovative and also influential because it's going to impact the millions of customers that are buying the Quest headsets, right? So again, none of this happens in vacuum, right? But our job, my job, is to extract the specific details related to your specific contributions, connect them to those higher level organizational goals, connect them to those news publications that are talking about how this work is important at an industry level, right? So that's what I would say. Anybody can really qualify for the EB1A. We just need to highlight your specific contributions.
Right. And what about this last part of the question that she had, that Kavya had? How can I highlight my role and impact within a collaborative setting? Any tips?
Yeah. So what I do is I always send my clients a worksheet, right? So like we get on a consultation call, I learn a little bit about you. I either say you're ready to move forward or you have more work to do, right? I'm going to be very transparent about that because the last thing I want is a bad customer experience, right? I don't want you to think you qualify for something you very clearly don't, right? And in that worksheet, I extract those details, right? What were your specific contributions? What were your specific technical tasks? What was the organizational outcome that you were trying to achieve? And we draft letters of recommendations around that, right? Letters of recommendations can come from your managers, they can come from members of cross-functional teams, they can come from peers. If you work with end clients, right? So for example, I've had some clients who are management consultants, let's say at one of the big SI firms. You might get a letter from one of your end clients talking about the work that you've done and how it was impactful, right? So that's how we come at it. In addition to that, I find that my clients are very good at leveraging their performance reviews, right? So if we are talking about a specific project that you've worked on, more often than not, your work on that project is also being captured in a performance review. So we can add that as a layer of an exhibit stating, hey, here's this LOR saying what this person specifically did, how they are furthering these organizational or industry-wide outcomes. And oh, by the way, here's a performance review talking about, in addition, like all the stellar work that they did for this project, right? That becomes another objective piece of evidence.
Thank you so much, Prashant, for the detailed explanation for Kavya. And Kavya, I hope you've gotten all your answers. And we have It's My Channel back again saying, perfect. Thank you so much. And we have Dan Nandan saying his explanation is very clear and sounds like a radio personality for sure. I mean, really, Prashant, for sure. Very, very clear in how you explain. And now we have another question from It's My Channel asking, I would like to ask one more question on the memberships. Do you have any suggestions other than the IEEE or BCS?
Yeah. So here's the thing about memberships. If you don't have a research background, in the sense that if you're not doing journal papers, conference papers, you're not doing blog posts, you're not reviewing conference papers or journal publications, IEEE really doesn't make sense, right? And neither does IET. IET is another technology kind of research organization And both IEEE and IET only make sense for people if they have that research profile. Otherwise, it just looks like a check the box exercise. And when I see that with a client, I tell them, like, I'm not going to use this as a membership. You need to go do some review work, right? You need to go do some authorship. And that way your membership is going to look good, right? In terms of professional organizations, BCS is obviously the one that I see come across my desk most often. There are others, Royal Society of Arts being one of them. There's one called Sigma G or Sigma Chi, right? XI, that I also see my clients leverage. What I'll say is this: memberships is oftentimes one of the most difficult criteria. Membership and awards is two of the most difficult criteria to satisfy, right? So if you're going after it, just make sure that the organization you're going after fits your profile. If you don't have a research profile, don't do IEEE, don't do IET. If you have a professional profile and BCS might be taking too long, go and explore the Sigma Chi, go and explore, for example, Forbes Technology Council or Royal Society of Arts. That those will help you satisfy the membership requirements. And then high level, one of the things I want to say about memberships is USCIS really cares about the organization's bylaws. Okay. Bylaws are extremely important. Don't go and join an organization that has not memorialized their process into some sort of governance document or some form of bylaws that says this is the criteria that you need to satisfy the membership, right? These are the outstanding contributions we require of our members. In addition, take it one step further. Make sure the bylaws also discuss who qualifies to make those decisions about membership, right? That's very important. Some USCIS officers like to see those details. Where in the bylaws does it say this is the selection criteria? Where in the bylaws does it say these are the people that are going to be making those decisions, and these are the qualifications required for the membership committee, so to speak? And then the third one, what are the qualifications of that membership committee, right? So that information also then needs to be publicly available. So you want to be very careful with memberships because there's many pitfalls there, right? It's not just enough to go and get it. You need to be able to support your membership with bylaws and governance documents and all of those different pieces of information.
Thank you so much, Prashant, for taking that up. And we have some more questions. Let's take up Nirvana's question now. This is next on YouTube. Nirvana is asking, when talking of high salary criteria, how much we are talking of? Does officers go with what is mentioned in the LCA?
Okay. Level 1 to 4 wage means nothing to me in EB1A, and I think it means nothing to a USCIS officer, right? I have had clients who will try to argue with me that you should, include my salary criteria as criteria number 6 or 7, because it's a level 3 or a level 4 wage. It means nothing, right? There's no point of reference, right? And what I mean by that is there is better data out there. Bureau of Labor Statistics specifically talks about what the 90th percentile of software developers, product managers who can be qualified in the SOC code of marketing managers or IT project managers, depending on your role, data scientists, for example. All of the statistics are available on government wage databases, right? So Bureau of Labor Statistics, Career One Stop, ONET. I always start there. If you are not in the 90th percentile in one of those 3, salary is a no-go, right? Because on the USCIS policy manual for salary, those are the 3 that they list right off the bat. Like, this is the starting point, right? In addition to that, we provide commercial wage data. Glassdoor, Indeed, ZipRecruiter, Levels, PayScale, Salary.com, right? Those further substantiate the fact that from a commercial perspective, this person's in the top 10%, right? And they also have those sorts of point of references like top 10% ZipRecruiter actually takes it a step further and can even get as granular, I think, as like top 3%, which is great. Now, the third layer of exhibits we provide for salary, and this is something I had to learn over the last 5 to 6 months, because I was only doing that level 1 and level 2, which was the government wage data, the commercial wage data. I've now turned it up a notch with the level 3 wage data, in the sense, and I use level 3 very interchangeably here. I don't mean level 3 as like the LCA, but I use level 3 as in a third tier of exhibits that we're providing is related to professional organizations, right? So, for example, there are staffing agencies out there that are well reputed. Robert Half, for example, ranked as a top 5 staffing agency by Forbes. Mondo, ranked as one of the best IT search firms in the country. These organizations, they provide wage data based on their placements, right? So now I've been starting to provide professional organizational wage data as well to further substantiate the salary criteria. I don't care what's on the LCA, right? Like, baseline, you got to start with the government wage database first.
Thank you so
How
much for
much
that,
total?
Prashant. And yeah, and Nirvana is saying one more. I see a lot of PR agencies. Is it lawful to take help from them?
I laugh at this one because don't work with the PR agencies. I apologize to all the PR agencies out there, but um, the problem is they will get you posted on USA Today. They will get you posted on Tech Times. They'll get you posted on Tech Bullion, right? MSN, Benzinga, et cetera, et cetera. The problem is, after every article or at the beginning of every article, they put a disclaimer that's there that says, this is not the opinion of USA Today. And that's a problem, right? Because all of a sudden, we're arguing on the publications about you criteria, and it automatically gets discredited by the fact that USA Today is saying, hey, I didn't put this out into the world, right? Like somebody else did. You're going to have a world of a problem, very incremental value, right? So do not pay PR agencies to get you posted somewhere, because it will backfire, right? Like, those disclaimers are only going to hurt you, and they're everywhere, right? So save your money, spend your time elsewhere.
Okay. And what about, what he asked earlier? How much total criteria should be enough? Well, that is a question. And does too many of them pose threat of for RFE as well?
Yeah. So, like, here's my best practice, right? I like to go in with a minimum of 4, right? I never go in with just 3. I learned pretty early on going in with just 3 puts you at a disadvantage, because if USCIS RFE is one of them, right, you don't have much background, right? If you go in with at least 4, and let's say 3 of them are very strong, right, and one of them is 50-50 or a little weak, you still have a good chance of approval, right? 4 and above, your chances of approval, from what I've seen, go up significantly, right? In terms of having too many criteria, what I would say is, if you can comfortably argue on 6 or 7 because you qualify for them, do it, right? If you can put forth a reasonable argument for 6 or 7 criteria, that's totally, but don't try to do something underhanded, right? So, for example, don't try to make criteria number 6 or 7 salary when the government wage database clearly says you're not in the 90th percentile, right? Don't try to slip something past an officer from a criteria perspective, which is going to discredit the rest of your application, because then they're going to start thinking, oh, they're trying to convince me of something that, like, very clearly they don't qualify for. What else are they trying to convince me of, right? So I think the most I ever argued on was 7. And I even told the client, like, look, 2 of them are pretty weak, 5 of them are very strong, right? And I think those are the 5 that are going to carry you. at the end of the day, right? And they probably did because he ended up getting the approval. And you don't know which criteria you end up satisfying when it's an approval, but you know, I know pretty early on in terms of like which one's actually gonna resonate with USCIS and which ones are not, right? Argue for as many as you possibly can, as long as it's within reason, right? And as long as you can put forth a good argument.
Mm-hmm. Right. Thank you so much, Prashant. And those were really insightful tips and advices. Also, thank you so much, Nirvana. I hope that you've gotten most of all your questions answered. And if you have any more doubt, you can keep commenting. Well, it's my channel also said that that's a long list, but thank you, Prashant, he says. Anyway, I have a few more questions, Prashant. I think I'll share my screen for now so that we can take them up. I was telling you about some of our Facebook groups, so this will be easier. All right. So let's go with this first one. This is an anonymous participant asking, has anyone here worked with, I'm looking for filing my EB1A petition and would like some thought. Okay, not this, this one. Is the interview backlog different for EB2NIW and EB1A? Does anyone have any idea of which dates are scheduled for EB1A interviews at the Islamabad Embassy or Abu Dhabi Embassy?
Yeah. So what I can say, like at least speaking from the perspective for individuals within the US, because that tends to be 99% of my clientele, you don't have an interview for the EB1A or the EB2NIW, the EB2 or EB3, right? The only time I've ever seen employment-based petitions get an interview is if, let's say, somebody changes a job, for example, right? And the USCIS officer would like to verify that they are continuing to, let's say, work for that new employer, right? But none of my EB1A or EB2NIW clients have ever gotten an interview from within the US. Now, if you do consular processing and you're doing your interview from abroad, yes, the entire process of consular processing involves a visa interview with a visa officer, right? So it's slightly harder, I would say, when you're doing it from abroad. But in terms of specific timelines for those two embassies, would not be able to tell you.
All right. Thank you, Prashant, for taking that up. Now I have this next question. This is, please help on where to publish articles for EB1A or let me know which journals are eligible. Thanks in advance.
Yeah. So this is dependent on a couple different things. One is just your overall profile, right? Are you a software developer that's working within the Android ecosystem? Are you a data engineer working with AI/ML, right? Are you a developer working with AR/VR technologies, right? And graphics technologies? Are you a UX designer, right? Because the answer is going to change with each of those profiles, right? I recently had a data engineer who got approved for the EB1A just this week, actually. The articles he came to me with was published in an electrical engineering journal. And when we were working on his analysis and all of his exhibits, he called it out. He said, "Hey, you missed this article." And I was like, "I'm not going to include it. It's an electrical engineering journal, right? It has nothing to do with data engineering and the work you've done, right? And it breaks the continuity of your story." So what I would suggest is if you go to the IEEE website, right? IEEE has a list of conferences that they sponsor. Research those conferences, right? Type in the conference name, type in the word ranking. Research.com will tell you its ranking if it's ranked. Those are the types of conferences or journals that you want to be publishing in, right? The ones that are known, they're reputable, they have a peer review process, for example, right? That is what I would suggest. Now, let's say you feel the journal writing process, the conference paper writing process is very tedious. I've had clients tell me that. Totally fine. There are other avenues out there to satisfy the authorship criteria. For example, freecodecamp.org. Free Code Camp is a nonprofit organization, right? And they teach people how to code for free. And in order to even qualify to be a blog writer on Free Code Camp, you have to go through a vetting process. I think they only accept 30% of their applications. But the great thing about it is if you go to their LinkedIn page, 60, 70,000 people claim that they learned coding from Free Code Camp. And they will also help promote your blog posts, right? And your technical articles. That is another way to satisfy the authorship criteria, right? Doesn't have to be journals, doesn't have to be conference papers. You can get creative with it. I've had clients from Pinterest, from Meta, from Amazon, where these organizations have channels to publish technical blogs, right? And I've had clients participate in those technical blog process, and they're able to show me that, hey, these blogs are getting viewership, right? They reach out to those marketing teams internally, they find the viewership statistics, and we provide that as an exhibit to show that, hey, this person is authoring scholarly articles. It's just not in the traditional sense, right? But it is for individuals that might be, the intended audience is a data engineer, cybersecurity professional, whatever that might be, right? Another way to think about it is trade publications. So I have had folks in cybersecurity who do co-authorship with the Cloud Security Alliance, for example, right? So there's different ways to think than your traditional, journal papers, conference papers. But if that's the route you go, just be sure that those conference papers, those journals, those conferences and journals are like reputed, they're ranked on like research.com, for example.
Awesome. Thank you so much, Prashant, for giving us that insight. And now we have Vibhor asking, my company is 1 year old in Washington. Can I apply for L1A visa via road through Canada and I'm a Canadian citizen? I think the answer is yes. Once I get L1A approved, question is, can EB1C be processed quickly by paying money? And can I get green card within a year? Do you want to take this up? It's not EB1A.
I can answer the question totally fine. So with regards to EB1C and the EB1 categories, right? One of the things you want to keep in mind is the priority dates right now, I believe, are in 2022, right? So if you are coming on an L1A, right, as an executive, you can absolutely apply for your EB1C 1 year, let's say, after you enter the country, and you continue to maintain your managerial, executive capacity and executive duties, right? Or really whenever your company is ready to apply for it. So as long as in the previous 3 years, for one of those years you were employed abroad, let's say in Canada, you come back as an executive to the US, your company can apply for an EB1C for you. Okay. Now, if your priority date, let's say, is January 1st, 2025, just hypothetically speaking, right? If it's January 1st, 2025, in the EB1 category, you are probably not going to be eligible to get your green card within 1 year because your priority date is not, 2022 and before that, right? Or whatever it might be in the future. Chances are, if you get a priority date that is 2025, for example, you might be waiting 2 or 3 years before you can even apply for your 485 applications and get your green card, right? It's just how the priority dates work. In EB1 category right now, they are not current.
Thank you so much, Prashant, for taking that up. And I have one more question from one of our previous shows with you, EB1A, building a profile to qualify for EB1A category. And we had Arjun asking, saying that it was a very good session. And he had one question. How about the applicant had suitable criteria for EB1A 15 years ago, but now he is into different job sector and current situation is not suitable for the criteria? Can this still be a valid case for EB1A petition?
Yeah. So the thing about it is USCIS wants to see it over a sustained period of time, right? If you did something 15 years ago, let's say a whole lot of research, right? A whole lot of reviewing the work of others, but then there's a 15-year gap. One of the things that some very hardline USCIS officers like to see is that the work you did was over a sustained period of time, right? So critical and leading role over a sustained period of time, judging the work of others over a sustained period of time. If there's a significant gap like that of 15 years, I think that's going to be challenging for an EB1A, right? Unless, your authorship and judging the work of others criteria, which I'm just going to assume happened 15 years ago, right? For purposes of this question, um, if you have 3 or 4 other strong criteria and those two are kind of weak because they happened a decade and a half ago, I think you'll probably be okay. But if you only have 3 or 4 criteria and those are two of them, you're going to have a problem, right? I don't think that EB1A application would get approved.
Thank you so much, Prashant, for taking that up. And we had more questions, but I think we're good for now. I think I've taken up most of them. So we'll move back to our questions, Prashant, now. And I had this next question for you. So my next question is, what role does professional networking and peer testimonials play in an EB1A application? And are there any best practices for product managers and software engineers to secure strong endorsements? You've already highlighted some of how these testimonials or recommendations play a very important role. So if you could just tell us more about the endorsement part.
Yeah, absolutely. So I think there's a few different ways, right? So one way that I use endorsements is like sometimes my clients have LinkedIn recommendations, right? 10, 15, 20 LinkedIn recommendations. And I leverage that from a final merits perspective, right? So I'll give you an example. I have had clients who have participated in those thought leadership engagements, right? So they've been invited to speak at conferences, or maybe they've been invited to speak on podcasts. In addition to that, I highlight the fact that, hey, not only are they getting this industry recognition through these speaking engagements, but they're also recognized by their peers. Look at these LinkedIn recommendations accumulated, right? So I would say if you don't already have them, start thinking about, asking people for LinkedIn recommendations, right? Specifically related to the work you've done, specifically related to the capacity in which you interacted with them, right? It can only help you, certainly will not hurt you, okay? Another thing is, I would say, folks tend to burn bridges very quickly, right? So you leave a job, you kind of forget about your previous manager, you forget about your previous colleagues, and that's natural. It happens. One of the best individuals, one of my best clients that I've seen really do this well, he built relationships over the last decade. And he was able to go back to his manager, a couple of colleagues from his time when he was an intern at Meta from 2013, when Meta was called Facebook, right? He was able to go back to that time and get letters of recommendations from people from 2013. And it's because his relationship building and maintaining skills were just exceptional, right? So you want to make sure that you are doing them so that when the time is right, when the time comes, people that you have networked with, the people that you have worked with are willing to sign off on those letter of recommendations for you, as opposed to saying like, why are you coming back to me 10 years later, right? Build and maintain relationships, right? If there are think tanks, if there are organizations in your industry that attract the type of professional you are, get involved, volunteer, build those relationships, make sure they get to know you and you get to know them, right? Because at the end of the day, if you can build 1 or 2 of those relationships like that from renowned experts in the field, right? Those people that have the media publication, the media attention, the people that have the Google Scholar profiles that are very reputable and very much recognized, those become very powerful LORs for you. So build relationships, maintain relationships, at least for individuals that you identify can help you with your EB1A application later on.
For sure. Thank you so much, Prashant. And do you have any success stories or anything along these lines that you would like to share with us before we leave today?
Yeah. So I send out a monthly newsletter, and in that newsletter, I like to highlight. Nowadays, it's basically just all taken up by EB1A. But I like to highlight in those newsletters, some of the success stories that I've been seeing. And of course, it encourages other people, right? They see other people's profiles who are going through the EB1A process and they become encouraged themselves, for example, right? So I will share a couple of those success stories from this month. So this month, we've gotten 3 new approvals. Those have not gone out in my November newsletter because my newsletter goes out at the end of the month. One of them is a data engineer, right? And one of the things that he did in terms of satisfying criteria for awards, he had the Business Mint Awards and the Global Recognition Awards. I don't think that's one of the reasons why he got his EB1A, though. We also argued on critical and leading role. So he had implemented certain projects, for example, in the state of California, as it related to their electric metering system and modernizing that system, right? So not only was that project important for the organization that he worked for and that he was contracted out for, but it was also innovative and influential, right? Because it was impacting millions of customers in California. Mm-hmm. He had judging the work of others, right? So he had done conference paper reviews, journal reviews, in data engineering related conferences and publications. He also had authorship, right? So he had worked on papers that had accumulated over 170 citations over the last couple of years, right? Salary was not one that we argued on for him, right? So based on that profile, he got approved. I had a client from Meta who got approved this month. He is a AI ML engineer, and this individual was very notable in the sense that he had about 10 patents, I believe, 10 or 13 patents that had been cited over 100 times in the industry. He also had a couple of conference papers that kind of memorialized the work he was doing at Meta. And so for him, critical and leading role, yes, right? We were able to prove that the work he was doing was important at an organizational level, right? Because if you think about it, everything within Meta, is the engine behind it is recommendation systems. So the next reel that you see, the next post that you see, it's all recommendation systems. His patents helped with original business contributions. The letters of recommendations that we drafted for him were from professionals in the industry that had over 1,000 citations each, right? And we had 3 or 4 letters like that. He had salary, he had judging the work of others, he had authorship because of those conference papers, and also original scholarly contributions because those conference papers were well cited. So we argued on about 5 criteria for him, and he also went through the process just fine, right? So I think, to kind of like tie a neat little bow on it, you don't have to have a PhD. You don't need to be an academic to get an EB1A, right? And that individual who I just told you the story about, who had like the 10 or 13 patents, in our consultation call, he was like, I don't think I qualify. And I was like, no, I think you do, right? Like, I think you've been told that this is what a certain profile should be for the EB1A. I think you've been told that 100 citations don't qualify, right? But in fact, it does if we, build everything carefully. If we demonstrate your industry impact carefully, we demonstrate your organizational impact carefully, I think you're going to get this. And he did, right? So there's a lot of misconceptions out there about who qualifies for the EB1A, right? And it's really important to know that anyone can build a profile towards an EB1A. It might take you a little bit of time, but you can do it.
Thank you so much, Prashant. That was really very insightful. And thank you for sharing your I mean, on the other hand, it's also your success story. Your client success story is also your success story. So
Right.
definitely, it was really good to hear about that. So yeah, lovely having you, by the way. It's been a while, and it was such a great and insightful discussion today we had on the topic, can productive managers and software engineers qualify for EB1A? And it was great having your tips today. Prashant, do you have any end note before we wrap up? I mean, it was already great, but anything else you want to leave our audience with?
Yeah. I would say, my parting thought is, or thoughts. One, Nipasa, I told you we would only get through like four of our questions because I take five
It's
minutes
true.
to answer like each of them. But I'm glad we were able to answer more questions from the audience. I think the audience definitely found value from that. So thank you, audience, for asking. Thank you to the higher IT team, right, for hosting me, and making this a possibility. And also for anybody out there that's looking to explore the EB1A. I don't care if it's you coming to me or to another attorney, right? But don't be discouraged by the fact that you don't have a certain background, or you don't have a PhD, or you're not an academic, you're not a researcher, because I would say 50% of my clients are not, and they are still getting the EB1A. It just takes some time. It just takes the appropriate amount of preparation. And that's okay, because the EB1A, it's a marathon and it's not a race, right? You are going to save yourself decades of GC processing time if you can qualify yourself for this category.
For sure. Thank you so much, Prashant, really. And we highly recommend getting in touch with a qualified immigration attorney, and why not attorney Prashant Dubey as well. And you've got his email address, and his address is sorry, how to subscribe for the newsletter. Is there a URL? It's my channel is asking before we go. Yes.
No, but that gives me an idea. I think I should automate the subscription process, because right now I just manually enter everybody's email into the newsletter, and it like builds up my audience. So that gave me a great idea. Just email me, please, right? And
Yes.
I will make sure you get my November newsletter and all my newsletters moving forward.
Perfect. And you can email Prashant Dubey. His email address is info@dubeylawoffice.com. You can check out the spelling on the screen and note it down. Thank you so much, Prashant. Really lovely. And since we couldn't cover up most of our questions, we would really love you to join again. And even if not EB1A, we can have many other topics discuss. If that'll be fine. I'm hoping to have you visit us regularly again.
Yes, that's the idea. Thank you for having me.
Perfect. Thank you so much. Have a great day. Have a great weekend, Prashant.
All right, see you. Bye.
Bye bye. Thank you, friends. Thank you so much. And before we close, just a quick reminder that if you found today's episode helpful, please do not forget to like, share, and also subscribe to us. We are Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, Twitter. We're also there on Instagram. Check us out, and it'll be really lovely to have you join us. And your support helps us bring more expert discussions like these. So hit that bell icon as well, so that whenever we have webinars like these, you are notified and you can join us. And in case you have more questions on this topic, you can keep commenting, because we would love to get back to you. And of course, stay tuned to our channel, Immigration and Jobs Talk Show, because we have more webinars coming up today. In fact, in just an hour. And also at 4 p.m., we have Daily Immigration Dose, which I join with my co-host, Samriddhi, and it's going to be a great discussion today as well. We just started yesterday. I hope you enjoyed it, and I hope to see you later. So thank you so much for joining us today. Bye-bye for now. It's Nipasa Pradhan signing off from Immigration and Jobs Talk Show. Welcome back, everyone, to Immigration and Jobs Talk Show. Really good to have you all. And I'm Napasa Pradhan. I'm going to be your host. Before we go into today's topic and we welcome our guest, I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And once again, dearest friends out there, uh, good morning, good afternoon, or good evening, whatever time zone you have joined us from across the globe, I'm sure. And welcome everyone to Immigration and Jobs Talk Show. And today we are live not only on YouTube, but also LinkedIn and Facebook. And yes, I'm your host, Napasa Pradhan. I'm going to be with you for the next hour, and we are going to have a very informative session today with none other than our guest. So I'm very thrilled to introduce you once again to our special guest for today's webinar, none other than Attorney Chand Parvathaneni, the managing attorney at the law firm of Sim Parvathaneni and Brown, based in Dallas, Texas. Well, Chand brings a wealth of experience in immigration law and is here to shed light on a very important topic today. And before that, Chand, really good to have you. Thank you so much for joining us today once again.
Thank you, Nipasa, and thank you all for joining. I think hopefully, again, we'll have a very informative session that's going to help the community. And the goal of all these discussions is everybody should know the rules and the laws, so everybody is complying with the laws of the country. And doing so, they improve their career and contribute to the society in the end.
Absolutely. Absolutely. And today's topic is what are common immigration scams and how can you report them? Today it's going to be very interesting because we have been hearing so much in the news almost daily, even if not daily, then it is weekly, but it is very common and we get to hear so many different types of scams. So today we're going to discuss most of them, and I'm sure Chand is going to give some very interesting points out there to keep in mind as well. So I'm very excited for today's session. What about you, Chand? What can we expect from this session today?
Sure. So in general, most of the Indians that come to US, they typically come using employment-based visas, the non-immigrant H-1B visas, L-1 visas, student visas, or a lot of them get green cards using employment-based immigration. And what that means is most of the people are highly educated. In spite of that, in
Mhm.
spite of people being so highly educated, we always see people get scammed by people. So education sometimes
True.
is not enough because people, I mean, sometimes the way these scamsters scam people, they make it sound so real. So if people are not aware of what's going on, what kind of scams are happening out there, somebody might get
Mhm.
duped because most of the people want to follow the rules. So if somebody gets a phone call from somebody that says, "Hey, I'm a police officer," or "I'm somebody," people want to listen to the other side because they feel that the other side is a real person, a real government officer. But the scamsters, they use various means to impersonate the government officials, impersonate the police officers, impersonate
Yes.
immigration officials, and so on. And people sometimes, because it's a whole different country, coming from a different culture to a different culture, sometimes the expectations and way things happen, people perspective is different because there's scamsters everywhere in the world, and the scamsters here are a different kind. The scamsters in India are a different kind. So what that
Yes.
means is there is always a chance that if people are not aware of what's going on and know their rights, uh, they might be scammed. So the goal is at least to give some information. How do you know if you're getting scammed, and what do you do if you, unfortunately, in that situation where you get scammed? How do you get some recourse? Do you have to go to the FTC? Do you have to go to the USCIS? Do you have to go to the ICE? So there are many enforcement agencies and many organizations as a part of the criminal justice system out here. And hopefully, this discussion today will shed some light on what people should do to not get scammed. And unfortunately, if they are scammed, what do you do?
Yes, we are definitely going to touch upon as many different types of cases as possible and try to learn from all that is out there to teach us from, all these fraudulent activities that are going on around the globe and especially out here in United States. So definitely before we dive into this very critical discussion, I would really like to remind all you folks out there that this is an interactive session. So please feel free to drop your questions if you have any, especially regarding this topic, or maybe you have some experiences, or maybe you got scammed, and maybe you were almost scammed. Why not share those experiences and maybe ask your questions, and just drop your questions in the chat. We will do our best to address them here. And so, without further ado, let's get started. Chand, I have questions lined up for you too. So, let's have the first question.
Hmm.
What are some of the common immigration scams that people should be aware of, both in India and the United States?
So, when you're talking about immigration matters, the immigration scams, the scams because people are trying to go from one country to another country. So, there are specific scams that target these immigration scams. And most
Mhm.
commonly, what we talk about are the visa lottery schemes. And I'll talk about it. There is something called the green card lottery in US, and people use that green card lottery to scam other people. And there is something called notario fraud. It's a notary fraud. So what that does
Mhm.
is, we'll talk more about it. It's more about people acting like they're lawyers and cheating people. And we also see job offer scams. People who are trying to get on H-1B, getting scammed by fake consultancies or bad consultancies, charging people for H-1B. So we see a lot of job offer scams. We also see a lot of phone and email scams. So phone and email scams are where scammers impersonate officials of US immigration services. And we also see some family based immigration scams and so on. So first, we'll talk about the visa lottery scams. So in visa lottery scams, what happens is United States, US has a scheme called diversity visa lottery. So every year they take a green card lottery. So people who get enrolled in that lottery, and if they get selected in that lottery, they can actually get a green card. And however, the main thing to note is India is not a part of diversity visa lottery. There are some countries that are a part of diversity visa, and the reason for that is US as a country, we want diversity. So we're trying to have people from all over the world, and for that reason, what US does is countries that are not highly subscribed, say maybe a lot of African countries, a couple of European countries, etc., they're eligible to just go into the visa lottery, and if they're selected, they're eligible to get a green card. So a lot of people use that because if you Google online, you will see a lot of that information. So what people do is they act like they can get you more chances into the lottery, act like they can get you into the diversity visa lottery. And we've seen people where even if the country is not a part of the diversity visa lottery, they show some links online and make it look like you're eligible. So just
Mhm.
be careful. Diversity visa, which is the green card lottery, yes, it is real, but it is not available for Indian nationals. So one thing to keep in
Right.
mind. And another thing we see is notario fraud. So in a lot of foreign countries, what happens is attorneys also do the notary, and the
Mhm.
title notario is used in US. And so what they do is those people can actually do a notary, but that's about it. They can't act as a lawyer, they can't represent people. But these people act like they're lawyers. They give false immigration advice, they charge people. We have seen people where people got duped by them because they said, hey, you can get a green card if you do a filing certain way, and they cheat people. So remember,
Mhm.
there are a lot of false people who pose as legal professionals, or people who can do notary, but they might not be lawyers. And there are ways. So the way you avoid it is you can always find out if somebody is a lawyer or not. Every state has a state bar, and one can verify if somebody is a licensed lawyer or not. That should be public information. So always do not work with anybody who is engaging in unauthorized practice of law. If somebody is not a lawyer but
Mhm.
acts like a lawyer, there is a good chance that you might get duped, because a lot of immigrants require the help of lawyers. So just be careful that whoever you are working with is an actual lawyer, because if somebody dupes you into thinking that they're an attorney, they file some cases for you. You might be in
Mhm.
trouble down the line. I've had a case where somebody from India, he was told by somebody to claim asylum. So this person applied for asylum, and he thought the other person was a lawyer. So he believed whatever he said. And this guy applied for asylum. He paid a lot of money, I think almost $20,000. And this asylum application, I mean, it was all a made up application. And this guy assumed that it's a valid application, and he waited. And eventually, when he came to us, we found out that he was out of status for such a long time. So be careful. And if you're working with a lawyer who claims they can do something, always make sure that they're reputable lawyers. And not only that, they're licensed. Every lawyer, it's a licensed profession, which means if a lawyer is not licensed, they're not allowed to practice law. So be cautious about these fraudulent attorneys who are not really attorneys but claim they are attorneys. And one very important one is the job offer scams. So the job offer scams are nothing. So these people, uh, they target people abroad. I mean, I've seen a lot of people in India get targeted. Especially, we see this a lot happening during the H-1B lottery time. So there is no real job. They just spin up companies here, and the companies are fake companies. Maybe, I mean, they exist in reality. They are registered, but a company just getting registered does not mean it's a real company. But what we see is people show those companies, people target people abroad, maybe in India. And they say, hey, we have a H-1B filing that we are going to do for you because we have a job opportunity. There is no real job opportunity. And in the process, what they do is they ask for fees, maybe for, fees for paying H1, maybe upfront fees for processing, documentation, etc. And these people are targeting these highly qualified people. And these people think that, hey, we have a real job offer in US because we are qualified. And sometimes people fall for it and pay money for H1B processing, etc. And anytime somebody asks you money for any H1B processing or any visa processing charges, upfront something could be wrong. Okay, so because an employer cannot charge any processing fees for this job visas, especially the H1B visa, the L1, etc. So always do your research, and legitimate employers, they typically do not ask money for visa processing. So if anybody's asking you to pay for a H-1B filing, pay for visa processing, something is wrong. And that tells you that you're probably getting scammed, and probably you have to do some more research, maybe even make a formal complaint with USCIS or a US embassy and so on. And
So
I
true,
think
because
phone and email scams are something.
nobody can really speed up the process, really. I mean, no matter how much you pay anyone, what is there is there.
Yeah.
And yes, that's it. So Chandi was saying.
Yeah, I mean, sometimes people, I mean, speeding up a process is possible because, for example, for H1, there is something called
Yes,
premium processing. So legally,
premium process.
people can pay money and get the process speeded up. So legally, there is a way.
Right.
So, but again, people have to be cautious. At least they have to do some research, especially if they're asking them to pay some processing fees. Always do some research,
Right.
because some could be, the only thing that is legal is the premium processing fees. So the premium processing fees to speed up a H-1B case, that is the only fees that can be charged to the employee. But other than premium processing fees, pretty much there is no fees that the employee can be asked to pay. So anytime, in general, the general rule of thumb should be, if somebody is asking you to pay some money for visa processing or H-1B processing, take a step back, do your research, and more than likely it is not legal. And then some phone and email scams. We have seen so many times, so many people from India fall prey to this phone and email scams. They get a phone call. Somebody asks them to pay because they're in some trouble. They say they're a government official. And we'll talk more about these phone and email scams in today's session. But people can get phone calls, get scammed. People can get emails, look at some of the documents. The documents look real, and they can get scammed. So be extremely cautious about phone and email scams. We have seen people getting links to pay online, and they think that it is from their friend, and they get scammed. So phone and email scams are very common, and we have seen people lose thousands of dollars on these scams. I mean, they don't look like something that are like that easy, but I don't know how they do it. But we have seen so many people scammed. Our own clients get scammed with phone and email scams. So I think in general, I mean, the goal should be avoid these kind of scams. And what that means is always look at websites like USCIS or the consulate, which is Department of State, for accurate information. Don't rely on third-party websites. Typically, most of the information about immigration, at least in US, either Department of State or USCIS, most of the time they will have that information. And always verify the credentials. If you are working with any attorney, always verify the credentials. It's very easy. You can go online, you can check. Every state has a way to verify if an attorney is licensed in that state or not. And it's very easy, but people should take some time to verify the credentials. And always
Right.
be skeptical about any guarantees. Be wary of anyone promising guaranteed results. Uh, Immigration outcomes cannot be guaranteed. If an attorney is saying, hey, 100% I think your case is going to get approved, normally they don't say that unless there is like something really, really strong. Okay, I mean, nobody's going to guarantee a result. Okay, but again, facts of the case, they can tell you if your case is strong or weak. That being said, if somebody is saying, hey, pay this money and we will guarantee you this return, this outcome, definitely there's something wrong. You cannot pay any money to guarantee a result. Okay, that's very important. And scams, if you think something is wrong, you're getting scammed, report it to the authorities. I know sometimes, a lot of times, it's the cultural difference. Somebody's coming from a different country to US, at least initially. I mean, people take time to adjust. A lot of times, people are victims of a crime, but they are hesitant to go out and complain. So if you are ever a victim of any crime, whether it's physical violence, if it is scamming, internet scamming, email scamming, phone scamming, any kind of something that you feel you're a victim of something, there is a very good criminal justice system out here. You might be able to complain it to the law enforcement in US. You might be able to complain to the Federal Trade Commission, depending on whether it's an internet crime. And sometimes you might even be able to complain it to the law enforcement in India if you're getting scammed by somebody who's got ties in India and something is happening. So always remember that if you are a victim, there is nothing to be scared. Always look for getting help from the law enforcement agencies and stay educated. I think doing so, I think, is going to protect everybody from falling victim to various scams in either United States or even in India, or maybe both.
True. True. So, friends, I think you should always be careful, especially, if you feel skeptical about payments or somebody on a call or email asking for more personal details, stuff like that. So, be more cautious and do your research properly and try never to, fall prey into any sort of scams for that matter. So, I think we are going to dive deeper. So, let's move on to the next question that I have for you, Chand. And if you could tell us, how individuals can protect themselves from falling victim to scams that exploit ignorance about immigration systems, law, and even cultural norms.
Sure. So, in order to protect oneself and from scams, these scams typically exploit ignorance about immigration systems. They exploit ignorance about the laws and the differences in cultural norms. They use this, they exploit them. And what people should do is you should take proactive measures. So you should always assume that there are so many bad people out there and who could scam you. So always be proactive and always strategize yourself. The first way is education. I mean, you have to educate yourself that in US, the United States Citizenship and Immigration Services, USCIS, they deal with immigration. So they have a very good website. They have so many useful articles. They have pretty much every information you can get about the visas, about the green cards, and so on. So that should be your primary source of legal information, source of your immigration law. So it is USCIS. And then we also have the consulates, which come under Department of State, and they have their own websites. So everybody should be aware of the USCIS websites and the DOS, Department of State's website. And most of the immigration questions regarding the law, you will find an answer in these websites, in these two websites. So educating yourself and knowing where to reach out, that's pretty important. And then everybody should familiarize yourself with the process. So familiarity is basically saying, hey, if you are on a H-1B visa, you can't stay forever on a H-1B visa. There is a limit of 6 years on H-1B visa. So you have to actually do something, which is basically get a green card filing sponsorship. So that has to happen. And a lot of people, unfortunately, they don't familiarize themselves with immigration systems. So we see a lot of people, they come to us in the fifth year of their H1, and they realize that they can't stay in the country after 6 years. So they are out of luck. So everybody should know what the visa categories out there for them, what kind of application procedures are out there, what kind of timelines. Because if you have to find a H1B extension, you need to know what kind of timelines you're looking at. So by educating yourself and knowing everything about the process, at least the high level process, you'll not let people scam you. Somebody cannot come and say, hey, you have to pay so much for your H1B. Or we have a lot of cases where there's scamming companies, even employers, bad employers who indulge in human trafficking. They don't pay their employees on time. So by understanding the legal processes, knowing the laws, you at least know what to do if whether you're a victim of a crime or not. I mean, we have a lot of cases where people are not paid on H1B, and these people think, hey, I'm not on a project, so my employer is not paying me, but I can't really force my employer to pay me because I'm not on a project. So people don't even know. I mean, sometimes people don't know the law. Even if you're not on a project, benching is illegal. And what that means is, as an employer, the employer is still supposed to pay you, even if you're not on a project. So sometimes knowing the law will let you know if you're a victim or not, because we hear from a lot of people who think they're not a victim. They think it is just a part of the process why they're not paid because they're on the bench. So know the law, and that way don't let employers exploit you or exploit the laws of US. So it's very important. And also always verify the credentials. So if you have a legal problem, you're going to some attorney, verify their credentials. And the same thing, I mean, if you are ever in any legal issue or need some legal help, don't just go to anybody that claims that they know the law, or they act like they're practicing the law. There is a way to check, and you should be able to verify the credentials from the state bar associations, and ensure you take help only from licensed attorneys. If somebody is not a licensed attorney, they cannot give you legal advice. Okay, so just be cautious about it. And the way I see it is, anybody that is licensed and practices immigration law typically will know what's going on. At least they'll be able to point out if they're not able to help. So always look for that. And uh, always be aware of anybody asking you for upfront fees. Legitimate services don't typically require large upfront payments. Okay, so if somebody, you're trying to ask for some application assistance, maybe you're going to an attorney for some assistance, if they're quoting you a big fee, I mean, again, always what you should do is you should at least get some second opinions. You should talk to multiple law firms if you feel that somebody is charging you a lot. Okay, because everybody's pricing is different. Uh, but again, from your perspective, if you ever think that somebody is asking you to pay something upfront, a very high amount, you should at least look around, talk to your friends, talk to other attorneys to make sure the fee is legitimate and somebody is not charging you more than what they should. And not only that, non-attorneys like employers or somebody out in the society, if somebody is asking you to pay some fees to do some immigration work for you and charging you, uh, be cautious and just see what's going on. And always use secure communication. And what that means is, just make sure, um, I mean, if you're making any payments and somebody sent you an email with some account numbers or anything, just be cautious. Make sure you're not being sent. I mean, uh, what some people do is they spoof email accounts. They make it sound like they're coming from legitimate emails, and this with this kind of spoofing and phishing going on, they make you pay because you assume that you're probably paying the right money to something. Maybe they're saying, "Hey, this is your apartment rent. This is the link to pay." Make it sound like it's your apartment rental company, and maybe the email, they make it sound like it's your apartment rental company, but it's probably not. It's probably some scamster. So if you see anything suspicious and things out of the normal, always be suspicious. Always I mean, anytime you're making any payment, always be cautious. Use the good practices, and always know whom to seek support from. So there are many community organizations. I mean, whether you're a victim of some crime or you're scammed, you're a victim of some domestic violence, there are many community organizations that assist. And so you should always know what community organizations assist. There are Catholic charities, and there are many organizations for victims of domestic violence, and there is so many things happening. So always know the community organizations, and proactively know who's out there in your local city and so on. And always protect your personal information. And the final thing is always report scams. So if you're ever scammed, report. If you don't report and you think it's a small dollar amount, so you're leaving it, what's going to happen is these scamsters are going to target somebody else. So always report scams. And by reporting scams, you'll help everybody else involved, and know whom to report, and always report these scams. And doing so, I think we believe that you can protect yourself from falling a victim to all these scams out there.
So true, so true. So, friends, I think the main way out is knowledge, learning, wisdom. So, the more you know about all this, the more you can save yourself, or at least you can know your way out, whether you're getting scammed or whether it's true, whatever the other person is telling you. So, find out and stay safe. All right. Now moving on to another question that we have for you. But I think, Chand, I'll just greet our audience out there. Thank you so much for joining us and also for your questions. We are definitely going to take each one of yours, so stay with us. Sagar, Avinash, Rahul, Ishwar, Anjali, Mehta, thank you so much for all of your questions. And absolutely, we will take one. But I think, Chand, let's move on with the next question that I have for you. What steps should someone take immediately, if they suspect that they are a victim of an immigration scam?
So if you suspect that somebody is trying to scam you, I think definitely, I think stop all interactions with them and cease communications, and log all their emails or messages or phone calls that you think they called from. So once you document, stop communications and gather this information. And if you think it has something to do with because if you think somebody probably breached your account, and because we have seen cases where somebody's email, people went into their email, they saw their friends, their contact list, and they sent emails spoofing their friends email addresses. So if you think that something of that sort is happening, always change your passwords, especially for your online accounts, for your banks and so on. And the next biggest thing is reporting. Okay, so anyway, I think everybody that suspects they're getting scammed will do these things, changing passwords and reporting to the bank, monitoring accounts. The biggest thing I think everybody should do is reporting the scam. How do you report scams? So in US, if it is an internet, if it is a scam, if it is some kind of a fraud or fraudulent activity or a scam that's happening, the first place that I think you should file a report is FTC. FTC stands for Federal Trade Commission, and the website is ftc.gov. So there is something called reportfraud.ftc.gov, or you can just like Google FTC, Federal Trade Commission fraud reporting. You'll see a link come up. So that is the first place I think everybody should report if they suspect fraud, and it will help the federal authorities to track and prevent scams. So FTC is a very famous website for reporting fraud. So always remember FTC, and that should be the first place. And if you are getting scammed over the internet, maybe somebody is making you pay some money to them over internet. So there is another thing called IC3. It's an Internet Crime Complaint Center in US. The website is ic3.gov. Most of the government websites end with .gov. That's how you know it's a legitimate government website. So ic3.gov is typically used for white collar crime or internet crime. So it's a very, very good website. So and even FBI also kind of uses ic3.gov. So definitely, if you have any internet crime, use Internet Crime Complaint Center at ic3.gov. That's a good place to complain. And local law enforcement. So when you talk about local law enforcement, we're talking about the local police in your city. And always, you also probably should call the police department, or maybe go to their office and also talk to the police department. Because worst case, if they're not handling it because it's a federal crime or something under federal jurisdiction, they will at least tell you. So always, I think you should also go to the local police department. And the local police department, depending on the crime, sometimes they'll be able to act on it, and sometimes at least they will guide you and tell you what to do as the next steps. And if it's a pure immigration kind of a scam, immigration fraud, maybe your employer is scamming you, employer is charging you money, employer is not paying you on time. For those kind of USCIS scams, there is this website on USCIS. So USCIS website is uscis.gov. And if you just Google scams fraud USCIS, you'll see a link pop up. So report on the scams fraud link at USCIS website, and anything to do with immigration. Somebody is doing some kind of an immigration fraud, always report it to USCIS. Okay, and once you do that, always if you think, depending on the kind of money you're looking at, kind of scamming that has happened, always reach out to the attorney or at least to legal aid organizations in your local city. Because if you don't have money for an attorney, legal aid organizations, they will help you. They will help you for free, and you should definitely talk to some legal aid organizations in your local city. And so I think that is what you have to do. And our thing is, always, if you don't report scams, if you don't report fraud, what's going to happen is these people will become more braver. So just know these links that I told you: FTC is one, IC3 is one, USCIS is one, and these three are very, very critical. That I think everybody should report if they are scammed. And then your local police. Okay, depending on the kind of a crime, always your local police is also your best friend.
Absolutely. Thank you so much for guiding us through this. I mean, very important thing to keep in mind, because we sometimes panic, and when we get panic, especially when we fall prey into these kind of fraudulent activities, we get scared, and sometimes we are scared to tell our loved ones also. But I think it's best to just go report them. And I hope you took notes, by the way, friends, because Chand had some important tips and notes to give out there. But even if not, I mean, this webinar is going to be published as soon as the streaming is over, so you can always listen to it and note down the details. Thank you so much, Chand. And definitely, friends, we will take up your questions. Sagar, Avinash, thank you. And also Chaitanya, we will take up your questions, but please stay with us. It's actually time for a short break now. So stay tuned. We will return and we'll continue our conversation with none other than Attorney Chant Parvathaneni, and about how you can protect yourself and your loved ones from immigration scams. We'll be right back on Immigration and Jobs Talk Show. Don't go anywhere.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, friends, to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, your host for today. And today we are discussing, how you can save yourself from scams and also your loved ones. What are the common immigration scams and how can you report them, with none other than Attorney Chant Parvathaneni. This is the second half, so welcome back, friends. And if you want to also contact Attorney Chant Parvathaneni directly, we have his contact details. It keeps scrolling on the screen, but also you can note it down right now. It's 817-523-8247. Once again, I repeat, 817-523-8247. And you can email him, and his email address is law@spblawfirm.com. And also go check out the website spblawfirm.com to get to know more about the law firm and also Chant Parvathaneni. Chan, thank you so much. It's been so far so good, insightful, informative, and interesting. So I think we should take a question from the audience right now.
Yes.
Let's take up Chaitanya. Hello. If an employer commit to file perm during working period, but if they don't, will it be considered a scam?
Um, so, uh, so when we talk about scam, I think scam is a little different. It's more on the criminal side. So, in US, what happens is people make promises, and sometimes those promises could be binding. When the promise rises to the level of being a binding promise because it meets the definition of a contract, it's a contract. So, if the employee and the employer they entered into some kind of an agreement where the employer promised to file the perm in return for something, maybe in return for the employee working for them. I think what would happen is if the employer breaches a contract, it's more of a civil kind of a case. It's a civil issue where it is not a criminal issue, but more employee broke the promise kind of a thing. So the employer broke the promise kind of a thing. The recourse is probably you have to go to the civil uh, courts and maybe fight for breach of contract, maybe fight for damages because of breach of contract. Again, there is no guarantee that somebody might win because the employer is not really obligated. I mean, they don't really have to file a perm, but again, you can't really enter into a contract with somebody and not honor it. So depending on what kind of evidence they have and what kind of maybe a written agreement or something of that sort, it is more of a civil case, but not of a scam. Scam is where people get defrauded, and it's a little different. Okay, but again, definitely, I mean, if somebody entered into a contract and broke it, there is recourse, but that's on the civil side, not really on the criminal side.
Okay. Thank you so much, Chan, for that answer. And Chaitanya, I hope that was pretty clear. Thank you. And if you have any further questions, you can keep dropping them in the comments. Let's take up this next one. This is on Facebook from Rahul Kumar. In the very first step for H-1B visa, how to identify the geniusness of selection notice. What all red flags can be checked over the selection notice as the applicant can't verify the same at their end?
Right. So I think we had a couple of questions even at our law firm because some people just call us and say, "Hey, my employer gave me this selection notice. How do I know if it is genuine or not? Is it fraud or anything?" And my thing is, unfortunately, you can't type in that number anywhere and find out if it is a real number or not. That being said, no employer will typically give them a fraudulent document. Tampering with any federal document, like a selection notice. Selection notice is a government issued document. If somebody tampers with the document, changes the name of one person to another person, and gives somebody a fake document, they will have criminal implications because that's a big issue. If anybody is uh, tampering and doing some kind of changes to a government issued document. So in general, it is very rare that some employer will give them a selection notice that is fraudulent. But unfortunately, I mean, again, the employee cannot check whether it's genuine or not unless you get on a Zoom call with the employer and maybe ask him to log into the USCIS portal right in front of you and show it to you. But otherwise, I mean, just looking at the document, I mean, you just have to assume it is true and genuine. But for some reason, you eventually find out that there is some kind of uh, uh, tampering with the document and they changed something, they altered the document. To me, I mean, that probably would arise to the a standard where you're probably scammed by somebody by altering a government document, and you might be able to report it, and then probably you might be able to have recourse. So, I mean, it is pretty rare. I mean, people don't do those kinds of stuff. Not that I've not seen people do that. But again, it's very rare. But if somebody is so foolish enough to alter a government issued document, there are criminal implications for that act.
Thank you so much for making that very clear. And yes, the how to identify the genuineness of selection notice. Thank you so much, Rahul, for your question as well. Um, Chand, let's take another one quickly. This is on YouTube. This is from Sagar. Okay, Vishnu Vardhan. Let's take this one first. Hello, Chand. I work full time for a company and I got my H-1B for the same company in the US. I am seeing the experience on H-1B and found the following question. Detailed description of project and services or engagements with client projects. VO returned my passport. Oh, I work.
Okay. So I think, hmm?
Yeah,
Yeah.
that's it.
So I think what has happened is Vishnu is working in India for the company, and this their office in US sponsored his H-1B. He got his probably got his H-1B approved because he's going for a visa, and looks like the visa officer returned his passport back, did not do the stamping. So my guess, what
Mhm,
happened is he got a 221G. Vishnu probably got a 221G, and I think what the visa officer is going to do is he's going to initiate a background check, and the Department of State, they're going to do some background checks, maybe contact the company in US, verify the information, and at a certain point down the line they will ask for a passport to issue the visa stamp if everything checks out, if they pass all the background checks. So
mhm.
what more than likely happened is your case is refused. It's not denied. Your visa is refused for now. And once all the checks are completed, at that point of time, you might expect a call from the consulate asking you to drop your passport. And at that point of time, you'll be able to get a, a visa. But I think
Mhm.
you have to probably wait for some time because the consulate is going to do all these background checks, maybe get in touch with the company in US. And down the line, you can expect a request from the consulate and get a stamp on your passport.
Okay. All the best, Vishnu. Thank you so much for your question as well. And thank you, Chant, for taking that up. Okay, let's move to Sagar's question now, quickly. This is on YouTube. Hi. Hi. Can H4 holder work in US? I heard news that court gave permission to work. Is this valid news? If yes, should we need to file petition again for H4?
So the rule is the H4 holders by themselves cannot work. The H4 holder should have their H1B spouse get an I-140 approval. So this rule is again the old rule. So the new rule, what I think you've heard in the news lately, it is just them saying that the old rule still stays. So the old rule is to file to for the H1 for the H4 holder to work in US, you need to file for something called H4 EAD, and as a part of it you have to show that your spouse has an I-140 approval. So if your spouse has an I-140 approval, you have to actually apply for the I-765 EAD card, and only then after it's approved you can work. So just a H4 holder by them, I mean, they cannot just by the H4 status you cannot start working. You actually have to apply for EAD card, you actually have to have your spouse's I-140 approval, and only then you should be able to work.
Okay. Okay. Thank you so much, Chant, for taking that up. And I think now we will quickly move back to our questions, some of which I have for you too. So, okay, there was a follow up actually from Vishnu Vardhan saying, if you get laid off before H-1B stamp, what are my options? And since I don't have my H-1B visa stamp, will my current I-797B become invalid?
So if you get laid off, what will happen is you cannot get a visa because you'll not be eligible to get the visa. But what will happen, because even if you get the visa, you can't really come to US, because when you at the port of entry they will block you because you have to show employment when you come into the country. But what you can do is, if you get laid off, you have to find a new employer. The new employer has to file a H-1B. And when the new employer
Mhm.
files a H-1B, because you had approval in the past, you're cap exempt. So the new employer,
Yes.
once they have that approval copy, you can either go for stamping if you have not received stamping. And if you have received stamping,
Mhm.
you can use the old visa, the old stamping with the old employer's name, but you have to carry the new H-1B approval. And at the port of entry, you have to prove that the day you get down the plane and you go into the country, you are actually going to work for that company. So if you get laid off, normally what happens is you're stuck until you find a new employer. The new employer files a
Mhm.
H-1B petition. Once that gets approved, you should be able to travel. Okay, the good thing is at least you don't have to go through the lottery again, but you definitely have to have a new employer before you can
Okay.
come into the country.
Okay. all the best, Vishnu. I think you are sure going to figure out. And also Rahul Kumar, whose question we just took up on Facebook, also has another follow up. I think we should just take that too. Um, w- why this has been asked, because the identification of letters over the selection notice is being compared with other selection notice, and the barcode number is not matching with the BCN. In my understanding, BCN must be matching with the barcode number. Please correct me if that is not true.
I'm not sure. I mean, I've not really reviewed the selection notices that closely. But again, if it's a
Mhm.
doubt that you have, just like check with the employer and put it in writing. I mean, anytime you suspect something is wrong, what we always recommend is don't call them on the phone and say something. Just document it in the email, because if something is wrong tomorrow, you have documentation. So just document it,
Right.
ask them what's going on, and ask them, because the employer really wants to prove it to you, they can just get on a Zoom call, just log into the my USCIS portal right in front of you, and show it to you.
Exactly.
Uh, but again, I mean, to me, I mean, somebody is really foolish to tamper with those selection notices. So it's rare people do that. But I mean, if you really think that something is wrong, call them. Just simply, I mean, in 5 minutes in a Zoom call, they can log into my USCIS and right in front of you and show it to you.
There you go, Rahul. You at least know how to go about this. So, all the best. All right. So, I think we should take up more questions. Yeah, let's take Deepak. Deepak is also asking on YouTube. I am an international student in the US, and I recently discovered that my university is not accredited by the relevant authorities. Is this a scam? Can I transfer my SEVIS record to a different university? And what implications might this have on my immigration status?
So it's probably not a scam, because if the university informed you that it is an accredited school, then it is probably a scam. But if the university never told you it is an accredited school, and you just assumed it's an accredited school, it's not really a scam. And the reason for that is the data is it's public data. You can actually go and check if the school is accredited or not. We have a lot of people who graduate from schools which are not accredited on F1 visa, and what that means is they cannot really use the degree later on. So technically tomorrow we can't use that degree from an unaccredited school for immigration, because we had a lot of cases where people went to schools that are not accredited, or down the line they lost accreditation. So I mean, all that means is that degree is not useful to you, so you should definitely transfer your service. So check with
Mhm.
a school that interests you. Check with the school DSO, and normally what they will do is, if your service is active, they should be able to transfer you to that school. So I would
Mhm.
definitely recommend you transferring to a new school as soon as possible. And what that means is you're working with a new school, get your admission and get your I-20. Make sure the school DSO transfers your service record, and as long as your service record is active, they should be able to transfer you.
All right. All the best, Deepak, and I hope you figure out. All right, Chand, there was this recent case which we all must have heard on the news about this Indian student, this 19-year-old who managed to, um, well, get a full scholarship to Lehigh University. So, if you could also get a chance to go through maybe the case or heard of it, if you could tell us, what are your thoughts on the legal and ethical implications of such fraudulent activities, and how can institutions and authorities better prevent and address these kinds of issues?
Sure. So everything we talked about so far was immigrants getting scammed. So you're talking about how people from other
Right,
countries were getting scammed. So this case, it's a case where the university got scammed. The university here
right.
and the institute here, they got scammed by an immigrant, by a non-immigrant. So what happened is, this kid from India. So he created all these fake documents, fake tax documents, fake death certificate about
Right.
his dad, and fake
Yes.
mark certificates. He even created a fake email address for his school back in India,
Yes.
and he applied for scholarship.
Impersonating. Yeah.
Yeah, and I think his goal was to prove that he is a student that uh, is a very highly qualified student. So he showed all his school records to prove that he's a very high quality student. 12th grade student. I mean, he did this in 11th, 12th grade back in India. So he showed all his 11th and 12th grade records, school records, to this US university, Lehigh University in Pennsylvania. And the university thought he's a very, very bright student. And
Yes.
they looked at his dad's death certificate, his financial data. They felt that this is a kid that's in hardship. He's a very talented kid, but he doesn't really have the resources to pay. So they offered him a good scholarship and everything. And this kid came from India to US to study. And what this kid
Yes.
did is he went into Reddit, and in Reddit he started writing some messages, and
Yes.
anonymously, of course. So anonymously, he wrote a message and said, "Hey, this is how I scammed the U.S. system, and this is how I got my scholarship by making all these fraudulent documents." And
Right.
Reddit, what they did is the minute they saw his messages, the moderators got aware. They did some background check, and they saw that this kid also follows the Lehigh University posts. So they didn't know
Mm.
because he was anonymous, but they at least informed Lehigh University and said, "Do you have anybody that fits this profile?" And
Mm-hmm.
so eventually, I think they started doing more investigation, and this happened very recently. They finally
Mm-hmm.
found who this kid is, because they did find that some kid who fits this profile, father is dead, doesn't make a lot of money, getting scholarship, so all that profile fit.
Yes.
They eventually found who this kid is, and eventually that kid was caught. He agreed because he didn't have a choice. He's getting deported back. He's been charged with
Yes.
some criminal charges. And what that means is scamsters can be from both sides. There are scamsters in US, there are scamsters in India. So it's never that it's
Yes.
always immigrants who get scammed. There are bad people everywhere. And that's what happened.
Mm-hmm.
In this case, the US university, the US system got scammed. And if not for the guy actually going on to Reddit and proclaiming his things, maybe he would have not
Mm-hmm.
got caught. And maybe the US would have been a victim of his crime. So the bottom line is there are bad people everywhere, and people have to report it. If you see scams, you have to report it. That is the only way to stop other people from doing more scams.
Exactly. Exactly. You have to report it. You have to stop it, and only then people will also learn from whatever is being recorded and reported. So yes, actions will always be taken. Moving on, Chand, I have more questions for you. If you can tell us about, since we've been speaking a lot about the scams, and if you can actually tell us how can individuals verify, the authenticity of someone claiming to be from the USCIS? Are there specific steps or contacts they should use? I mean, you told us about the real websites, but also more if you can add anything.
Yeah. So we have had this a lot of times, and sometimes it is genuine. We have people calling and saying they're USCIS officers. We have
Mhm.
just yesterday evening, I had a call where this officer from the airport, the CBP officer, he called this company, and the company was like, they just thought it was a prank call, and they just shouted at this officer and just like hung up. And later on, they realized and they called him back. So sometimes you might get a call from a USCIS officer, you might get a call from a CBP officer, and sometimes it's a fake call. And so that's why it is very important that you really know how to find out if the call is really coming from a USCIS officer or not. And thing is, sometimes they ask personal information, even the genuine calls. So sometimes you're worried: is it really a real government officer, or is it really a fraudster? Um, and the times USCIS officer calls somebody is they want to make sure somebody is working as required under H-1B. They're getting paid as required. So sometimes it does happen that USCIS officer will call you, and a CBP officer also might call you. So people, what I think you should do is, if somebody is threatening you on the phone, being very unprofessional, they're asking for some financial information, they're asking you for payments, more than likely that is a scam. If it's a real USCIS officer, if it's a real CBP officer, they are very, very professional, and they are not threatening, and they don't ask you for any financial information. So they don't ask you for your bank accounts, they don't ask you to pay any money. So the first sign that somebody might not be from USCIS or CBP or any other government office is, if you feel that the way they're talking is threatening, they're trying to blackmail you, they're trying to get money out of you, definitely this is not something what the government officers do. So that's your first indication, because sometimes we have heard people call us and say somebody called and said it's an IRS officer, a tax officer. So be cautious. I mean, so what you should do if somebody says they're a government officer, this is what you should do. If you suspect something wrong, simply politely tell the officer, we don't know if you're real or not. Simply send us an email from your official email to my email, okay, and put your official contact number, contact details in the email. The USCIS officers will not never have a problem with that. I've never seen a USCIS officer say, "No, I'll not email you," because they understand. I mean, people sometimes get wary if they're real or not. And these government officials, their email address always ends in .gov. So if they send you an email, you can always reply back to them and say, "Hey, I'm replying back. Just please confirm that you are who you are." Okay, basically, that's one way. Always try to get an email and ask them to verify through email, and at least contact you through email. And that way, once that contact is done, then maybe you can call them back and talk to them and cooperate with them, because you do want to cooperate with government officials. So, but again, there is nothing wrong in you trying to validate that they're a real government officer. That's very important. And again, the main thing is try to validate their phone numbers and so on. So you can always Google their phone numbers, and when they call you, take their number and you always call them back, because sometimes they can spoof a number. So they might make it sound like on your caller ID, it might look like it's a real government number, but when you call them back at that number, they might not exist. So always take their number, Google that number, and always call them back. What I always suggest is ask them to email you their entire contact information, ensure that they have a .gov email, and then initiate conversation. And that being said, no USS officer, no government officer will ever ask you to pay any money to them, never threaten you with an arrest. So if somebody is doing that over the phone, upfront you can assume that they are fraud, and immediately involve, either if you have an employer, involve your employer, or definitely the best recommended approach is involve a lawyer or an attorney. Okay, so don't ever pay anybody any money, because they're threatening you with arrest. They're threatening you that you've done something wrong, you overstayed your visa, so you have to pay some money or anything. So anytime somebody is threatening you with something on the phone, there is something going on. These government officers are very, very, I mean, professional. They don't threaten you. They probably ask you for information, and they're always willing to send you an email and confirm their identity. Okay, so that's how I think you should always verify if somebody is a USCIS officer or a government officer.
There you go, friends. Thank you so much, Chand, for making that so clear. And yes, I'm sure people listening to us right now, they'll feel more confident to deal with all these kinds of cases if they are ever exposed to all these types of scams we have discussed today. And I think I have one last question for you, Chand, because I was telling earlier, since we really see so much about all these types of scams, in different news about immigration fraud, or is really scams every day almost. So can you provide or tell us about one or two very recent cases, case study examples, if you can remember, or maybe share a few lessons and takeaways also from these cases?
Sure. So I had one case very recently where somebody was called on the phone. She was the H4 spouse, and she was called on the
Mhm.
phone, and she was told that the other side was a government official, and she was threatened about arrest. They said something that her husband has done something wrong, and she's going to be arrested very soon, and she
Mhm.
immediately has to pay some money for getting bail. And they told her not to get off of the phone, and I don't know how they convinced her, but again, sometimes people get scared because people follow the process, and if somebody calls them on the phone and says something, sometimes people under that stress, they believe that that is true, and they would not let this person get off of the phone. And they made her like transfer this money and do all these things, and she lost $3,000. It's a big number for that person, and she was devastated. That whole experience was traumatic. And not only, I mean, not one, I've seen multiple cases in our law firm where people, they were called and they were told not to get off of the phone. Sometimes people were actually asked to drive and go. So I had a case where somebody had to drive, go to a Kroger, buy some gift cards, and send them gift cards. And when they were being told to buy gift cards and give them the gift card information, even then they did not suspect,
Mhm.
because in that stress, sometimes people don't think right. So in that stress, they went and bought some gift cards and gave all this gift card information to this other side. and that's it. There is not even a way to retrieve that money back. So at least, I mean, I've recently seen those issues. And sometimes, again, if somebody calls you on the phone and says they're a government officer, not always it is fraud. Because yesterday evening, I had this case where this company's employee came from India. At the port of entry, they stopped this employee, and then they called the employer. An employer thought it was fraud. An employer refused to answer it on the phone. But luckily, they called us, and then they were able to call CBP back and
Mhm.
verify the information. But because, I mean, these scamsters sometimes even make the real calls, people sometimes tend to assume that it might be a fraudulent call. So be careful. My
Yes.
thing is, if somebody is threatening you, blackmailing you, asking you to release financial information, trying to get some money out of you, that is the biggest indicator of fraud on the phones or on the emails. So that is where I think definitely, I think, be cautious.
Right, right. I mean, all sorts of scams, not just immigration. And people nowadays are so much into this. There are so many groups out there, notorious groups, trying to have successful fraudulent activities everywhere possible. There are calls every
And
day about
unfortunately, I
from different
mean,
banks.
yeah.
Yes,
Yeah, and unfortunately, sometimes we have heard that these calls are originating in India, and because even Indian government is like very actively works with U.S. law enforcement. I mean, people in India got
yes,
arrested because they're trying to scam U.S. People, U.S. senior citizens, U.S. immigrants, and so on. So, I mean, these bad people are everywhere. These bad people are in India. They're probably in Africa. They're probably in some other countries. So, I mean, it's
yes,
sad, but there are bad people out there and trying to do these kinds
it's
of stuff
happening.
and scam other people. Yeah.
Yes, and every day we are hearing all these sorts of news. We hear our friends and loved ones being, you know, getting calls of all these sorts. Some, they reject, but some they fall prey, and it's sad because there's so much loss of money and so many things, right, Chand? Especially money, I
Yes.
think it's
Yes.
mostly payment based. Yes. Thank you
Yes,
so
and that's
much,
why I
Chand. I
think
mean, this was,
discussions like
yeah,
this, yeah, yeah,
sorry.
discussions like this at least bring out that kind of awareness, and hopefully, I think, I mean, people don't fall for those kinds of tricks.
Yes, right, right. So there were so many important topics we discussed, important things to keep in mind. Do listen to this whole episode again. And also Rahul Kumar is asking once again, is it possible that someone can be picked up in H-1B lottery in the first and the second draw? I don't think so.
No, it's not possible. And I mean, if somebody, because especially this year, if somebody is picked up in the lottery the first time, they went based on their passport, unique passport. So it is
Yes.
not likely that they can be picked up in the second draw. And in the second
Mhm.
draw, the USCIS announced the data. Only around 13,000 people got selected. In the first lottery, around 113,000 got selected. So the second lottery was very, very small lottery, and we discussed this like
Yes.
the last month. We were making some predictions. So the lottery was like not a very large lottery. It was a very small lottery, only 13,000 selections, and nothing like last year. So it was a small lottery, and we'll see.
Sure, sure, sure. Also, I mean, we're getting a lot of questions from Vishnu. I would suggest, Vishnu, why not call up Attorney Chand directly, And well, he's also saying, thanks, Chand, for all the answers. Since I had never been to the US, when I find new employer to file my H-1B, will they have to provide pay stubs to US for approving it? So I think I think it'll be best, if you can contact Attorney Chand directly and I mean, do a personal discussion because I'm sure your case is very different and needs. I mean, you have a lot of questions too. So the contact details are on the screen: 817-523-8247. Feel free to leave him a text as well, and you can even email him law@spblawfirm.com or visit his website spblawfirm.com. But thank you so much, Vishnu, for being so participative and for all your questions. Thank you. Chand, is there anything you want to say before we leave today's session and our audience?
Yeah, again, I think just a general reminder that I mean, just follow the rules, and if you ever feel that you're a victim of any crime,
Mhm.
use the resources. There are a lot of good resources both in India and also in US. The law enforcement is strong. Use the resources, and don't ever shy away from reporting crimes or reporting any of these issues. And doing so, not only that you bring awareness, you also stop criminals from targeting other people.
Right, right. Thank you so much, Chand, really. And that's all the time we have for today's webinar. Friends out there, I really want to also say thank you once again to Attorney Chand Parvathaneni, for sharing your expertise with us today. And really, it has been a very enlightening discussion. Thank you all viewers as well for all your lovely questions and yeah, tuning across whether it was YouTube, LinkedIn, or Facebook. Thank you for your questions. And thank you, Chand. Until next time, I hope to see you again in the coming week.
Sure. Thank you so much, Nipasa. Have a good day.
You too, Chan. Thank you. You too, friends out there, have a good day ahead. And thank you so much for joining. You can also contact me in case you're looking for a project placement or anything related to immigration. If you have any questions, why not reach out to me? This is also my WhatsApp number or where you can call me. 408-335-6444. And my email address is nipa@higheritpeople.com. And to get to know more about us, visit us at www.higheritpeople.com. And thank you so much, really. It was good. And don't forget to subscribe to us because we keep having very important discussions like these. And we also keep updating lots of important news and updates. So subscribe to our channel. Our handle is Immigration and Jobs Talk Show. And we are on YouTube, LinkedIn, Facebook, also Twitter and Instagram. Check us out. Thank you so much. And this is Nipasa Pradhan signing off for now. Stay safe and thank you all for joining Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com.
What is the process for obtaining a J2 visa and how does it depend on the J1 visa holder?
Everything that applies to the J1 applies to the J2 visa holder as well.
Is the length of stay for J2 visa holders directly tied to the J1 visa holder status?
Correct. The J2 visa status is directly tied to the J1's visa status. So if a J1 is issued for 4 months, the J2 would also be for 4 months.
Like, can J1 and J2 visa holders study in the US? And if yes, then what are the specific requirements?
There's definitely a lot of benefits to
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam, and today we have a very special guest with us who has joined us for the very first time. And before announcing that, I would directly go to our important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. So, viewers, I would like to say that today it's going to be a very special episode. The guest who has joined us today for the very first time, and I'm thrilled to introduce Attorney Poonam Gupta, who is a renowned immigration attorney with 25 years of experience in the immigration field. And let me tell you that she also has experience in intellectual property and litigation. So, Poonam, first of all, a very warm welcome to Immigration and Jobs Talk Show. And I would say that it's really an honor to have a show with you. And thank you so much for being a part of Immigration and Jobs Talk Show.
Thanks, Sam. Great to be here and looking forward to an exciting discussion.
Of course, sure. We would definitely have a very insightful and exciting discussion. Poonam, as this is your first time on our show, so I would like to know that how you're feeling right now.
I'm feeling pumped, great, and excited to help people understand more about immigration.
Wow, that's great. So, as this is your first time, so could you please take a moment to introduce yourself and share a bit about your background and experience in immigration law?
Sure. I grew up in India and then moved to the US. I practiced in India for a few years and then moved to the US. And I've been here 25 plus years. And I started in immigration, went down to do some litigation, and then came back to immigration about 14 years ago. And I've been doing immigration, US business immigration exclusively for that time. And in that time, I have advised clients in all industries, all sizes, all stages of their development, from starter to startups to multinational Forbes 50, Forbes 10 corporations. So I've seen the entire gamut and pretty much everything there is to see on the US business immigration side. But US immigration being what it is, there's always things that we learn, even today, even after 25 years. Every single day, there is something new to learn. There's some nuance that is, we haven't seen before and we see again and again. So it's always exciting.
Wow, that's so good. So, Poonam, as an immigrant, was it challenging for you to shift from India to USA, or was it easy for yourself?
Being an immigrant is never easy. Immigrants face a lot of hurdles, face a lot of challenges, and it's an emotional roller coaster for most immigrants because they're leaving behind things that they grew up with, things they're comfortable with, into a completely unknown culture, completely different culture. And in US, it is even worse because compared to what we grew up in India, coming to the US is a culture shock in some ways, but in other ways, the nuances of the society, the etiquettes, and so on are very, very different. So it was a challenge, but I think I've assimilated fairly well and become fairly comfortable. And my goal is to help other immigrants and ease their journey as best as I can. That's why I'm in this business and I'm doing what I'm doing.
Yeah, I was about to ask that only that because of these challenges that you face, that's why you decided to become an attorney to help others, and you answered that.
Yes,
All right.
definitely.
Yeah, well, that's a great start, I would like to say. And our viewers also know you, and that's really great. So I hope that this is just a start of many more great conversation together.
Yes, for sure.
Of course. Okay, all right. So, Poonam, I would like to just directly jump into today's topic. That today session is about, can J1 and J2 visa holders legally work in the US? Explanation by none other than attorney Poonam Gupta. So let's directly ask our first question. So, Poonam, let's start with the basic understanding of today's topic. Like, can you please explain what are the key differences between J1 and J2 visas?
Sure. J1 is the primary person who's being sponsored to come to the United States, and J2 are any of their dependents. Dependents under US immigration law are defined as spouse and children under the age of 21. Dependents are not parents, uncles, aunts, or any extended family or grandparents. It's simply spouse and kids under the age of 21. J1 holders, depending on what they are coming to do in the US, and there are several categories of J1s. They could be working, studying, any of those things. And J2 have to be individually sponsored by the J1 sponsor as well. Unlike some of the other categories, like for instance in H1 or L1, the dependents can apply for their visas simply on the basis of the principal applicants or the principal immigrants' documentation. For J2s, that is not the case. They need to be sponsored separately and they need their own separate DS 2019.
All right. That's great. So, Poonam, let's move ahead with our second question that I would like to ask, that what is the process for obtaining a J2 visa and how does it depend on the J1 visa holder? What can you say on that?
Absolutely. As a dependent on the J1 visa holder, everything that applies to the J1 applies to the J2 visa holder as well. As I said previously, each J2 dependent has to be sponsored separately by the J1 sponsor. The J1 sponsor has to issue a Form DS 2019 for each J2 applicant, and then the J2 applicant applies for a visa at the US consulate directly. And they apply, they can either with the J1 holder or after the J1 holder, like most other categories, it's directly dependent. So whenever the J1 status ends, the J2 status will also end.
Now, I would like to talk about program duration and stay. That how long can J1 visa holders stay in the US? And does this duration vary by program type?
Absolutely. So there are many different program types. J1 is one of the most versatile programs the US Department of State administers. It could be for as short a duration as a couple of months. For camp counselor or summer work travel, the maximum is 4 months in those cases, up to 5 to 7 years if someone is coming to do research or be a physician in the US. So depending on the program type, the length could be a few months to a few years. And I can go into those details if you want later, but that's the broad brush.
All right. Okay. So, Poonam, what can you say? That is the length of stay for J2 visa holders directly tied to the J1 visa holder status?
Correct. The J2 visa status is directly tied to the J1's visa status. So if a J1 is issued for 4 months, the J2 would also be for 4 months. And the critical thing to note here, similar to F1, when the F1 or a J1 enter, or J2 for that matter, enter the United States, their I-94 document will not have a definite end date. It will say D/S, which stands for duration of status. The end date on their application of their stay is actually on the Form DS 2019, and that is something that defines the period of stay that is permissible. So the DS 2019 is the controlling document for the J1s and the J2s.
So, Poonam, what can you say about work and study opportunities? Like, can J1 and J2 visa holders study in the US? And if yes, then what are the specific requirements?
So the J1, depending on what they are coming to the US to do, that will dictate what they're permitted to do, whether they are studying. If they're coming here to do a university program, for instance, then obviously they're coming here to study, and they can definitely study. Can they work alongside it? If they're coming to study, then potentially they could work. Their the J sponsor would be able to guide them on what the parameters are for their work in the US. So they could engage in academic training, which is similar to the optional practical training that F1s have. And the academic training could be during their course of study, it could be after the course of study, and the duration of that would change. Moving to J2s, J2s can study part-time, full-time while they are in the US, and they can also work while they are in the US. And the only requirement, unlike some of the other visa categories, is they need to apply for an employment authorization document from USCIS before they can work. But they can study without anything further, just by basis of their J2 status.
All right. So, Poonam, as you mentioned right now about the academic opportunities and academic journey, I would like to ask from you that I noticed that you started your academic journey with a BSc in zoology from Delhi University, right? But
Correct.
later you pursued an LLM from New York University. So I'm really curious to know that how you shifted your zoology, career from then to LLM. What was the journey? Was there some experience or incident happened that changed it, or what it was?
Sure. So I had my heart set on going to med school in India, but as you know, med school is extremely competitive. And I wanted to be in the cutting edge of technology, whatever it was. I finished my zoology degree and enrolled in the master's program and realized that very quickly realized in my master's program that that was not how I wanted to spend my life. I could not see myself in a lab working with, you know, on working on experiments in isolation. For me, helping people and being out there and doing things with people is important. So I pivoted to law. My dad's a lawyer, and I got his advice. And he'd never pushed me to pursue law, but he was pleasantly surprised and happy that I thought about law. And I went into law in Delhi. I did my LLB in Delhi and then practiced in Delhi. I practiced intellectual property law at a top firm in Delhi for many years before I came to the US. And then in between my law in Delhi, I went to Cambridge on a full scholarship to do a master's there. And then when I moved to the US, I got a scholarship to study at NYU and did my master's to take the New York bar. So, and then when I came to the US, the immigration piece just pivoted and changed everything for me. And I found my true passion in immigration.
That's really great. Finding your passion gives you so much happiness. And that's so good to hear it from you. I must say that. All right. So, Poonam, I would just like to share with our viewers that, guys, if you are navigating the intricacies of visa applications or facing any legal challenges or simply need just guidance on the latest immigration policies, then please contact attorney Poonam Gupta. You can also email her on info@summit-legal.com. And for sure, visit our website www.summit-legal.com. All right. Now, moving ahead, and if I want to talk about career impact and opportunities, then how can holding a J1 visa enhance the career prospects in the home country after completing a program in the US?
There's definitely a lot of benefits to doing a J1 in the US. One is international experience and exposure to a US work culture and practice, which is a very professional environment, unlike a lot of countries, not all, and definitely not in the Western world, but some of the other countries where even though the environment may be professional, the US work culture is very different. So getting exposure to that is a huge plus in my view, having worked in India and in a very professional environment. The level of professionalism in India compared to the UK, where I also worked, compared to the US, I would say the US has the most professional of all environments among the three. So that I think is a huge plus. And then the second is in this global economy, having a global network, coming to the US and connecting to people from different backgrounds is invaluable, invariably. And no matter what you do, there are ways in which you can leverage your connections in different countries and in the US to grow in whatever industry you are in when you go back to your home country. And obviously, because you're coming to the US on a J1, there are some skills or some knowledge that you're seeking to gain by coming to the US. You'll obviously gain those as well. So, depending on the motivation behind that J1, those are the top three things that come to mind.
Thank you so much, Poonam, for your detailed answer. And let's move ahead with my another question that I would like to ask. That is, how can J2 visa holders leverage their time in the US to build professional networks or gain work experience despite restrictions?
So there are actually limited restrictions on J2. J2 is one of those categories where they are allowed to work as soon as they receive their employment authorization document from the government. The only restriction they have is during the time that they're waiting for that work authorization papers to come through. Once they have that, they can do whatever they want. They can start their own business. They can work for anyone for as long as they want. They can work for multiple employers. There are no restrictions on that. So obviously, applying for work authorization is great because working in any industry or any area gives you the leverage and the experience that simply being on the fringes does not. So I would encourage all J2 holders to, and that is only spouses. The kids cannot work on it as a J2. Only spouses can work as J2. So they should definitely leverage their time and apply for work authorization. While they are waiting, they can definitely enroll in some schools. And these days, networking opportunities abound. No matter what city you are in the US, there is some group, some event, networking event that you can be a part of. So I would highly encourage everyone to go out and network and find people who share your passion that can help you grow together. And it's always beneficial. Last but not least, they can volunteer. I recently posted on LinkedIn about volunteering and the pitfalls surrounding those. So I would encourage everyone to look at that. In summary, volunteering is something that is for an organization or a role that is purely a volunteer role. It is not a role that is meant to displace any paid work. So those are just some opportunities, some options to keep in mind. But the world is open to J2s.
Right. Okay. So far so good, Poonam. Now, moving ahead with the next question that I would like to talk about work authorization for students on J1. So, can you please explain that what work authorization options are available to students on a J1 visa?
Sure. So as I mentioned earlier, J1 visa holders are eligible for work authorization. Most of them, and again, depending on what visa category they're coming, what program they're coming for, most of them are for work or getting trained while they work. So somebody who's coming in as a college or university students, they have ability to work on campus or during their coursework, after their coursework, as part of their academic training. If they are coming in as a researcher or a scholar, again, those are work study or working options, and they would be working and being trained accordingly. Then the interns and trainees also are programs where somebody's coming into the US to intern at a host company and work at that company, or trainee will train at a company. So they will be working. Work is part of what they are getting, and they get trained while working. So the only category of J1s that need work authorization are the students and the academic training. Most others are working and training simultaneously.
Great, great. Okay, so how can J1 students apply for work authorization while maintaining their student status? What can you say on that?
Sure. So J1 students go to their J1 sponsor and seek work authorization. It is an endorsement on their DS 2019. And sometimes they may require an employment authorization document from the government. But any work authorization has to be approved by the program sponsor. For scholars, that is, for J1 students, that would be the form of academic training, and that academic training can be before they complete their program or during their program. Sorry, when I say before, I meant while they are in their academic program, or they can do it after, at the end of the academic program, similar to optional practical training for F1 students. So they will need authorization from the program sponsor, in summary.
All right. Thank you, Poonam, for your answer. Now, let's move ahead and shed our lights on visa extensions and transitions. So, what can you say, Poonam, on this? That what is the process for extending a J1 visa, and under what circumstances can an extension be granted?
So most programs have a limited duration, and the program sponsor, and if, say, for instance, for trainees or interns, the maximum duration is 12 months to 18 months. If the program is completed in that time, then great. If there is additional time required, then the program sponsor is the only one that can decide whether or not they will grant that extension. So if the host company requests that they need additional time for that additional program to be completed, they apply for, or the J1 applicant applies to the program sponsor with supporting documents and explanation for why they need additional time. Then the sponsoring organization will issue an updated DS 2019 indicating the extended period. Most of the time, when a person is extending their J1 program, they do not need a authorization from the government, from USCIS. They simply need an updated DS 2019, and that is sufficient. But if they're going to switch from one visa category to another visa category, so say from an academic J1, they want to switch to a research J1, then that is a different category, and a different program sponsor will approve the J1. In that case, they will need to go to USCIS and request that extension and update. But if they're simply extending, the program sponsor's issuance of a new DS 2019 will suffice.
Great. So, Poonam, my next question to you is that can J1 visa holders transition to another visa type, such as H-1B or a green card?
Technically, yes, they can. The big restrictor for most individuals is if they are, whether or not they're subject to the 2-year home residency requirement. How will you know whether you're subject to the 2-year home residency requirement? There are two places to look. One is your DS 2019. Program sponsors will mark on the form on page 1 whether or not you're subject to the 2-year home residency requirement. Or when you apply for your visa at the consulate, on the visa itself, there would be an annotation subject to 212E, 2-year home residency requirement. If you have either of those, and sometimes there are mistakes, sometimes you're not subject, but the officers may make a mistake. But if you have any of those annotations, you are subject to 2-year home residency requirement. What is the 2-year home residency requirement? It means that you have to go back to your home country for at least a period of 2 years cumulatively. It doesn't have to be together, but over a period of time, you have to go back home for 2 years cumulatively before you can come to the US in H-1B, L1, or a green card. So that is critical and important. And can they transition to other visa types? Yes, there are lots of options. They can transition to F1, H1, L1, O1, E1, E2, green card from family-based or whatever. But depending on what the criteria is and whether or not they're subject to the home residency requirement, whether they can switch to that status will be dependent on that annotation.
All right. So, Poonam, my next question to you is that are there options for J2 visa holders to change their status to another visa type while in the US?
Yes, they have the same options as a J1, and a lot of them do all the time. They are also subject to the same home residency requirements as the J1 because they're dependent of that J1. So, for instance, an Indian national is subject to a home residency requirement, but a German national may not be. So, an Indian married to a German, the German gets a J2, they will be subject to. If they had applied for a J1 on their own, they may not have been, but because they're applying as a dependent of an Indian, they would be subject to the home residency requirement. And until they complete that, they would not be able to move forward to that. So, same restrictions, same options, same everything. Just be mindful of that.
Okay, thank you so much, Poonam, for your answer. Now let's talk about two-year home residency requirement. So the two-year home residency rule can be a major hurdle. So what creative solutions have you seen for J1 visa holders wanting to stay in the US longer?
So, most people think you can apply for an H-1B after a J1. USCIS does not like that. USCIS wants the J1 visa holders to go back to their home country and apply the skills that they've learned in the US in their home country. One option is to apply for a waiver if waiver is available, or switching or doing consular processing. So, I mean, you cannot switch to an H or an L from within the US or outside the US if you have a home residency requirement. But if you have a home residency requirement, you can apply for an O1 outside the US. You can go to the consulate, apply for an O1, and come back. But if you want the green card, before you are able to get the green card, you have to go back home for 2 years or get a waiver for the 2-year home residency requirement before you can get the green card.
And how does the waiver process for the two-year residency requirement work? And what compelling reasons can support a waiver request?
So there are 5 statutory bases for a waiver. The first is a no objection statement. So the home country for the J1 applicant has to provide a no objection, that they have no objection to granting the waiver. And if they give that no objection, then the person can apply for a J1 waiver with the Department of State and then, if needed, with the USCIS. If there is a US government agency that is interested in the work that the J1 applicant is doing, then they can request a waiver to keep the J1 person in the US in the public interest. Number 3 is persecution. If the J1 visa holder would face persecution on account of race, religion, or political opinion if they return to their home country. I imagine if that is the case, then they would also potentially qualify for or apply for asylum. Then the 4th is extreme hardship to the US citizen's spouse or child. And if they're married to a US citizen or a lawful permanent resident, then they may also have other pathways open to them, but they would still need a waiver. And the last is the Conrad State 30 program. This is for J1 physicians who work in medically underserved areas for a specific period of time. And then the way this works is, the most common way is requesting a no objection certificate from the government, from the home government, and using the documents, including the no objection certificate and any other documents that the Department of State requires, including the form DS3035, and submitting it to the Department of State. Once the Department of State approves, they send the recommendation for the waiver to USCIS. In some cases, there may be a need to file the Form 612 with the government, but in most instances, it is not required.
So, Poonam, after learning so much, why don't we shed our lights on the future trends? So, what can you say that with this evolving immigration policies, what changes do you foresee for the J1 and J2 visa categories? And could we see more leniency or new opportunities in this?
Sam, this is an election year in the United States. So, depending on which administration is in power next, we could see an immigration-friendly administration or an anti-immigration administration. And depending on where they are and what their priorities are, for an immigration-friendly administration, we could see efforts to simplify and expedite the J1 visa process, reduce the bureaucratic hurdles and processing times, potentially expanding the program categories to include high demand areas like STEM, or updating the 2009 skills list, enhance support for waivers, and so on. There are a lot of areas they could do good in. Or they could remove the requirement for J2s to require an EAD. This is just one example. But on the flip side, if the administration is not immigrant friendly, then we could see heightened security and denials. They could be increased scrutiny of J1 applications, more rigorous vetting processes. There could be reduction in program categories that could be restricted or eliminated. And I would think the interns, trainees, or the au pair programs may be reduced or eliminated. There could be stricter enforcement of compliance. There could be limitations on waivers, increased processing times, and so on. So immigration is very dependent on the administration and administration priorities.
All right. So, Poonam, as you mentioned about the election, now my next question would be like this only. That do you think that there really will be a mass deportation, as Trump says about it?
It's a soundbite. Whether it is something that can actually be enforced and whether the government has the resources to execute on something like that remains to be seen. I remain skeptical, but we don't know the extent to which any government will go in promoting the anti-immigrant sentiment. So I can't say anything more than that. I think it's just wait and watch.
Yeah, because Trump is completely unpredictable. You never know with him, right? What he does, what is his next step? Completely unpredictable.
Correct.
So, Poonam, do you think that the J1 visa program will expand to include new industries or sectors, especially with the rise of remote work?
Again, I think this is dependent on the administration that's going to be in power next time round. It could, but the remote work is actually being curtailed in the United States more and more. More and more companies want their employees to be back in office full time, similar to pre-pandemic. But we'll see.
All right, all right. So I think we have covered great amount of questions till yet. And Poonam, one more last question that I would like to ask from you: that have you encountered remarkable cases where J2 visa holders successfully transitioned to their own independent visa status, and what made their journey stand out? Please tell our viewers about this.
Yes, actually, I do have one. So I had a client who was the head for a nonprofit organization She was on a J2 status and was able to transition to an H-1B and has made her life in the United States and is successfully, charting new territories in the United States after pivoting to H-1B and getting her green card. It's just for me, seeing women come out of their, from behind their dependent status and building on it and making something of their professional journey and not delegating their professional journey to their spouses and their partners is always inspiring and empowering. And I like to support as many as I can in that sense. So this J2 holder was, it's the story is really near and dear to my heart, and I am very proud of her.
Wow, that's so good. I mean, but I would say that after hearing these stories, many of the people are going to inspire from you and they are definitely going to keep you as an idol. So it's really good to hear these things from you. So, Poonam, it was really great having you. But before wrapping up, I would like to ask that any last message you would like to give to our viewers about who are applying for J1 and J2 visas?
I would just say be mindful of the 2-year home residency requirement and work around it and plan for it. There are people who come from India who come just for the summer program in high school or in college because they want that experience of being in the US and don't realize that they're stuck with a 2-year home residency requirement. So please read your papers, please read the immigration documents carefully and educate yourself and be proactive about your immigration journey. Don't let somebody else dictate it for you. It's your life. Take charge of it. Thank you.
And also to our viewers, I would like to say that, guys, please contact Poonam so that doesn't matter that whether you are just applying for the visa, but even if you're navigating the intricacies of visa application or facing any legal challenges or just simply needs guidance on the latest immigration policies, then please feel free to contact attorney Poonam Gupta on the given contact details that I would like to read out. Her email ID is info@summit-legal.com and her website is www.summit-legal.com. So that's all I would like to say. And finally, Poonam, I would just want to say that it was truly appreciating you having on the show, and it was so good. And I would love to have more and more shows with you. It was so good. And anything that you would like to say to our viewers?
No, I think this is great. You're doing a great service to all immigrants in helping them learn about themselves. And as I said, no two immigration cases are the same. So please do not try to apply anything that you hear in any video to your situation. It may seem like it's identical, but it's unlikely. It may be similar, but it's unlikely to be identical. So please, to the extent you can confirm with information from the government website, great. Otherwise, consult with an immigration attorney that you trust and go forward and take charge of your immigration journey. Good luck.
So, thank you, Attorney Poonam Gupta, and also to our viewers. And I would just like to say that in case if you have any questions or want to connect with Poonam, please feel free to contact her on the given details. And also stay informed by liking, sharing, and subscribing to the Immigration and Jobs Talk Show for more updates. Thank you so much, everyone, for joining us. And I'm Sam signing off for now. Thank you.
Hello, viewers. Thank you so much for joining us today. This is Immigration and Jobs Talk Show, and I am Napasa Pradhan. I'm going to be your host for today's session, and it's going to be a wonderful one. So, before we dive into today's topic and I introduce you to our special guest, I really wanted to wish you a very good morning, good afternoon, good evening, wherever you have joined us from, whatever time zone you have joined us from. Thank you so much for doing this. And there's an important disclaimer I need to read out. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, thank you for joining us today here at Immigration and Jobs Talk Show. We are streaming live on YouTube, LinkedIn, and Facebook. So feel free to drop your questions if you have any, in the comment section, wherever you're watching us from. And we'll try to get as many as we can in this session today. But before we go on to today's topic, today we have a very special guest with us, someone who is a prominent figure in the field of immigration law. And she is Sophie Alcorn. She's the founder of Alcorn Immigration Law and has been recognized as the top 10 immigration attorney in the state of California. She's also the host of the Sophie Alcorn podcast and the author of the best-selling book, Ask Sophie, The Founder's Guide to Visas and Green Cards, currently based out of San Francisco Bay Area. It's such a pleasure and an honor to have you with us, Sophie. Thank you so much for joining us
Hi,
today.
Nivasa. It's so wonderful to be back. Thank you so much for having me. There's a lot of exciting updates, and I'm eager to share my knowledge and answer questions. So thanks for the opportunity to be here.
Thank you so much. Thank you so much. And talking about it, I mean, let's get to know what are your thoughts on the latest update on the second lottery coming up for H-1B cap.
Yes, it's so exciting. So a couple days ago, USCIS just announced they are going to conduct a second lottery, or the random selection for the previously submitted H-1Bs. So this means that if an employer put you in the lottery in March and you were not selected in April, you now get another chance. And it's really exciting. And it's also super exciting for most people in the world because they've already reached the master's cap of the 20,000 set aside for people with advanced degrees from the US. And so it means that everybody is eligible for this second lottery now. So if you have a master's degree and you're going for the master's cap, great, you still get another chance. But everybody else who just has like a bachelor's degree or the equivalent, they also get a second chance. So it's really exciting.
It is. For folks out there, I mean, all this while, everybody were like, is there a second lottery going to come up? And, oh, by the way, is there any chances of maybe a third lottery maybe after this?
Right, right. It's so erratic every year. I mean, one year they had like 4 extra lotteries, and then other years they've had 0. And so it really fluctuates. I'm sure they try to do their own like predictive analysis and statistical modeling to try to get the right number, but there's always fluctuations, interest rates, layoffs, employers, whatever. So, I don't know if there's going to be another this year. I have no idea, but I'm just really happy this is happening now. I wish I knew when it was happening, but I don't. They just said soon. And if you previously registered, you're going to find out about it through your USCIS online account. And typically, they give employers 90 days to file the petition after the selection has happened, and it would still be to target an October 1st start date. So we have August, September, October. So theoretically, you could probably request a later start date than October 1st if your employer wanted. You could choose a start date up to 6 months into the future for the I-129 H-1B petition. But we'll see. Like, if you wanted to still try to make it by October, and I don't know, let's just imagine this happens next week, I think there would still be ample time for an employer and for a visa interview to go through the process. So it's really exciting.
Exciting, it is. Let's stay hopeful, folks, I would just say, and all the very best to all you folks out there who have the second chance. Let's pray for the best, okay?
Yeah.
So, yeah. And let's get to today's topic. Our topic for today's discussion is top visa options for employers for a quick hire. H-1B versus H-1B exempt versus L1 versus O1. And basically, it's the second episode, but since we couldn't cover it properly in the first episode, maybe, Sophie, if you could just give us, like a roundup, or like what can folks expect from us in today's webinar?
Wonderful. Okay. Well, I will share a little bit more. And thank you for the warm introduction. I really appreciate it. I started my law firm. My dad was an immigration lawyer. My mom's an immigrant from Germany. And I just see the grit, resilience, determination, creativity, innovation that come from our immigration system in the US. And I believe that we should live in a world where every kid has the chance to grow up and live their dreams. And so that involves, removing artificial barriers like immigration to allow people to live their best lives. So happy to keep in touch with everybody. And you had an amazing disclaimer. This is mine. This is not legal advice. Talk to a lawyer if you need individual legal advice. Obviously, whatever questions you ask are not confidential. This is just an educational service. And in my slides, I do have this QR code, which is our consultation booking link if you do need help. And let's see. And would you like me to now go into some of the overview about some of the background on H-1Bs and Ls for a few minutes? Would that work for you?
Yes, we should do that. I think without further ado, let's get on to whatever you have for us today. And we are absolutely ready. And I hope the other folks out there are as well.
Wonderful. Well, I'll go through my slides. Feel free to jump in if anything's unclear, but I'll try to go through them in maybe 5 to 10 minutes, give everybody a brief overview of H-1Bs, cap exempt H-1Bs, L1s, other types of visas, green cards, and then we can turn it over to questions. Okay?
Absolutely. Thank you so much.
All right. You're so welcome. Okay, so high-level immigration context. Lots of reasons people want to come to Silicon Valley, where I practice immigration law. They want to launch new technologies. They want to increase their profit. They want to move really fast. They want to work with the brightest minds from the world. They want to raise money and venture capital from US investors. Now, you're probably all very familiar with this in the audience, but in general, the US has visas, green cards, and citizenship. So most people, like from India, for example, would come here on a non-immigrant visa, such as a B1, B2 visitor visa for 10 years, where you can stay 6 months at a time, or an F1 student visa. And then after you're here, you have various options, such as changing your status, maybe if you got selected in the H-1B lottery, or you're going to pursue an O1 visa for extraordinary ability. And then you can be sponsored for a green card, either by a family member or an employer usually. And a green card is the same thing as permanent residence. Sometimes it's called an immigrant visa. If you're already in the US, you can get it through a process called adjustment of status. You might be qualified for a work permit along the way. There might be travel restrictions at some point, but you would get an advance parole document to allow you to travel. And then 5 years after having a green card, if you want to naturalize and become a US citizen, that's something you can apply for yourself. You don't need an employer. And once you're a citizen, you can sponsor your parents for green cards. And you always have to pay taxes in the US, but you can be gone as long as you want. So lots of advantages for that. So most people come here on a visa and then get a green card. Some people do, like some folks from India who are EB1A qualified. They might, for various reasons, choose to apply for the green card from India before moving here, but usually that can take several years. So often people want to move here quicker through a visa. And then there's a lot of international students in the US. Along the way, they can have work options such as curricular practical training, optional practical training, pre-completion or post-completion, the 24-month STEM OPT extension, after the up to 12 months of regular OPT after they graduate. And historically, the hope was always, I'm going to go to the US, I'm going to graduate, I'm going to get a job that'll sponsor me for the H-1B. They'll put me in the lottery every year until I'm selected, and then they'll sponsor me for a perm and an I-140. But several big companies recently announced that with all the tech layoffs, they're no longer engaging in their perm programs for their employees. So these this path is not as secure as it used to be. And so, definitely excited to provide alternative options. So for work visas, the most common, we talked a little bit about the H-1B lottery, so that's very exciting. It is possible to hire people with H-1B transfers, and you would need current or previous H-1B status. The new US employer has to proactively file the H-1B visa transfer petition. They have to prove that they have the ability to pay the prevailing wage. And if somebody's already maxed out their 6 years on H-1B status, there are ways to get extensions beyond the 6 years through a law called AC-21. And that is based on having a perm or an I-140 approved. And then you can get either 3-year or 1-year extensions. So lots of people from India utilize that. Now, we did get a question about what is a cap exempt H-1B. So these are H-1Bs that do not require the lottery. They are available at any time of the year. And the best way to use it to have a job at a private company is to obtain 2 concurrent H-1Bs at the same time. So step 1 is to either get a part-time job at a qualifying cap exempt employer. So that could be a university for a part-time teaching assistant job. It could be at a nonprofit associated with a university or a nonprofit research institution. There are various global talent fellowships and organizations that have sprung up to support this. So you basically work for them for 5 hours or 10 hours a week to get your first H-1B. And then while you're doing that job, you don't have to go through the lottery to get a second concurrent H-1B with a private employer. So your other employer can then sponsor a part-time or full-time concurrent H-1B. So that's been very, very beneficial. And just to recap, those cap exempt organizations that you could get the first job at include universities, government research organizations, nonprofit research organizations, and nonprofits affiliated with universities. Okay, so those were H's. And just another note on H's before I move forward, because we work with a lot of startup founders. We've gotten H-1Bs approved for CEOs of pre-revenue startups, even where they're the 100% owner, and even where there's no major venture capital investor. The government is very interested in allowing folks on H-1B to become startup founders because they recognize the innovation potential that people on H-1B have to develop new critical and emerging technologies and AI and ML and other areas. So if you are on an H-1B and want to be a founder before getting a green card, it is definitely possible. And you could even do that with a cap exempt H-1B. Okay, so now for employers, another option they look at would be an L1 intracompany transferee visa. And the basic setup would be there's, and we work with a lot of startups. So typically for a startup, it would be a parent company with an office in San Francisco, maybe incorporated in Delaware, and it has like a wholly owned subsidiary, like private limited company in India. And there's people who've been employed at the Indian office for at least 1 year out of the last 3 years as managers or executives or people with specialized knowledge. And now the US office is transferring them over to be a manager, executive, or person with specialized knowledge in the US. So you can come for up to 3 years initially, or 1 year if it's a new office. You can get 2-year extensions. The L1A can be extended up to 7 years. The L1B can be extended up to 5 years. And the other really cool thing about the L1A for managers and executives is that it provides a path to the EB1C green card pathway, which is the fastest. EB1 is the fastest green card pathway. So if you're from India and you don't qualify for extraordinary ability yet, it can be very helpful to get that EB1C approved as well. Now, the O1s are also very popular right now. It's typically a 3-year initial petition for extraordinary ability. And then beyond the first 3 years, you can either get 1-year extensions or new 3-year petitions, can be renewed indefinitely. If you are from India, you get a 5-year multiple entry visa in your passport. The O1 visa interviews are usually pretty fast. To qualify for an O1, you need 3 of the 8 categories that are pretty well established. So that could be like awards, people writing about you. What did you create or invent? Are you a leader? Are you a member of organizations that are hard to get into? Are you a judge of who is an expert in your field? Are you an author or a speaker? Have you earned a high amount of money relative to your other people in a similar role in your geographic area? So these factors can be mixed and matched. You can do it if you are a founder, a researcher, an engineer, a TikTok influencer, an inventor. We just mix and match the categories in different ways. And the other cool thing about the O1 is you can be self-employed, you can have multiple streams of income, you can have one job at an employer, you can have many projects. So it's a very flexible thing, although the drawback would be that your spouse does not automatically get a work permit. So just various factors to keep in mind. And I am absolutely here to help, and we'll be sharing my contact information more, but you can always reach out to me and my firm at alcorn.law. And my book, Ask Sophie, is available on Amazon and Audible. And okay. So there we go. That is the overview. And I'm so delighted now to ask questions, to answer questions or chat or anything else that would be helpful.
Thank you so much, Sophie, for that wonderful presentation, I would say. And you made it so much clearer with all these slides you had to provide for us. So
thank you.
Really happy to have you. All right. So was good. And I'm sure folks already have questions I can see, actually. So Rocky Berman, thank you so much for your questions. Raja Shaker, hi, thank you. Just stay with us. We will take up your questions. And absolutely great. So far, so good. So a lot of things going on. I mean, as far as immigration is concerned, and with the elections coming up, I think everybody, they have questions in their head. What is going to happen if Kamala Harris is going to be selected, or what is going to happen if Donald Trump is going to be selected? What do you think? What do you have to share with our folks out there?
It's been such a roller coaster this year, and I'm always like recalculating what the immigration landscape will look like. Okay, here's what I can say about both as it stands now, not knowing what the outcome will be. So first of all, we've had a lovely 4 years of this Biden administration from an immigration perspective. We got out of the COVID backlogs. Consular processing is back to decent times for most countries around the world. Premium processing is available for more cases. The online lottery, H-1B system's working. So there's been a lot of improvements. And also for startup founders, international entrepreneur parole is now another option as well. If you get, the levels are about to increase, but say you get $320,000 of investment from a U.S. angel or VC investor, that could qualify you for our equivalent of a startup visa now. So all those things are wonderful improvements from this Biden administration. If there is a Republican administration, what we saw during the last Trump administration was the Muslim ban, high levels of RFEs for H-1Bs, stopping H-1Bs for computer programmers, litigation about H-1B third-party contractors, slower processing times because State Department officials were leaving their consular posts. The whole system got slower, and there was more friction. That being said, one of the things that former President Trump mentioned on a podcast with some venture capital investors a few weeks ago was that he's actually in favor of a proposal that Hillary Clinton originally came up with, which is essentially like the staple the green card to the diploma sort of idea, which is like, look, if you're smart enough to come here and be enrolled in our universities on an F1, you should theoretically have a path to a green card and citizenship. So what that looks like, I have no idea in practice. I think if there's a Republican administration, it would take some resolution of the US-Mexico border and asylum situation that would need to get clarified before anybody's going to move forward on high skilled. But if that's in place, high skilled would become very easy. If it's a Democrat administration, like under Harris, for example, I think we'll see general similar positive trends to what we've seen for the last 4 years, but she's also very different. And she might have, I mean, she's been focusing very intently on the southern border, on getting investment into Latin American countries to try to create more economic abundance there. So there's less migration flows to the US. So her stance on high skilled is probably slightly different. Maybe she'll be more proactive, but in general, I think the Democratic Party wants to see an increase of high skilled, even for example, making O1s and EB1A and EB2NIW self-petition green card pathways more accessible. So that's my analysis now. Now, depending on who either of them hire to actually implement their campaign ideas, then that's like a completely different thing as well, because remember President Trump was kind of like pro high skilled. He wanted a skills based thing like Canada and Australia when he ran before, but then the person he put in charge of immigration had very different perspectives. So well, I don't know.
So true. And there are things changing. There's still a few more months, so anything can happen.
Yeah, anything. It's going to be a wild ride in the reality TV show of American politics for the next several months. But in general, what I've been telling people is, if you want to move here and you're eligible now, like, don't dilly dally. It would probably be a good idea if you qualify to just get it done now, and then at least you're in line, in the queue, waiting, and then that would be an advantage for whatever happens in the future.
Yes, just keep your game up. I think, see what chances you have and try to put your game up. I think, that's how it always works. All right. Thank you, Sophie. That was very nice and good to know your views on this as well. So let's get back to our topic and let's get back to the questions folks have for us as well. All right. So let's take let's take this one from Rajat. Rajat is asking on YouTube. If someone is selected in the first round of the H-1B lottery and their employer submits a petition, is there still a possibility that they might not receive a call for a visa interview from the embassy?
It would be very, very rare and unlikely. So typically what would happen is the employer had to submit the petition by June 30th. And the employer could pay for premium processing, but doesn't have to. So you could find out if they did. If they did, you should have already gotten an approval or a request for evidence by now, because it's been a month and they are supposed to take action within 15 days. If your employer does not want to pay for premium processing, then you are able to. So you can ask them to upgrade it, and you can, in that situation, you can personally pay the $2,805 to ask for premium processing. Once there is a decision, your petition will go through the electronic system to be transferred to the State Department. And then you should be able to schedule your visa interview at a consulate of your choosing based on the available processing times of the different consulates, which fluctuate a lot. And then you go for your visa stamping interview. And usually the visa is granted pretty directly after that. There is a situation called administrative processing where the government can do additional background checks or look at the company that's sponsoring you, or maybe there's maybe your name is similar to somebody else's, so they have to disambiguate your background check with somebody else's. So that can take a long, indeterminate amount of time, but that's extremely rare. So in most cases, but you don't just randomly receive a call for a visa interview. You have to work with your employer and your immigration attorney to proactively schedule the visa interview. It's not just going to magically happen. You have to take action.
Right. Plus this year, I think it was very beneficiary centric. So only employers or people who were registering for the folks with H-1B, only they get to see what the status is, right?
Yeah, the employers are responsible for the process. So they create the online accounts, they put their candidates into the system. Exactly. So you need to be kind to your HR person so that they're willing to share information with you. Don't annoy them too much.
For sure. So, but anyway, I mean, a call, if it ever happens, it's only going to go directly to the employers, right? Not to the
Yeah.
person.
The employer has to check the online system to see if there's been an
Exactly.
update and to see if you've been selected. Yeah.
Right. Thank you. Thank you, Rajat, for your question. I hope that's pretty clear now since Sophie has answered that. Should we take up another one, Sophie, from the
Let's do
audience?
it. Let's do it.
Okay. This is from Pedoju. Filed
Okay.
H-1B with my PG from India, post-graduation from India. I want to know that my application will be in regular pool only, no? Yeah.
Probably, yeah, because the U.S. master's cap is for people who got an advanced degree from a qualifying. So, like, if you had a master's degree from the U.S., you would go into the master's cap. But if you have a master's degree from India, you would go into the regular cap. But everybody in the world is going to be included in the next round, in the second lottery round. So you should be included in the regular pool now.
Okay. All the best, Peduju. I hope you make it. Let's take another one. This is also from YouTube. This is from Rag. Heard elsewhere from Sophie that L1s are heavily scrutinized and not encouraged to jump into. What do you have to say about your own comment,
Thanks for
Sophie?
holding me to task, Rog, and thanks for listening to various things I've said in the world. I'm trying to make this more accessible for people. This is something that fluctuates a lot. So I would say recently we've been quite successful with L1s. Sometimes there's trends in the immigration lawyer forums where it's like, what the heck? They have 10 employees and there was still a horrendous RFE. So I think it just fluctuates, but really the principle that I would take away from the last few years from Republicans and Democrats alike is if you want to get an L1, you need to have like a functional company abroad that's going to keep going without the person who's transferring to the US. That organization, let's just say in India, needs to have employees, a revenue stream, growth plans. If you're the sole employee in India, you're not going to be able to transfer to the US. They want to see that you're supporting a multinational growing business. Now, the smallest possible size for the foreign employer, I think that we've gotten it improved with like 5 to 10 employees to transfer an executive to the US. So it doesn't have to be that big, but it should still have a presence. And then you should be able to withstand any L1 scrutiny. I think that's my current approach.
Thank you so much. And Rag, I'm sure you are a total immigration enthusiast. I mean, really good to have you back on our show because I remember you from yesterday's show as well. So thank you, Rag. And yeah, thank you for watching Sophie and her comments as well. Sophie, you're watched, so be careful.
I know. I go
All
to
right,
coffee
so-
shops now in the Bay Area, and when people I'm like, I don't know if you're recognizing me or if you're just looking at me. I don't know. But if you see me in
I'm
real
sure
life,
people
say hi.
recognize you. And you
What's
just go walking around like that? I'm sure they
Uh,
recognize you. I mean, from your book, from your
I'm in the heart
podcast.
of Silicon Valley, and so now I'm like, I don't know.
Yeah, wow. You will meet, what do you call, people are, I mean, your, what do you call them? Who will have to look after you?
Oh,
Oh, gods, like not gods. There's another word. I'm so sorry.
Security
That's
guard.
just slipping out of my mind. But yeah. All right.
Need a
Let's
bouncer?
take this
No,
one
no,
from
no.
Rocky. Yeah.
Okay.
Heard about H-1B exempt visas, but I'm not sure how they work. Can you tell me about the advantages and disadvantages of pursuing H-1B exempt status for my company and how it
Absolutely.
differs from regular H-1B visas?
Yeah. Thank you.
This is a long one.
And thank you, Rocky. This is a great question. So I mentioned it a little bit in the presentation. The disadvantage of pursuing cap exempt H-1B status is it takes time and money. And so if you get somebody selected in the lottery, overall it's cheaper, but it's just risky because they might never get selected. There's about a 25% chance. So if you have a company and it's like a for-profit LLC or corporation or something doing business with revenue, for your organization to become cap exempt itself, you would have to like incorporate a new 501c3 and have revenue there and like set up a whole additional company. Most employers don't want to do that. Most employers would work with one of these nonprofit affiliated with universities institutions to do the cap exempt H-1B sponsorship for their employees. And so that's worked very successfully for candidates around the world, for my clients for years. And there's different organizations springing up with different price points to do that and different offerings. The drawbacks of working with them are you're paying another organization to employ your candidate for several hours a week. Your candidate has to do other stuff that fits with the educational nature of the nonprofit, like training American students on an internship that they have. But you can set that up to be beneficial for your company and have a domestic talent pipeline as well with, students who are familiar with the work you're doing. So your employee, has some additional obligations they need to maintain during the whole course of the H-1B, or until they get selected for the lottery, or until they get a green card. But if you're, if your organization has cash flow, and if getting somebody to the US is important and urgent, and if that person is not otherwise qualified for like an L1 or an O1 or some other type of visa, and if you don't want to go through the pain of trying to organize a part-time TA-ship with an H-1B at a university yourself for your candidate, I mean, these are wonderful cap exempt organizations that can help you get somebody to the US working with you in person in like 2 to 3 months with very little risk. So from that perspective, it can be worth it. It's a different cost benefit analysis for every employer. So.
All right. Thank you so much. I think that makes it very clear. I mean, to Rocky, thank you so much, Rocky. Very interesting question. And Sophie as well for taking that up.
Thank you.
Moving on, I think we will take up your questions, folks, but I think now it's time for a short break. So if you have questions and want to contact Attorney Sophie Alcorn directly, why not call her in this number, 855-644-2581, and you can email her hello@alcorn.law. That's how you can get in touch with Sophie Alcorn. She is also the founder of Alcorn Law and a best-selling author. Thank you so much. And definitely go visit www.alcorn.law to get to know more about Alcorn Law. And thank you, folks, for being here. Don't go anywhere because we're going to definitely talk more for the top visa options out there for you. So stay with us here on Immigration and Jobs Talk Show. This is Nipasa Pradhan with Sophie Alcorn.
Thank you so much.
IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we are discussing on this topic, top visa options for employers for a quick hire, H-1B versus H-1B exempt versus L1 versus O1. And this is the second episode with none other than our guest for today, Sophie Alcorn. So good to have you, Sophie, once again. And welcome back to this second half of this webinar. I hope you're having a good time.
Thank you so much. I am. I love all the questions, and it's so great chatting with you about all this. So thanks for the opportunity to be here.
Thank you. It's truly an honor and a pleasure to have you. And folks out there, for those of you who have been seeing Sophie and you know that she's a familiar face, let me tell you a little more about her. She is Sophie Alcorn, the founder of Alcorn Immigration Law, and has been recognized as the top 10 immigration attorney in the state of California. And she also is the host of the Sophie Alcorn podcast and the author of the best-selling book, Ask Sophie, The Founder's Guide to Visa and Green Cards. And maybe, Sophie, would you like to tell us what sorts of things do you discuss in your podcast, maybe, and how's it going?
Sure. Yeah, the podcast is really fun for me, and I hope everybody subscribes and listens. I will put the link in the chat window so that you can find it on Spotify and Apple Podcasts. But it's a weekly podcast, and it's about everything I am interested in. So definitely subscribe. It changes all the time. Most recently this year, and the archive is, I think, a tremendous resource because I have over 100 episodes on what is an H-1B, what is an O1, what is an L1, how do I get a green card, how do I consular process, what do I do with an RFE. So I did that for 100 episodes. Then I wanted to change it up. So recently I've been interviewing people. My most recent nerd fascination is outer space immigration, which I think as a planet we need to prepare for the future.
Wow, that's very exciting and futuristic for sure.
Yeah.
So can you tell us more? That's totally out of the box, so out of this world.
Out of these, absolutely. I've been interviewing space law professors, space startup founders, former fighter pilots, people doing intellectual property law for space tech. It's fascinating stuff, and it's really brand new territory. And I just want to make sure that when we have hotels in space and a moon base and people are going to Mars, that we have a clear, clean, wonderful immigration system that allows people to effortlessly go between the Earth and other destinations. And like that kids born in space will have a citizenship after multiple generations so they can come back, right? This is like far-fetched sci-fi, but I love it.
Me too. You say it sounds exciting, and wow, yes, we're going to have some immigration law for space too, for sure.
Yeah, I would love to be in the room and help write the treaty because the law is super antiquated, I figured out, and people who, like, technically, if you send something into outer space, it's still the property of your country. And if it lands back in your country, it's like it never left. But if it lands in somebody else's country, then there would be immigration and export. But if you're just like on the moon, you're still in the US or in India, if that's where you left from. But you can't own property in space. You own your equipment, but you don't own the surface of the moon. So it's super confusing. And there's like a lot of legal concepts, like if you have a slip and fall in a space hotel, do you have to take it to the UN, or is there some like private right of action? So I'm just fascinated. I want to help with this. Now for the fall with the podcast, I was just at the Capitol yesterday in Washington, D.C., and I've been really involved in conversations about artificial intelligence and bringing startup founders to the US and helping people to be able to innovate these new technologies. And so for the fall, my focus for the podcast is going to be talking to bipartisan lawmakers, former members of Congress about prospects for high-skilled immigration reform, because it's something I'm really, really passionate about.
Very nice, very nice. And talking about AI, it's taking over so many spaces, workspaces, whether it's media or any field for that matter. So you have to say a little bit about artificial intelligence as well.
Oh, God. Well, it's affecting everything. And if people don't know it yet, then maybe have a look, because it is happening. And it's one of those things that's like happening exponentially. So it's like oh, doesn't matter, doesn't matter, doesn't matter. And then all of a sudden it's like, oh, wow, it matters. It's happening. And there's huge potential for innovation in the field. And, it's even going to affect like our power grid to have data centers that can actually, run all of these LLMs and different like GPUs and LPUs and all of that. So there's a lot of like logistical and infrastructure opportunities. So if anybody wants to, this was my learning yesterday, knowing about AI and electrical engineering with the power grid is like a job of the future that will be very, very important in the United States, definitely in the national interest. So there's like new opportunities like that coming up all the time. And Biden's executive order very much promotes AI as well as any other critical and emerging technology in the national interest. So if you want to pursue one of these fields, there's funding, there's visa and green card opportunities. Like we want you here. And there's a lot of potential for what you can create that can help the world.
So folks out there who are still fortunate to be a student maybe so far, I think you can think about pursuing something with artificial intelligence, because I think that is the future for sure.
Absolutely. And it's not even just artificial intelligence, which is the other interesting thing. And I'll provide this link to your team.
And it's not just future. I mean, it is happening already.
It's happening now, but our government isn't just interested in AI. It got all smushed together in the AI executive order, but it's advanced computing, advanced engineering materials, advanced networking, AI, biotech, clean energy, data privacy, cybersecurity, autonomous vehicles, human machine interfaces, quantum, semiconductor, space tech. So there's actually a lot of really, really exciting opportunities for careers.
Sure. So thank you so much, Sophie. I mean, that was very enlightening, and I'm sure folks are going to be more interested to get to know more about this. So don't forget to check out Sophie Alcorn, folks. Her, information is scrolling on the screen. You just note them down. And we will go on to the questions now because we just have a little more time. And Rag, who had questioned us earlier, has more questions for us. What documents should the employer periodically submit to the USCIS during the L1 visa holder's tenure?
Great question, Rag. There's no like random compliance checks where you just have to send in information as an employer, but they will evaluate everything on the renewal, such as the extension. So at that point, you're going to need to be able to show that your company is still doing business, revenue, tax filings, your org chart, that the job still exists, that the person's been working there, that you've been paying them properly, if they've, been growing in their career at all or their responsibilities. All of those things are super helpful to show.
Thank you so much, Rag, for your question again. And Rag says that he liked the NVCA podcast of yours. Very nice.
Thank you. Appreciate that. That was a fun one. The National Venture Capital Association is a really great organization. They actually litigated to keep the International Entrepreneur Parole Program, which is like our startup visa, to keep it alive. And it's been really great working with them. Silicon Valley investors are very interested and motivated to keep immigrant entrepreneurs coming to Silicon Valley. So there are supporters for immigrants who are very vocal and who definitely do a lot to help.
Lovely, lovely. Thank you so much for sharing that as well. And thank you, Rag. Like I was saying earlier, you totally are an immigration enthusiast, and it's lovely to see that you're following up. Thank you for joining us here. Yeah. Let's move on to Raja Sekhar. H-1B visa petition was selected in the initial lottery, but the employer is now facing financial difficulties and may need to withdraw the petition. If we withdraw the petition, can we still participate in the second lottery, or will that impact our client's eligibility?
Withdrawing the petition will remove the beneficiary's eligibility. So it would be really lovely if this employer could maybe just wait a few weeks to see if this person is chosen in the second lottery before making any sudden moves. If so, an H-1B, let's just pretend this person gets selected. The H-1B has to be filed in good faith. So if the employer is having financial difficulties, and really would never hire this person, they just shouldn't file it. If they're having financial difficulties, but they would still love to have this person work on October 1st, but they just don't know if their financials would qualify, it might be worth it to move through with the petition. Maybe the person will get selected. And, if they have to fire you because they can't pay you after October 1st, at least at that point, you would have, approved H-1B petition, you would have been counted against the lottery, and then you could try to do an H-1B transfer to another employer.
Mm-hmm. Thank you. Thank you for taking that up. I'm sure Raja Sekhar is very happy with your answer. All right, let's take up this next one. This is from Ankit. I have heard that O1 visas are a great option for hiring top talent quickly, but I want to learn more. Can you explain the eligibility requirements and application processes for O1 visas and how they differ from H-1B and L-1 visas?
Great question, Ankit. Absolutely. So in one sense, they're all visas. There's a petition with USCIS. You can pay for premium processing. USCIS will make a decision. Once there's an approval, you go schedule a visa appointment. You get a visa in your passport. You come in. You do the job you said you would do. So they're all similar in that respect. But who qualifies is very, very different. So the H-1B, super straightforward, bachelor's degree or equivalent, company that's offering you a professional job that has the ability to pay you. That's that, super easy to get through. The L1 is like, hey, you've been working for us abroad for a year and we got to transfer you here now to help run things in the States. The O1 is a different beast. It's saying, hey, Ankit is the very best XYZ, the very best AI enterprise SaaS AI startup founder of India, focusing on helping the healthcare vertical. And now, because he's so extraordinary in India, we want him to be able to come to the US to do XYZ, whatever you want. Start a company, get a part-time job, get a full-time job, be a consultant, do all of those things at once. So the O1's very different. It's like, hey, we already know you're the best at something in your country. So come on here, tell us what you're going to do, but you can basically do anything you want as long as you get pre-clearance for that and set it up in the petition. So there's a lot of flexibility. It doesn't have to be from your home country. You could be famous in a third country. You could be famous in the US. And what famous means is very, there's a lot of grace within that standard. So if you think that you even might have 3 of the 8 criteria for an O1, whether you're a researcher or a TikTok star or like an entrepreneur, at least get an assessment from an attorney. We'll do that for you because it's a really great option. If you're not married or if your spouse doesn't need to work, it's a really, really great option because you have a ton of job flexibility in your field. It's basically like having a work permit to do whatever you love. So definitely would encourage people. And the other critical thing I just want to mention is you do not need to have an employer to petition you. You can also have an agent. And this is something we copied and pasted from Hollywood where movie stars have agents. Now we're doing that for Silicon Valley clients where software engineers have agents. So that's the method by which you don't have to have just one job. We can include an itinerary of your services. You can have projects come and go, consulting work, startups, all of that. So if you don't, you could even get the O1 first through an agent, through a subset of jobs, and then go to I don't think big tech likes to hire people with O1 agents, but they could just transfer your O1 to them. Or a small company would be like, oh yeah, you can just work part-time for us. Great. We don't have to do your visa. Great. So it's a really wonderful option.
Yes. And like you were saying, I mean, especially if you're talking about famous people, it's not like a one-man band or anything. I'm sure they'll have managers, they'll have people who make them who they are, makeup artists or Dress up
Yeah,
artist.
yeah.
I don't know.
I had one guy at a big tech company that was like, "Do you think I qualify? I've written like 40 letters of recommendations for my direct reports and they all got extraordinary ability, but can I qualify?" I'm like, "Yes, sir. You're very, very qualified." So there's lots of different
Yeah.
ways to qualify.
Right, right. And then there's also the P3, right, which is pretty similar, a little different.
Yeah.
That
Yeah.
also, so, but Ankit, I would just say it's always best to consult an attorney where you tell them your whole case, your whole situation, and they can guide you best where you fit. So,
Absolutely.
yeah. All right, let's move on now. We have another question. This is from Afreen. Is there a minimum salary for a job in H-1B status? What status would my spouse and children have when I am granted H-1B status? Also, I want to know in details how concurrent H-1B visa work.
Okay. There is a minimum salary for a job in H-1B. It depends on the job, your level of responsibility and experience, and the geographic area. It is the employer's responsibility, working with the immigration attorney, to calculate it's called the prevailing wage for your job. So there's a government website. You can do like a government wage search on the FLAG Department of Labor website to try to estimate it, but it's part of the legal process to figure it out. The spouse and children of an H-1B holder have H-4 dependent status, which does not automatically authorize spouses to work, but everybody can be here with you. Kids can go to school. They're considered your kids till they're 21. And then how does the concurrent H-1B visa work? Well, the two programs that I'm aware of right now, one of them, they both involve your employer's participation. So really you should have your employer reach out to my law firm to figure out how to support you. But two of the programs I've worked with, the more established one is called Open Avenues Foundation. They have the Build Fellowship. And the new one is called the Parachute Project, and they have different pricing models and different requirements. There may be more out there as well, but those are the two I've heard of.
Lovely. Thank you, Afreen, for your question, and Sophie as well for taking that up. All right, we have Ankit again. Another question. Can I sponsor an employee for an O1 visa if they are already in the US on a different visa status, such
Absolutely.
as an F1 or J1? Yeah. Okay.
Yeah, that's just called a change of status. And then if they want to go for a stamping interview for the new O1 petition, they can schedule that. But that's very straightforward as long as they're maintaining valid F1 or J1 status. The exception is if somebody is subject to the 212E 2-year foreign residence requirement for their J1 because they got government funding or a Fulbright scholarship or something, they're supposed to go back home for 2 years after their J1. But even if they are subject to that 2-year requirement, they can still qualify for an O1. They're just not eligible for a change of status. They have to go back in consular process to activate it.
Thank you. Thank you for taking that. All right, this next one, this is Nirlip. He has two questions. We'll take this first one first. Can I sponsor an employee? Oh, this is the same one. Sorry. Are there any specific requirements or procedures for converting their status to an O1 visa? And how will it impact their stay in the US?
Yes, it is a specific process. So you have to meet the O1 requirements. You have to do the O1 change of status petition. If you have selected a change of status to O1, when their I-797 approval notice comes, it will have the start and end dates for the requested O1 status, which will take effect automatically when they're in the US on that date. So this becomes their new I-94, and they will have a new date by which to leave the United States.
Okay. Thank you. Thank you for your question, Nirlep. And thank you, Sophie, as well. Rag also says thank you. Thanks, Sophie and Ipasa. So sweet. Thank
You're
you.
welcome.
Thank you. I think we have covered most of our questions, but just in case if I've missed anything, let me just have a look. Yeah, I think that is. Oh, we have this next one. This is from Esther. What can be like a hindrance for your H-1B petition filed? How long does it take to get a response from the USCIS currently?
What can be a hindrance? Well, you have to meet the requirements. So if the government wants to scrutinize the employer's ability to pay you, or if they are concerned that it's not a specialty occupation under the laws about if that job role qualifies, they might issue a request for evidence. If they're concerned whether you've been maintaining your status, they could ask you for more documents. So those are some of the common requests for evidence triggers. Now, how long does it take to get a response? It depends on if you have requested premium processing. If you did, then it's 15 days to get an answer. And if you didn't, it's usually many months. Let's check this out. I'm just looking at the USCIS case processing time website. So if you are being sponsored by an employer in California for an H-1B to be issued abroad, then, and if you don't choose premium processing, they're going to take 6 months to make a decision on the petition. So most of my clients proactively choose premium processing every single time because they can't wait around for this. But it's a range depending on where you are, where the company is, when you filed it, but it's usually many months. But you can always upgrade. If your employer didn't want to pay for premium processing, you can be like, hey, let me pay the $2,805 myself, and then you can get it done.
There you go, Esther. I think you have your options there, and all the best. It should work. Yes. And thank you so much. I mean, I think with this, we can wrap up our show for today because I think we've covered most of our questions from the audience, and it was a lovely presentation, making things so much clearer for us. You know, today we spoke about top visa options for employers for a quick hire, and of course, the different visas. Thank you so much, Sophie. And maybe before we go off, if you could just give an end note to all our audience out there, and yeah, that'd be great.
Absolutely. Thank you, Nipasa. Well, this was really fun, and I love everybody's questions. And thank you for those folks who have been following my work. I really appreciate it. That always feels great to hear that I've been able to help you and maybe make a little bit of a difference in your life. So that's super exciting. In summary, I just want to end on a positive note because I feel like people don't realize how much power and control they have over their immigration destiny. So like if you have a burning desire to move to the US, to live here, to get a green card, yeah, you can do it by, 90 Day Fiance, marrying somebody, falling in love, probably fall in love first and then marry them. You can do it by getting a job. Those are very unreliable. So I built my practice on people who are self-petitioning their own way. And that way, whether it's an O1, whether it's an EB2 national interest waiver, I-140 self-petition, followed by an upgrade to like an EB1A for extraordinary ability to fast track your green card. Like I've really built my practice on helping people take responsibility for their immigration into their own hands. And I just want to encourage everybody, like it is so wonderful when you have a kind employer who respects you and who wants to help you through this journey. That's like the best. But if you don't have that yet, you don't have to just like wait around wondering. You can actively build up your profile to qualify for many types of options. So I just want to give you that note of encouragement and hope that this is actually within your control, which surprises a lot of people. So, so thank you for that opportunity, Nipasa.
Thank you so much. Really, I mean, you're giving us a different perspective, and absolutely nothing better than depending on your own self, who you can trust entirely. So why not?
Exactly.
Thank you. Thank you, Sophie. It was really wonderful to have you. You have a great day ahead, but I would really love you to join us once again. So I will look forward to that.
I would love that anytime. It's so fun chatting with you. Thank you for doing this. And thank you to your amazing team.
Thank you.
Okay. Bye-bye.
Thank you. Yay. Awesome. Bye-bye. Have a great day. And folks out there, thank you so much today. It was really lovely having all your questions as well. And thank you. Sophie, you were amazing once again. Let me tell you that. And folks, feel free to contact Sophie. Her Number is 855-644-2581. And you can even email her hello@alcorn.law and visit her website, www.alcorn.law.com. Sorry, www.alcorn.law. That's her website. And thank you, friends. You can even contact me. And if you're looking for a project placement, H4, green cards, anything related to immigration or jobs, feel free to contact me as well. My number is 408-335-6444. And my email address is nipa@hirightpeople.com. And visit our website, www.hirightpeople.com, to get to know more about us. For now, this is it, but definitely stay tuned to our space. Our handle is Immigration and Jobs Talk Show. Don't forget to subscribe to us, like, share, and also look out for another webinar that I'm going to be joining you with, another guest, and that's going to happen at 2 p.m. EDT. So look out for that. Thank you so much for joining us now, and have a great day ahead. This is Nipasa Pradhan signing off from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. So good to have you back. And I'm very excited to have another session now because this is going to be a little different. I'll tell you more about it. But before I go to it, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Friends, I am Nipasa Pradhan, and I'm going to be your host for this session today, which is going to be very interesting and different, like I was telling you a little earlier. So, we are going to be joined by not only, if you can see our topic for today, it is F1 visa approved after 221G refusal and a student success story. So, it wouldn't be complete without the student himself joining us. So, definitely, we are going to have Karan join us. So I think let me just introduce you to Karan and our guest for today. So without further ado, please help me welcome Yvette from Udeti, visa expert, and also Karan. Thank you so much for joining us, both of you.
Yeah, thank you for having us.
So good to have you. So Yvette, you've already met her earlier, and she is a visa expert currently with Udeti and ex-US consular officer. So it's really good to have you with us, Yvette, after a real long time.
Thanks. I'm really happy to be here. Excited for this story.
Me too, me too. So how is it today to see Karan maybe after a while? I think you're seeing him today, is it?
Right. So Karan had a 221G refusal, and we worked together to face the subsequent visa interview. So it's been a little bit of time since we connected, but I really liked his story, which he'll tell. And I thought that viewers may also benefit from his journey, the time spent in the United States, especially how he navigated things.
Absolutely. So, friends, Yvette is former US diplomat and founder of Reddy Visa. And if you want to book a consultation, you can already see on top of the screen that you can use IT people to get a 15% discount. So, let me tell you that already before we go on ahead with our session. Also, our guest, Karan, very good to have you. You are going to be one of the first, who is going to be here to share your story with us, your success story. So I'm very excited for today's session. And Karan is a student who faced significant hurdles, and he emerged victorious on his journey. So we will unfold the story as we get to know him better. But I think, yes, Karan, we would love to know you more. So where are you from? What do you do? How you got into thinking of studying abroad even? And yeah, let's get to that first, at least.
Yeah, thank you again. Thank you for having me here. And then thank you, Yvette, for thinking about this and just bringing us all together. So happy to be here. So yeah, my story actually goes back to like when I was in my 10th standard, like just like any student, I was pushing hard to get good grades, like trying my best to like make sure that I'm like doing everything I can from an extracurricular standpoint, but also in classes. But to everybody's surprises, I actually ended up like getting the highest score in my
Mm.
entire like district and also my school. And honestly, for me, like that was a really big confidence booster, because I always knew that I had it in me, but I didn't get that backing from other people, and also just like nobody really had that support to my end until I actually did it. So I feel like 10th standard was kind of like when I was like, okay, I can do anything I want. I'm able to like accomplish anything I want to do in my life. And then just getting that boost, whether it's from my marks or like from the boards, like just in general, I thought that was a pretty big confidence booster. So after that, I
Mhm.
went ahead and like studied, finished my high school. As I was like graduating from my high school, I realized like I'm very interested in like working with others. Like I really enjoy engineering and also enjoy like just computers in general. But that
Mhm.
at that point I was thinking like, okay, what should be the next move for me? Like if I want to like go study in India, if I want to study in abroad. I looked into a lot of different options, and actually one of my seniors in my school ended up applying to a US university. And at that point in Punjab, so I come from a very small town in Punjab near Jalandhar. So at that point, like most of my friends were like looking into Canada or UK or other countries. But I always knew that US is the place where you get the best education, the best opportunities, and also just um, knowing so much about the Western culture, I was always intrigued by it. So I think just like having that senior who applied to the US university really helped me figure out kind of that path. So once he did it, I talked to him and understood like what it takes, like what are the exams you gotta take, like SAT, ACT, how do you build your profile, how do you write your essays, the recommendation
Mm.
letters, and all of that stuff. And then after actually my 11th standard, I started preparing to just apply for my undergrad in the US. So before I even finished my high school, I already had like admits from some of the top schools in the US for my undergrad. And then after a lot of different factors that went into my like decision making, I ended up going to Miami University, and I did my bachelor's in software engineering with a co-major in business analytics.
How interesting and how inspiring. Very nice. And you were so focused already from a very early age, and you just knew what you wanted to do. So I think things were much clearer for you in your head, and therefore much easier to proceed, I guess. But lovely, lovely. I mean, to get to know more about you, and also that, coming from a small town in Punjab, Jalandhar, and then, pursuing an F1 visa at Miami University. Maybe you could tell us about some of the key challenges you faced initially. But before that, maybe how did you get in or come across Udeti? And how did you think that you want to pursue consulting about your visa with them?
Sure. So I actually got to know about Udeti very recently when I was applying for my visa renewal for my master's program, which is at Northwestern. So I went to Miami University. I graduated in 2021, and then I worked in the US for 3 years. And then recently, I came back to India to renew my F1 visa, and I'm going to be pursuing a master's in at Northwestern. So I got to know more about Udeti actually two resources. One of them was like another YouTube channel, and I saw a similar video where people talked very highly about Yvette and Udeti in general. And then somebody in my network from New Delhi recommended Yvette and Udeti's services to me. And I feel like that just 30 minutes of conversation with Yvette and just knowing more about Udeti just really changed my visa experience, and just gave me that boost that I needed when I was like actually appearing for my visa interview. As Yvette started, like I had a little bit of a unique case. So for me, I was just looking for that confidence, honestly, just somebody saying that it's going to work out, and just somebody knowing that my case is a little bit unique, but it's not like something that's impossible for me to actually end up getting that visa. So long story short, I talked to Yvette and I went for my visa interview, and I ended up getting my visa approved. So it was a very, very beautiful, stressful journey that ended up being a very happy journey. So I'm really happy to be where I'm at and looking forward to joining Northwestern soon.
Very great. Me too. And Yvette, what do you have to say? What do you have to say about working with Karan? How was the whole thing? And yeah, after that, I'll ask my second question.
Right. So Karan, obviously was very motivated, ended up going to Miami University in Ohio. And then after that, he will talk about the time he spent on OPT. So when he went for his visa renewal, the consular officer has noted that he was in the US for undergrad and then OPT. That's quite a long time. So that's why the consular officer called him in for a interview. And you always have to be careful when you go into an interview after spending such a long time in the United States, and just not be nervous and be prepared. I think that he had a good shot, regardless of who he consulted with, because he was going to Northwestern. However, you can never be too careful after spending so long in the United States. So he just took the extra step of preparing. His answers were quite good. But I just helped him clarify them a little bit so that the consular officer understands his journey very quickly, and that there's no obstacle for him to get that visa renewal. So that's a little bit from my end, but I'll let him continue on his journey in the United States. I'm sure our viewers have some questions about that too.
For sure, for sure. But before we get to them, maybe if you would like to talk about a few common reasons, why maybe students like Karan might face like a 221G during their F1 visa renewal, even after, having a strong profile.
So if you were in the United States and you were going for a renewal, and there is a clear reason, for example, on your I-20, it mentions that you have an OPT employer and you're going for a renewal during an appropriate time frame, like they just finished their master's program, they just finished their bachelor's program, now they're going for OPT. I can see the progression clearly. Most of those applications will get approved. But in Karan's case, he went to Miami University, did OPT, and was trying to go to a completely different master's program. So it required more of an explanation. It was a more unique situation. So you get called in for an interview when you submit for interview waiver. If there's any question about your case, it doesn't necessarily mean that you're going to get refused or there's a red flag. You can get called in if the consular officer even has a slight question. The question could be, I wonder what his grades were in undergrad, because I wonder how he used his visa. Did he use it well? I want to ask him. I want to talk to him. So maybe they didn't necessarily see any red flags, or maybe they did. But for 221G, any question, any even minor thing, the consular officer will call you in for an interview. They're not going to take any chances, and there's no way for them to get their questions answered without calling you in for an interview. And we can talk about a little bit more about 221G later, and even some questions that you could expect at the visa window Maybe Karan didn't get all the questions, but I can cover in more severe cases if the consular officer is approaching you with a lot more doubt. You never know. If the consular officer could be like, okay, you're going to Northwestern, awesome. Or the consular officer could really press you and want to know so much more. And so I can tell you those questions in a more worst case scenario. So we can talk about that a little bit later.
Cool. That will be very helpful, Yvette. I'm looking forward for that too. And my next would be for Karan. Karan, if you could just tell us, some of the key challenges you faced initially, maybe just to start off, and then we'll go on to a few odd questions from our folks out there who have dropped their questions. Thank you so much. Just stay with us.
Yeah, for sure. So again, as I said, like just coming from a small town itself, like you always have that like mentality of like being an underdog. So I feel like I always had that mentality, but I was always hungry for more. So as soon as I reached in the US in 2017, I kind of had to figure out like the culture. I was also very young, had to like get used to a new place. Definitely felt homesick a little bit in the beginning, but again, as soon as I kind of like got done with that whole mentality, I just went straight in, like heads deep into like everything that was given to me. Like so many different opportunities at Miami University of Ohio. So many different things that I did like while at school, whether it was like being a resident assistant on campus, supporting the well-being of other students on campus, being a teaching assistant, learning from the best at Miami University. Like going for different conferences, and I also just thought like there were so many different like challenges just like along the lines with like COVID. Nobody expected a pandemic in 2020, so I had to like figure out how do I stay safe and how do I like maintain my well-being. And then also as I was like going through my career and just like towards graduation, I was looking into like what do I want to do, what were the different like opportunities that I was interested in. But to be honest, like I feel like all of these different challenges just made me who I am. Like it really brought a different unique perspective together. Like I feel like I'm a very strong independent person after living in the US on my own for the last 7 years. Being away from family was definitely very challenging, but it really helped me kind of like be there for myself, and also just like making my own network. I
Mhm.
made a lot of different friends, a lot of like really really nice people came along my journey throughout the last 7 years. And then after just working and just studying, I just wanted to know like, okay, what's the next step in my career? So just applying for these graduate programs, getting into Northwestern, and then just having that mindset of like, okay, what's next for me? How do I keep on building and how do I keep on learning? But how do I also keep on growing in my career and my future journey? So I'm really excited to see where this takes me. And I honestly think challenges makes you who you are. So if there were not really any challenges, the journey wouldn't have been this fun.
Absolutely. Very well said. And with the right support and determination, I think we can all clear our hurdles. And just like Karan, he was able to continue with his academic and professional journey. It's really inspiring so far. So we will definitely keep unfolding his story. But I think we should quickly take up a question from our folks out there. This should be from Firstly, if it's fine. And do you think applicant who previously refused 2 years actually have a better chance securing F1, especially since time has passed and pushing the circumstances? Yvette, what do you have to say?
I would say certainly if someone is applying multiple times in a row, the chances of them getting a visa are lower and more time that has passed is better. But determining whether or not you have a better chance actually matters based on your profile and your overall circumstances. So it is better to wait some time before applying again if you have multiple refusals. However, it's not a guarantee of a visa. That really depends on your circumstances at the end of the day.
Okay. Firstly, thank you so much for your question. And I think you should definitely go Get a consultation booked as well, with Yvette if you want to have further questions. And don't forget to use IT people for a 15% off. Also, we have Yvette's contact details on the screen. You can note it down. And now let's take up Jatin. And Jatin is also asking, we'll just quickly take this one. Recently, a lot of officer got lazy. Okay. They do not want to approve someone who never travel abroad. Even their first question is about travel history. They want 18-year-old to travel far away. What do you think about this? This is crazy.
So, what you may perceive as laziness could be efficiency, but I can also see how you could perceive it as laziness. It could be considered laziness, but with 120 applicants a morning, adjudication expectation, consular officers tend to put people into buckets, and it's efficiency, but I definitely understand what you mean about laziness. It's very difficult to adjudicate these cases. There are marker questions. How many admits did you receive for F1 visas? What's your travel history for B1, B2? Where if you answer a certain way, you progress to a different question. So sometimes that first initial question could be a way to filter applicants by the consular officer. Travel history simply shows that you have a little bit of change to travel the world, which gives them insight into your finances. So that's something that they can see based on passport stamps and visas. And it's one of the only things they're able to see in terms of your finances because they don't rely on documents too much. So that's why consular officers look at travel history. I hope that cleared up a little bit for you.
For sure. Thank you so much, Jatin, for your question. And if you have more, you can feel free to keep commenting. All right. So let's get back to Karan. Karan, tell us more. 7 years, how does it feel? How did you, let's compare like Karan 7 years back and Karan now.
Yeah, I would be like, I'm definitely a very different person. So as Yvette was talking about like travel history, like when I was leaving for the US, like it was the first place I was ever actually traveling to, first time leaving the country, first time actually stepping out of my comfort zone. And then for me, like I was a very, very naive, very, very studious, very, very like to the book person, but I would say I'm still very much like that, but I also have a very different personality. Like I'm able to talk to people, I can connect to people, I understand the US culture a lot better. I know all about sports, like you can talk about Chicago Bears, or if you want to talk about any other football in the US. I'm also able to like learn and also just connect to people a little bit more, whether if it's about politics, global politics, any issues in the world. And for me, I feel like for my career itself, like just being in the US early on in my life was very beneficial. Like when I was working, just being in a corporate setting, being able to like present my views, being able to like present what I've learned in an undergrad degree from a top university was very much like well perceived in a corporate setting. And then just my overall track record has really helped me just get from a Miami University, which is still a great university, to like Northwestern. And then obviously for me, like sky's the limits from here. So I'm really looking forward to like seeing how I can keep on taking this journey to the next level. But I would say, yeah, like very different person, but I'm one thing that I don't forget is like I always gotta stay grounded. So my parents, my family, my support system is very, very good. So I'm really lucky and fortunate in that sense. And then for me, just being in India right now, being able to connect with my family and take a little bit break from my crazy career, my different opportunities that I was exploring. I think it's really, really nice to have this break in my life. So just really enjoying this and looking forward to what's coming up next.
Okay. And when you finally returned to India for your visa renewal, you were placed under 221G. Can you maybe walk us through it and tell us what the experience was like and how did you manage it?
Yeah, for sure. So yeah, as I said, I came to India in August of this year, and I did like a Dropbox visa renewal for my F1. So what I did is like I dropped off all my documents, my passport, my I-20, and it went to the Chennai consulate for further processing and approvals. So once that happened, in a few days after, like 2 days after, I got a notification saying that your visa was refused. So once I got that, I was panicking a little bit because I wasn't really sure what the word refused means. So I did a lot of research. I looked into Reddit, a lot of different resources online, and then from a bunch of research, I found out like that means that there's some questions that the visa officer has regarding my profile that they would like to get it clarified, whether if it's by interview or whether if it's by sending them further documentation to prove something. So I waited to get my passport back to my address, and then in a few days, once I got my passport back, it had a 221G slip in it, which said that I need to come in for a visa interview any day other than a Wednesday to the Chennai consulate. So I was literally in Punjab. I booked my flights the day after and flew across the country from Jalandhar all the way to Chennai the next day. And then I was like, I just want to get this done and also want to like make sure that I have everything in my control. So I flew all the way across the country to show up for my visa interview. I would say it was definitely very nerve wracking because for me, like I had everything figured out, but this one visa stamp was the last thing that I needed to do. And also just thinking about like everything that I have done, all the struggles, but all the good things that have come into my life in the last 7 years and all the good things that are coming up. So I was definitely a little bit nervous. So I think Yvette and Udeti's services were very, very beneficial there. Um, as she said, like just being able to like articulate myself into like what do I need to say when a visa interviewer asks me a question and just making sure that I answer the question to the best of my capabilities. So I think that was the number one thing that I needed to work on. And I just got that boost in confidence after talking to Yvette and Udeti. So for me, that 30 minutes really, really changed everything. And then in the morning, I went to the Chennai consulate, went for my interview, and it was definitely very nerve wracking because there were so many people and everybody going through the same scenario. But for me, I was always confident and already confident because I went through a similar interview for my F1 back when I was doing this for Miami University. So I had that confidence that I know what questions I'll be asked, and I had confidence from Yvette. So pretty much I went all in and was like, I can do this, and I believed in myself. And then after a few questions at my interview, I was told that my visa was approved, and I just got my passport back in mail this week. So I'm very excited and looking forward to going back to the US and also just pursuing my master's at Northwestern, and just really, really excited to see how this next part of my journey unfolds.
I'm excited for you too, and all the best, So looking forward, maybe next time we hear from you, we can hear more about your success and your journey. So it'll be really good to maybe have you back the second time, maybe from there. Who knows?
Yeah,
But
for sure.
also, Yvette, do you have anything to say?
Yeah, so at this point, I think I'll say so. Karan actually recommended a friend of his who was also in 221G administrative processing, and she was going back for her master's at
Mhm.
Georgetown. So you would think that she would have a little bit of an easier time at the window considering they're going to big schools. But I talked to her and I talked to other people who have been 221G refused. So even though Karan had a couple of questions, you can expect a little bit more questions. So I'll go through at this point and ask some of the questions you might get when you go back for a renewal after you have spent some time in the United States on your F1 visa. So questions could be, what's the purpose of you going back? Your original visa was issued back in 2018 for undergraduate study. Did you complete it? Please hand over your I-20s from undergrad. What was the purpose of your undergraduate education? How did you fund it? Are you done paying off those loans? How are you currently funding your master's? who's paying off those loans, what does your parents do, what are their salary, and your visa expired in this date. Why did you wait to come back? Why did you not come back at that point to renew it? Why are you waiting until a year later, even though they could technically stay in the US on an expired visa and remain in status? The consular officer still asks this question. How many semesters do you have to graduate, or what is your master's program like, depending on your circumstances? What's your current GPA if you're in the middle of a program? And what was your GPA in undergrad? They may ask for both those transcripts. What are your plans after completing your studies? And if you've been on OPT, had internships or any sort of jobs, please explain what those are. Do you have employment letters? Do you have any tax documents? So as you can see, there's a lot of questions. And for example, if you have a huge student loan from undergrad that you haven't paid off, and now you're going for a master's program that's really expensive, even if it's an excellent master's program. I know consular officers who've refused people going to Harvard because that person couldn't explain the legitimacy of the loan that they took out, for example. So those are just some of the things I just wanted to add for our viewers or watchers. Thanks.
Very helpful. Thank you so much, Yvette, for those questions. Because, when people prepare, folks out there prepare for themselves for interviews, they have all these questions. What are they going to ask? How do I prepare myself? So I'm sure that would be very helpful. Thank you, Yvette, once again. Well, come back to you, Karan. You were saying earlier. So if you could actually be more specific, maybe what tips Yvette gave you particularly to be cautious about.
Yeah, I would say like Yvette gave a really, really good list of questions. So when I was like preparing for my interview, I definitely prepared all of these questions. I would say like some of the tips that she gave me was like definitely around confidence, just like try to connect to the visa interviewer, like don't just use jargon or like say words to like say words. So I feel like when I was talking in my answers, like I was giving a little bit more like to the point, like a lot more bookish answers than like trying to connect to the visa interviewer. So it didn't feel like that honest, or like didn't feel like it was coming off like a conversation. So for me, like I just wanted to make sure that the answers that I was giving was like very, very conversational. I'm being to the point, but also just addressing the question and not giving up too much, and not like leaving the answer to a lot of assumptions. So I think a
Okay.
lot of the questions they talked about, actually, I got like five of those. Like some of the questions I was asked was like, what was your undergrad GPA? When did you graduate? Why are you going for Northwestern? What will you specialize? Why are you going to be doing this right now? Who's going to be funding your education? So just like being honest and just making sure that all your answers are like to the point and just being confident. So I feel like a lot of people lose that confidence. There's also a lot of nerves with you that day. And a lot of people also just forget like, okay, why were you doing this? And why are you like actually going for this program? And it's as simple as just looking into your SOP, like statement of purpose, and be like, okay, this is why I applied for this program. And the day of just like making sure when you're actually talking to the visa interviewer, just being confident and honest and to the point, is I would say all the different tips that I received from Yvette.
Okay. Thank you so much. For giving us that sneak peek into your journey before, appearing for the interview with, and Yvette got you prepared for it. So totally, I'm sure you recommend Udeti to everyone out there watching us. Do you?
Yeah, 110%. I feel like if anything, um, you at least know what the visa interviewer is thinking. And I feel like just having a third person in the room who totally has that experience of like interviewing thousands of people who have gone through a similar process in the past is very helpful. And then just getting like honest feedback on like, okay, if you're saying this, like it's actually not coming off the right way that you're trying to portray the answer to be. And then just getting feedback on like, okay, this is how you can say the answer, and like this is how you can portray yourself in a better way to make sure that what you're trying to say actually comes off right. So I think Yvette and Odeti's services are very, very beneficial from that end. And also just like being prepared for the interview, just like understanding like what all documents do you need, understanding like what the visa interviewer might be thinking and what might be going on in their head, and just like knowing the ins and outs of like what you can expect the day off. I think for me, I like to be very well prepared. So just having all of that really, really helped me like just be calm and myself the day of the interview. So
Yes, you
yes, to all the
definitely.
viewers. Yeah, I was gonna say yes to all the viewers. Definitely reach out to Yvette and Udeti and use their services.
Yes, definitely. Thank you so much for that. And when you do, friends, don't forget to use IT people. It's the promo code for you to get a 15% discount. All right. So,
Thank you so
also, like,
much.
sorry.
I was just thanking him for that feedback. Thank you.
Okay. And, well, I thought I have another question I would ask Karan, if that's okay. I would like to know, how did you navigate your time on OPT and STEM OPT, while working on a top firm like Deloitte? And what strategies did you use to maximize these opportunities?
Yeah, of course. So I would say like on an F1 visa, like there's definitely a really, really good opportunity of using your OPT and STEM OPT. For me, like as soon as I graduated, or even more, like even before, I was definitely very interested in hands-on learning experiences. So I always wanted to like use the experience, use the knowledge that I've gained in the classroom to an actual outside the world, outside in the real world scenario. So actually doing a lot of projects in classes, doing projects with different companies in college really helped me kind of get that perspective. And as soon as I graduated, I was very lucky to have a very, very good offer to go work at Deloitte and the analytics side of consulting in Chicago. So for me, when I was navigating that, it was definitely a very challenging time because it was COVID, and 2020, 2021 was very difficult to find good jobs and like find good opportunities. And for me, like one thing that really, really helped me was like just being resilient and being consistent. So for me, I applied to a lot of different jobs. Every single day, but what ended up working out for me was like the network that I built and just the connections that I had. So one of the things that really worked out for me was like reaching out to an alum of Miami University who was working at Deloitte, and he also had a very similar background of like having experience, engineering degree and then going into consulting. So I reached out to him on LinkedIn, had a call with him, had a coffee chat, and then he ended up recruiting me from Miami of Ohio in near Cincinnati, Ohio, to come to Chicago and like work at the very, very, very good top firm in the world. So I was very lucky and very excited for this opportunity. So as soon as I moved to Chicago, I was excited to like use my learning experience, learning opportunities from school, and see what all I can learn. And for me, OPT and STEM OPT really helped out in that way, because getting that 3 years of experience from Deloitte and actually leveraging that time well was very, very keen for me to go into the master's program as well. And at Deloitte, I did so many different things. I worked on some of the top technology clients in the world. I worked with people all across the world, had teams in Netherlands, India, Australia. I was actually the youngest consultant in my team of 200 people. So definitely felt like I had a lot of responsibility on my shoulders. So that really helped me kind of navigate my career and understand like what do I actually want to do. And at Deloitte itself, I was able to find my passion in product management and passion for technology. So I feel like that 3 years of OPT, STEM OPT really helped me understand like what do I want to do in the future. So after getting that experience, I'm really excited to move into Northwestern now and get like my master's degree. And after graduating, I'm looking forward to seeing how I can use that experience in my bright future, hopefully soon.
That's really amazing. I just wanted to say what, an impressive, articulate young man you are, and how me and Napasa are probably both very impressed at your level of dedication, emotional intelligence, and, just overall, I think we both met a lot of people. So I just want to give you that compliment. That's very inspiring for people. So I think that's why it's important. The question I have for you is, in high school, you said that you didn't really believe in yourself as much until you scored the highest, and now you are an overachiever. But I kind of believe that seeking external validation can be somebody's downfall eventually if they don't achieve what they hope to achieve. And even though it gives you so much validation and confidence, it just takes maybe one thing in life to feel like maybe did I do well enough? So my question to you is have you found that internal belief in yourself, or do you still feel like achievement is giving you that gratification that you're looking for? I'm just curious.
No, I would say I've definitely found that because for me, like in the last 2, 3 years, were definitely I was achieving a lot of things, but it was also like at that stake of like not being able to see my family, like not being able to be with them, like not being able to be there for my sister's graduation. So I feel like all these gratifications were helpful for me, like to be in the mindset that I was, that I want to achieve something in my career. But outside of that, like when I was looking at me as a person, I was losing a lot of good moments with my family, and also just losing that important touch in that important years with my family. So I feel like I did a lot of like self retrospection in the last 2 years, like as you said, like just having that gratification from what's next, like getting something done, achieving something, and then like figuring out, okay, what else can I do, was definitely the mindset that I had when I was 20, 21, like very young, graduating from a good college in the US. But I feel like once you actually are in the real world, once you're independent and like working for a big company, but actually in the zone where you don't have somebody like telling you what to do, you don't have like a set career path or like a set journey, that really helps you like kind of be that person to understand like, okay, what do you actually want in life? So I did a lot of self retrospection in the last few years, and for me, like now all of these things that I've accomplished is just like something that I worked really hard for. But for me now, what I seek is like real connections and real values and real moments with my loved ones. So for what I wanted to do in the last 1.5 months was like to just connect with everybody that I've not been able to see, and just get that motivation from the people rather than the end results. So I think that kind of worked really well for me in this last 1.5 month, and I feel really, really motivated, really, really looking forward to see like, okay, now what can I do for these people? Like, how can I support these people? My family is what motivates me. My friends is what motivates me. So I'm excited to keep on building those relationships and just be very mindful that, okay, like if I want to do something next, like what else am I missing out on, just because I want to do this one thing that might be um, like loving and good in this one moment, but it might be something that I regret in the future. If that makes sense. Sorry, it's a very deep answer.
No, I love it. That's amazing. I love that answer. I'm glad that you were following and were able to respond to my kind of complex question. So love that. Thank you. I think back to Napasa now.
Yes, lovely, and it's truly very inspiring, to see you achieve, and you're sharing your story with us today. It's really great, and like Yvette was saying, you're an overachiever, but I would say you are. I mean, also that, but you are so sorted. Like you know already from now, 2 years from now, where will you be or what you want at least. I mean, most of us we have a hard time figuring out our week, or even the weekend for the matter. So hats off, really. It's really good to stay focused, know what you want, and yeah, stay inspired. And thank you so much, Karan, for this, really. So Also, maybe Yvette, if you could, I think my next question to you would be, what are the key factors that consular officers look for during F1 visa renewals, especially for students who have spent an extended period in the United States?
All you can do is submit your I-20 and have a good DS-160 that explains your time in the United States. If the consular officer has any additional questions, like I said earlier, they'll just call you in for an interview. It's nothing to be feared as long as you have all the proper documentation and a DS-160 that is clear and concise and not overly rambly. Hopefully that'll be enough for the consular officer. But if you've spent an extended period of time in the United States, probably you will be called in for the interview. So just do what you can to avoid it. But if you go in for the interview, be prepared because they, like I said, you can be called in for 221G even for minor questions. So long stays in the US generally generate a interview.
Right, right. Thank you, Yvette, for that. And moving on now, again, back to you, Karan. So, Karan, talking about the interview now, what was your mindset when you got in, during that in-person visa interview after being in this 221G? And how did you, prepare yourself? And what advice would you like to give others who are watching us right now in a similar situation?
Yeah. So as I said, like my timeline was very, very like rushed. I kind of got my 2 to 1G slip on a Friday. I reached out to Yvette for a counseling appointment the Monday. The Monday morning, I actually flew across the country from Punjab to Chennai, and it was an 8 hour flight and a few hour delays and like layovers and whatnot. So I reached in Chennai around 9 p.m. And then as soon as I got into my hotel, I got settled, and in about an hour and a half, I had a conversation and a counseling appointment with Yvette. So through throughout, I was actually very well prepared. I thought through like all the different questions. I thought through like what all was I gonna be asked. But I was definitely a little bit nervous because everything was kind of dependent on this one visa stamp. And then I also had like a lot of different timelines kind of built into like my travel back to the US, and then like just getting ready for my orientation and all the classes. So definitely had some of that nervousness that like what if it gets rejected, or what if I have to like show up again. So those things were creeping in my head. And then the day of my interview, I actually, after talking to Yvette, I was very confident, and like I kind of took that confidence with me to bed. And then the day of my interview, I woke up early, tried to get to the consulate like an hour before, and then went in like as soon as they opened. So as I was going in, I was seeing all these different people. I was seeing all the different nervousness and all the smiles and all the cries, just so many different emotions in the room. So that also made me happy and scared a little bit. But I'm not sure if people have seen Ted Lasso here, but they have a really, really good motivating kind of poster there, which is like, which says just one word, like believe. And for whatever reason, that one word just kept on coming into my head, that I gotta believe in myself. I gotta stay confident and just like get it done. So I feel like at that point, as I was like approaching the line, I just like didn't think of anything and just had that word believe in my head. And as I approached the counter, I just went in and I was like, you can ask me anything. I haven't done anything wrong. I definitely have a pretty good track record, and I'm looking forward to like getting this done. So as soon as I got there, I was asked like, what was your undergrad GPA, and where are you going and why are you going there? And as I answered those confidently, I feel like the visa interviewer also kind of got a little bit more understanding on like why I was asked to come in for an interview and like what's going on. And then after the last question was like, who's going to be funding your education? After I answered that question, I was told that, hey, your visa got approved. And I can't believe, I was like really, really happy. I asked the officer that, hey, do I need to put my fingers anywhere, like am I done? And she was like, congrats, you're done, you're good to go. And I was like really, really happy after that. So I feel like it was definitely so many different emotions that day. But as I said, just having that confidence and just like knowing that you can get it done was something that was very, very important, and something that really, really helped me the day off.
Very nice, very nice. So maybe Yvette, would you like to give out some more tips maybe to folks out there to prepare themselves and maybe gain more confidence before the interview?
So for the minority of students who find themselves in a position of going for a bachelor's degree first and then a master's degree, a couple of tips, or even if they go for H-1B in the future. First and foremost, always use your visa well. Never have unauthorized employment that you could potentially get reported for. Never steal anything because minor arrest records will show up and it happens more than you think. Never try to find OTP or STEM OPT with companies that are not legitimate or pay training organizations that you don't have direct referrals for to get jobs, because there's a lot of scammers out there that may say, hey, pay me $3,000, you'll do some training, we'll give you a placement, and that placement isn't real. And now you have on your record a company that does not exist. So all these things can be major hurdles. And you hear Karan was confident because he did everything well and appropriately. Karan actually also paid off most of his loans through his OPT and had a plan for paying for his master's program. So if you're going for an undergrad and you have a lot of loans and then you have not paid those loans off and you're going for a master's program, then finances are going to be a major issue. So these are just some tips when you are going back that may prevent you from having problems with your H-1B or your F-1 visa renewals. So I hope that's helpful.
Thank you, Yvette, for those tips. Absolutely, that would be very helpful. Also, now moving on, now, Karan, my next question to you is like you're now set to continue your journey at Northwestern University, pursuing a master's in engineering management. So, what motivated you, to take this next step, and how do you see it enhancing your career?
Yeah, for sure. I would say like just being at Miami University and like being around people from some of the top places, some of the top cultures, and like a lot of different smart people in my career have helped me like understand what I want in my life. So I feel like after being at Deloitte, after actually founding a smaller kind of startup product at Deloitte, I really, really enjoyed that journey of being able to like start something from scratch and like leading something from end to end. So for me, like having that technology background, but being able to be that bridge between business and technology was always very, very important. So as I was thinking through like, okay, what's the next step in my career, I could have stayed at Deloitte and like just be a manager and like kind of kept on going towards the route and like kept on jumping the next part in my career, next stair in my career ladder. But I wanted to use this time well to actually accomplish something and like leave an impact. So at Northwestern, I'm very, very looking forward to like actually working on a lot of different products and like starting something of my own, and also just using the great background and connections and like working with professors from some of the top companies in the world. I really am looking forward to learning from them and also having that as part of my future board of directors in whatever company I found. So for me, this is like kind of a bet on myself. I want to use this experience to see what can I learn, what else can I grow myself in, and like what can I like leave behind when like I go after so many years in this world. So for me, I think this is a very, very much once in a lifetime experience and once in a lifetime opportunity. So I'm looking forward to getting those very important technical skills, but I'm looking forward to gaining these management, leadership, and also just emotional skills from people and the professors that I'll be working with.
So lovely, so lovely. All the best for all your future endeavors. I would say academics or non-academics, all the best really. And we really hope to see you succeed more and more. So Udeti, why did you choose Udeti and what would you like to tell folks out there? Why should they also go check out Udeti?
Yeah, I would say Udeti is like one of its kind service in this whole like kind of wide world, because like having Yvette with that experience of being an ex visa interviewer, after interviewing so many people, like knowing what kind of goes in the people's head, like what is that red flag that the visa interviewer might be looking for, how do you actually fill out your DS-160, how do you like put your best foot forward. I feel like just having that um, kind of counseling, but also like you're somebody who can guide you through that process is very helpful. And Yvette and Udeti have also like written a lot of really informative blogs about like end-to-end process on like F1 visas, different categories of visas, and like what kind of documentation are they looking for, what is like DS-160, what are some of the do's and don'ts in filling that form, and also just understanding like what is something that can kind of get you that 2 to 1G, but also like some of the other categories of refusals that are offered by visa interviewers. So I think that these services end to end is like one of its kind, and something that I highly recommend to people just to understand like what might be kind of going the day off in your interview, but also just preparing yourself beforehand and kind of giving your best foot forward and best shot at the visa interview. Because as Yvette said, like as you keep on getting a refusal after refusal, it's very hard to get the same visa stamp, especially if you don't have anything changed in your profile or like anything changed in your documents. So I would say definitely use the service now so that you don't regret not putting your best foot forward in the future.
Right. And Udeti, I'm sure you have enhanced Karan's journey greatly, and here he is with his success story. I'm so happy that we could do this today. So far, so good, and I'm sure we'll have a lot more to get to know. I mean, once Karan is also there, we'll love to know about your products, and who knows, use them also in the future if we have a chance. But also to Yvette, maybe my next question to you is, uh, in Karan's case, how does sending an extended time in the US, on an F1 visa affect his renewal prospects, visa renewal prospects?
So I would say that spending an extended period of time in the United States is always going to be a cause for question. And for some people, it's totally understandable. I went to undergrad, then I went to OPT. And for others, they may need to be doing a little bit more explaining. So I would say it's really case by case. But if you have spent a long time in the US on an F1 visa and then you're going to go back for a master's or a PhD, just definitely expect to be called in. Like I said earlier, just be prepared with a pristine DS-160 or I-20 and have a have the time in the United States that you are spending be all legal and without any cause for concern, and your renewal chances are going to be a lot better. So
Great, for sure. So, in order to have a smoother renewal process, and I'm sure you have your status and you have doubts about how should you go forward, it's always best to consult an expert, and definitely you should also contact Udeti. You can contact Yvette Bansal, former US consular officer, and her number is scrolling on the screen. And I would like to wrap up today's session. So Yvette and Karan, maybe have an end note from your end. Let's go with Yvette first. What would you like to say to folks out there?
yeah, so I would just say that I don't know. I have a lot of thoughts in my mind, but I would just say, prepare for your visa interview. There's lots of resources on udettivisa.com, the blogs that we have. So if you can prepare on your own, that's totally fine. I love all the plugs here today, but we do have a lot of free resources too. So don't, feel obligated. I just want to, congratulate Karan on the story that he shared, and thank you guys for hosting me and him, and I appreciate it. Until next time. So thank you for the informative session here.
Thank you, Yvette. But before we go, I have an interesting question from our team as well. So, how many visas have you rejected in your career, Yvette? And if you have any major reasons, it'll be really nice.
Probably rejected. I don't know if I can guess, maybe at least 10,000, maybe 15,000 visas. rejection, I would say, maybe more. It depends. A lot of the visas I adjudicated were interview waivers, as well as in person. So there's a high visa rejection rate in India, and the major reasons for rejection are unclear purpose of travel and finances.
All right. Thank you. Thank you. That was from, all right. So now let's go on to Karan. What do you have to say as an end note?
Yeah, thank you again for having me, and thank you for just like letting me tell my story to this world. So I'm really looking forward to hopefully inspiring at least one student, and hopefully somebody looks at this video and is looking very excited and looking forward to their journey in the US and looking forward to what all they can accomplish. So one thing I would say is like sky is the limits, and take this opportunity to study in the best country in the world the best way you can, and just never look back. And you've done so many things to be where you are at, and also have kind of done everything right until this moment. And this F1 visa will also be in your pockets as long as you do your best and as long as you put the best foot forward. So don't be nervous, have confidence in yourself, and sky is the limit. And I'm sure you're going to do great in the US. And thank you again for having me, and I'm looking forward to seeing a lot of people from the viewers in the US and hopefully getting to talk to some of them soon.
Absolutely. Thank you so much, Karan, for joining us. And here's wishing you all the very best for all your future endeavors. It was great having you here. And definitely your story is truly very inspiring. And thank you so much, Yvette, as well, for giving all those tips. Very helpful. I'm sure folks out there are excited and are already feeling a little more confident, after watching us here in this webinar. So thank you once again. And folks, if you want to contact Udeti Visa and contact Yvette Bansal, former US consular officer, to get yourself more prepared for visa interviews, call on this number 630-303-6165, and you can even email her. That is, note down the email address, yb@udetivisa.com, and go visit udetivisa.com for more details. And to book a consultation with Udeti Visa experts, use this promo code IT People. You can see it on top of our screen, and you'll definitely get a 15% off on using this promo code. So thank you so much, folks. Thank you for joining. Thank you, Ved. Thank you, Karan, once again. And here's wishing you all a happy weekend ahead, and hoping to see you again very soon on Immigration and Jobs Talk Show.
Thank you.
Bye.
Thank you.
Thank you, friends, for joining us wherever you're watching us from, on YouTube, LinkedIn, or Facebook. Thank you. And don't forget to subscribe to us. Our channel is Immigration and Jobs Talk Show, not only on YouTube, but also on LinkedIn and on Facebook. Connect with us. It'll be very nice. And don't forget to hit the bell icon to, be updated whenever we have discussions like these, webinars like these. And also feel free to contact me. My number is 408-335-6444 regarding any sort of immigration questions. And also remember that we also sponsor H-1B visas. And my email address is nipa@higheritpeople.com. And to get to know more about us, go check us out at www.higheritpeople.com. Bye-bye for now. This is Nipasa Pradhan signing out of Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higherit
Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm Napasa Pradhan, and I'm going to be your host for today. And it's going to be a fun webinar because we are going to discuss about major hurdles in US immigration. But before I tell you more about the topic and also about the guest who's going to join us, I have this important disclaimer to read out. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, a very warm welcome to all you folks who have joined us. And good morning, good afternoon, or good evening, whatever the time zone you may have joined us from. So, yes, thank you so much. And like I was saying, today's topic of discussion is major hurdles in US immigration and how can you overcome the challenges is what we're going to discuss in today's webinar, which is going to go on for about an hour. And friends, we are streaming live right now, not only on YouTube, but also on LinkedIn, Facebook, and Twitter. So thank you so much, all you folks, for joining us. And if you have any questions related to immigration, and especially, with the topic of discussion today, it'll be very nice to have your questions because we are going to have our expert join us, and she is none other than our very regular guest. She is attorney Prashanthi Reddy, and she has been practicing immigration law for over 27 years and counting. So, very lovely to have you with us today, Prashanthi, once again. Thank you so much for joining us. Sorry, Prashanthi, you're muted. Just.
Oh, sorry.
It's okay. So good to have you. Thank you for joining us. We can hear you now.
Can you hear me?
Yes, we can hear you.
Okay, I wasn't muted. I don't know what happened. Yeah.
Okay.
As I was saying, it's great to be here again.
Thank you, Prashanthi, and I'm looking forward for a very insightful webinar, and hopefully it's going to be very helpful for the audience out there who have joined us today. Thank you so much. So today's topic, major hurdles in US immigration. This is a topic of concern, definitely, and a challenge faced by many immigrants out there. So, Prashanthi, what can viewers out there expect from us today?
Well, we'll talk about, what the topic says. What are the challenges that are faced by immigrants? What are the challenges faced by USCIS? What are the political challenges? What, if any, are the solutions to these problems? And, also some common mistakes that, immigrants tend to make while filing their application. So I think, these are the things that we'll cover today.
Absolutely. But before we dive into the topic further, about the second selection round announcement for fiscal year 2025 H-1B cap, I think we have to talk about that since we always have people asking. I think before people ask today, it's our turn now to let them know. So what do you have to say about this? USCIS recently announced a second selection round for the fiscal year 2025 H-1B cap. So maybe if you could explain a little bit, what this means for applicants out there and how they can improve their chances, maybe if they have any.
Yes, so that's great news for everyone. USCIS has decided to conduct another lottery. The reason why USCIS has decided to conduct another lottery is because the applications that were previously selected, not everyone filed for their H1. So that's what they do usually. They do first round of lottery. They select enough people that they think will even cover the ones that don't file, but it looks like they didn't select enough people this time. So though it's over if it's 85,000, I think they've selected some 100 and something thousand. So it looks like a lot of people have not filed, and therefore they're still need more numbers to complete the lottery. So because they want to use all the H-1B numbers. So when they find that they don't have enough H1s to cover the entire cap, then they do another lottery. And that's what they've announced yesterday. Their announcement is that they will have another lottery. They have also announced that they will do another lottery, but not for the master's quota.
Masters,
The lottery will
right.
be only for the general quota. What does this mean? This means that anyone, of course, will be everyone will be put into the lottery again. All those people who have registered as of the deadline in March, you cannot register again. So those people who have already registered will be put into the lottery again. There won't be a separate lottery for master's cap people. Usually how it works is there's a 20,000 numbers are put aside for master's degree holders, US master's degree holders, and the rest of the 65,000 are for the general cap. So what happens for master's degree holders is they get two picks into the lottery. So they're first put into the 20,000 lottery for the master's cap, and then if they don't get selected, they're put into the general 65,000 lottery for for everyone else.
Yes.
So that won't happen, meaning that the master's cap people will not be put into two lotteries. They won't, because it looks like the 20,000 master's cap quota has been filled, but they'll still get a chance to be put into the regular lottery,
Okay.
with everyone else, right? So they will have one chance to get selected again, along with everyone else. And they haven't done the lottery yet. They'll do it in the near future. That's what they said. And once they do it, then we'll get notifications in our USCIS portal as to which cases have been selected. And they will finally then include, selected, not selected, denied. These are the things that'll come up as final status on our portal. And the selection notices will also be attached as PDFs in the portal. So we just print it out and then submit it along with the application. Once they do the lottery, then they will again give us 90 days to file the H1. So you'll have 90 days starting from the date that the lottery is conducted. It'll also say on the notice as to when your 90 days period is getting over. So perhaps if they do the lottery in August, then November might be the end date to file all your H1s. Maybe the end of November. So we have to wait and see. So that is information about your lottery, and that's breaking information. Everybody's been waiting for it. There was a lot of speculation as to whether there will be a lottery, there won't be a lottery. A lot of people on the ground, a lot of companies, IT companies, did tell me that the market is bad, so they have not filed, even though they have been picked. Their candidates have been picked in the lottery. So this was somewhat expected, but you never know with USCIS. Also, we don't know how many cases, how many numbers are left over. So we don't know that either. So we don't know how many how many people they will select for this lottery. We'll wait and see. They do announce those numbers end of the fiscal year. So we will have those numbers at some point. But as of now, we don't know how many more numbers are available. So we don't know if it's a lot or if it's, only a few. So let's wait and see.
Yes, absolutely. But it is the time where you can definitely be excited, friends, and look forward for this second lottery that you have been waiting for. So they have finally announced yesterday, and it is happening. So look forward for it. And all the very best to each one of you. Probably folks out there who couldn't make it to the first lottery, this is your second chance. And let's hope for the best, pray hard, and keep your fingers crossed as well. So thank you so much, Prashanthi, for that update, and definitely a breaking news. So once the numbers are out or any other update on this is also available, we are sure going to update you. So don't forget to subscribe to our channel, Immigration and Jobs Talk Show. And thank you so much, Prashanthi, for that once again. Moving on to our topic back again, major hurdles in US immigration and how can you overcome the challenges? I have another question regarding this, actually the first question. So Prashanthi, if you could tell us, what are some of the common cultural adjustments and challenges that new immigrants face, when moving to the United States, and how can they prepare for these challenges?
Right. So a lot of immigrants, of course, there will be cultural language barriers, which put immigrants at a disadvantage because they don't have enough information sometimes. They don't have the resources. They don't know where to go, who to ask. They don't have an idea as to what the law is. So those are always challenges that immigrants face. So one of the primary challenges immigrants face and entrepreneurs face also is the presence of as you were saying, cultural and language barriers. So now always navigating a new culture, understanding, what the local, for a businessman, understanding what the local business practices are, communicating properly in a, in a language that is foreign to them can be daunting. However, many immigrant entrepreneurs do, adapt and, are able to, scope the market out and, find their market share and communicate quite effectively. Luckily for Indian nationals, English is not an issue. So they face less cultural or language barriers when compared to, people from other countries where,
Language.
English is not their main language. However, there are many, even for them, there are many organizations, there are many immigration attorneys that you can contact who might speak your language. There are a lot of resources online that can help you, overcome these cultural and language barriers. I think in addition to this, limited access to finances is also another problem that a lot of immigrants face. Especially entrepreneurs, because they don't have family here, they don't have, financial resources available here in the US. Often it's difficult for them to, to move their financial resources from India to the US. And, that's not always possible and it's time consuming.
Yes.
They don't have, we see immigrants here may not immediately get a credit card because they don't have a credit history, right? And they're unfamiliar with the banking systems. They don't know how to get loans. And sometimes if you're a non-immigrant, you may not be given a loan, like if you want to buy a house, etc. So that's another thing that, immigrants often face. They may not get student loans. Even if they do, the interest rate might be really high. As opposed to if you're a permanent resident or a US citizen, you obviously have a better access to finances and to loans. However, there are options available. There's, funding sources such as crowdfunding, personal banks, networking, and a lot of financial institutions do offer loans to people on a H-1B as well. So, there are solutions out there, but there are problems as well. Also, I guess the immigration law itself is so complex that it's often confusing for a person, especially who has just arrived from, outside the country, to navigate this entire complex, immigration system. Even for attorneys, it's complex sometimes because, USCIS interprets the laws differently at different points of time. So you kind of have to guess how they'll interpret the law sometimes. And that's difficult even for professionals. So you can imagine how difficult it is, for common folk out there. And the law itself is written, the way it's written is not easy to understand, right? So as all laws are, not sometimes written, for common people to understand, they have to be interpreted. So that's one problem. So obtaining visas, work permits, and understanding, the legal requirements, whether you're starting a business or you've come here as a student, it's difficult.
Yes.
But I must say that entrepreneurs often, they are resilient. As I said, immigrants are resilient and they often find avenues, they seek legal advice. They partner with experts, they go online, they do their research. And there are also a lot of government advocacy groups that will teach or educate immigrants on what their rights are, how to file for citizenship, what to do, what not to do. So there are a lot of public engagement from USCIS as well. Also, another challenge is maybe they have, immigrants have, people who are immigrating here, other I must say non-immigrants, have limited professional networks. So for them to, find out information, they don't know anyone that can help them. They're mostly, they might be, like if a student comes here, they might be all alone. They might not have any family here. They have to depend on their peers and their other student bodies, or maybe their DSO in their school, to find out
Yes.
what kind of you know to find out about everything, not just immigration but everything, where to get a
Yes.
credit card, how to open a bank account, everything. But
Yeah.
luckily there are a lot of mentorship programs, and there is a lot of support out there for entrepreneurs as well as for people who come on a H1 or students who come here. So there is some help out there. So it's a matter of finding the help.
Mhm.
And last but not the least, I think what a lot of newly people who come here newly encounter is trying to balance out their family responsibilities, their entrepreneurial pursuits, keeping in status, their job, it all becomes rather overwhelming and difficult, right? So, especially for people who have young children, if they're trying to set up a business at the same time, trying to figure out what the laws are, open a bank account, etc., etc. It can be very daunting. But again, there is a lot of support out there. So I look for the support. Don't try to do everything on your own. So that is
Yes.
some of the hurdles and some solutions available for immigrants, people immigrating to the US, in general.
Thank you. Thank you, Prashanthi. Thank you. That was very clear, actually. But when we talk about culture, especially, and if you think about America, I think what comes to mind is the work culture, how people are actually in America to hustle and to make money and to have a better future, retire early, maybe, things like that. So that is the common culture that comes to the mind. But if you can give us a little picture of just like that, like a sort of a culture out in America, so that people out there from different parts of the world can really know what are they going to expose themselves to when they move to the United States.
Um, Again, I always try, Nipasa, to stick only to immigration.
I
So I don't
know.
want to go into the culture part of it, because I just feel that, I'm an expert in immigration and not necessarily in culture, but in general, because I've lived here
In
for some
general,
years,
yes.
and since you're asking, yeah. I mean, yeah, as you said, there is the culture here is, people are very hardworking. Most people are. But if you're coming from India, especially, that should not be a problem for you, because I know Indians are very hardworking as well. Um, but sometimes culturally, when you say something, and your body language may not be interpreted the same way, it's difficult sometimes to and interpret the body language of a person, a local, American, or a person, from that culture. So sometimes those barriers are there. Communication barriers, I would say, even though you're speaking the same language,
Yes.
there are communication barriers because body language is not understood, or sometimes when something is said in a certain way, it's misunderstood. Though you're saying it, it's the way that you say it and what you mean when you say something, right? The
Right.
underlying meaning is sometimes misunderstood. So, when you come here and if you're new, always ask. Don't be afraid to ask questions. If you don't understand what the person means or intends, always ask. And people here are very straightforward. They're not cunning or conniving, and they will take you at face value, right? They will not have any preconceptions about you. They don't usually have preconceptions about people. They will take you at face value, and
Mhm.
only if you prove otherwise will they then, form an opinion of you. So people don't generally form an opinion of someone at the get-go, which sometimes people from other cultures do. So
True.
that's a refreshing change. They're very frank and upfront. So that's,
Nice.
something to keep in mind, that they're not judging you. I mean, there is racism and all that, but in general, people don't, they're pretty straightforward, and they will take whatever you say literally, and they will believe whatever you say if you say it, right? So because they're not cynical, and like our
Mhm.
cultures tend to be, sometimes we tend to be cynical. So that's the only, I think, something that maybe I should mention. And
Sure.
also the laws are different here in this country, so always keep in mind the laws are stricter. So you might think that you're stealing something or shoplifting, which might be okay in India, but here you'll get into a lot of trouble if you're an immigrant. So please be careful with even small things. I mean, getting into an altercation with someone might actually end up being assault, right? It might be verbal assault. You might not actually hit someone or cause anyone physical harm. So don't get into any altercations with anyone at any social situations or in a bar, etc. Be very careful with, no means no. So, rape is a big issue here. Consent is very important. So keep that in mind as well. So these are the few things that students tend to get into trouble for. And that's why I thought I should mention it.
Yes, thank you.
Not knowing the law, listening to someone else as to what the law is, thinking that it's okay to break the law because they won't get into trouble. These are a few things to keep in mind. Even simple things like having a driver's license, driving without a driver's license is a huge problem. If you get into an accident and someone gets hurt, it's a felony and you can be deported. Same way with shoplifting, same way with the other things that you might think are petty offenses might actually be felonies, and you don't want to even, have the cops, um, have any encounters with the cops of any kind, because
Right.
that can affect your immigration status.
Thank you so much. Thank you for putting that all out there on the table for us, Prashanthi. I'm sure people out there have an idea now what they will be going to if they're planning to move to America for their future. I mean, whether it's studies or working. And like Prashanthi has already mentioned, friends, you may not have the language barrier, and also, but also, at the same time, the local lingo matters. So what you may say, they may not understand, or what they may be saying in the same language, English, you may not understand clearly. So it's always better to make sure, confirm, ask and re-ask. I think it's always best to play safe. And also same goes with the rules and the law. So do your research properly and see that you're not misled, and don't have the misconception that they are already judging you. All right. Ask. That's always best. Thank you, Prashanthi. All right, let's move on now. I got another question for you, and that is, how can having an experienced immigration attorney help individuals overcome USCIS denials and realize their residency dreams?
So often there's some basic mistakes that people make when they try to file their applications themselves. Um, and so you should, if you use an attorney, it's unlikely that those mistakes will be made because they do this all the time and they have certain processes in place. I mean, human error is something that you can't avoid, but I think they're less likely to make that human error than you are because they know what to look for. They have, as I said, processes in place. They have 2 or 3 people reviewing your case, and also they have a unique knowledge, right, which you may not have. Even if you read online, you may not have the knowledge that they have, right? So they have the knowledge that will help you encounter any situation and will help you um, be able to file the application correctly. Application is not just simply filling out forms, and sometimes even those forms, though it might seem to be pretty straightforward, it's not straightforward. And there are so many instances that I can tell you about. If you're not aware of what USCIS is looking for, you might answer a question incorrectly. You might give the incorrect information because you don't know what the repercussions are, and you don't know actually what USCIS is looking for. Sometimes you might even misunderstand the question. So it's important that you prepare your immigration petition correctly. Even if whether you're doing this on your own or you're doing it through an attorney, and I recommend doing that always through an attorney. Even if they're doing it, you can always make sure that your name, your date of birth, your date of last arrival, all that information is given to them properly so that they can they can enter all the information correctly. um, the fee is very important that you submit the correct fee, and this is something an immigration attorney can help you with because the fee is very, very complicated, especially for certain cases, and especially now where they have add-on fees which are applicable, not applicable to you. it is confusing even for us as to what the fees are on a particular petition, and it took us a while to read and reread the regs and their the practice tips and information that USCIS has provided to understand, for example, what the H-1B fee is, whether the additional asylum fee applies to you or not, what the I-130, like a family-based petition, what the fee is. If you're a certain age, if you're under 14, it's a certain fee. If you're adult, it's a certain fee. When you are over 75, there was a different fee, but now that fee has been removed, right? So things keep changing rapidly. So it's difficult for you to keep yourself updated. You might go to a website and look at the fee, and that might not be the correct fee because it's changed, and that particular website was not updated, right? So always make sure you use an attorney for that purpose. Providing information. So the form sometimes asks for information, and you might think that it's not necessary to fill it out. For example, when you're filing for your green card, they ask you for 5 years of employment, 5 years of address proof, and oftentimes we see people, even when they fill it out, when they give us the information, they don't give us the full 5 years. Then we have to go back and ask them for all the information because they don't realize why it's important and that the case can actually come back or an RFE can be sent. So incomplete filling out of application, and as human beings, we tend to do that, right? We don't, if it's a application is really, really lengthy, we think that, okay, we've given them enough information. If they need more, they'll ask for it. So, that's an example of what you shouldn't do and why you should use an attorney, because they know what has to be filled out, what is optional and what is not. Also, sending your case out to the correct address. This is also very complicated. Addresses keep changing. USCIS changes their addresses as to where to send particular cases. It's complicated as it is because depending on the type of case, depending on where you're living, there are many factors, depending on which your address has to go to a particular place. On top of that, they keep changing that information as well. And they keep changing the criteria based on which your petition goes to a certain address. Also, sometimes when you have documentation that needs translation and you send out untranslated documents because you do not know that you need to send out a document only in English because you don't have knowledge of the law, that will cause a problem as well. And that's another reason why you should use an attorney. But if you're doing it on your own, make sure you send out translated documents. And supporting documents. It's sometimes difficult to know by just going to the USCIS website what supporting documents have to be submitted for each case. So again, an attorney can tell you what documents you need to support. They can review the documents. They can audit them, make sure if the documents are not correct, then they will suggest either correction of the document or they can suggest alternate documents to submit. This is also extremely important. For example, in a green card application, when you're filing a birth certificate, when you're submitting a birth certificate, the birth certificate has to be from the correct authority. And you might not know that. You might submit a birth certificate from the consulate, which is not acceptable. The birth certificate has to be registered at the time that the birth took place. If it was not registered at that time, then you have to submit secondary evidence. And all this is not necessarily there in the instructions to the form. So that's why I'm saying, filing a case on your own can be daunting. You might think it's easy, but it's not. Also, preparing you for your immigration interviews. When you file a green card, when you file a H-1, you have to go for a visa interview. When you file a green card, you'll go for a green card interview, and the attorney can prepare you and tell you what to expect in a marriage-based interview or other family-based or employment-based interviews. This also, again, if you read up, you may not get proper information on how you need to prepare, what the common questions are, etc., etc. In addition to that, if you've ever had prior problems with the law, an immigration attorney can advise you on how you can still apply for your H1 or for your F1 or for your green card, etc. Even with prior issues with the law. So that's another thing, another reason why you might need an immigration attorney.
Absolutely. And so, do you need an immigration attorney? We would all say yes, you definitely need, because there are so many things to keep in mind while filing your visa application, whether you're a student, an employer, an employee, or maybe you're going for a family-based visa. For all these, and there are so many steps and so many things to keep in mind for each document, just like Prashanthi has said. So, you should. I think, yes, you should definitely have an attorney to go through your whole case and help you, I mean, see you through the whole process for sure. But if you cannot afford one, but it's always good to consult one so that you'll be guided in the right direction. So thank you, Prashanthi. And at this moment, I'll quickly say hi because we have questions from the viewers and they have been waiting for us to also take them up. Hi to Reshma, Ravi, Akbar, Shaukat, Chandra, Rag, Caroline. Very lovely to have you and also your questions. I think we should quickly take one. Let's take up Rag. Rag is asking us on YouTube. Entrepreneurs are advised to hire immigration attorneys at the inception phase and not the visa stage. What's your take on this?
Yes, that's a good. I think Rag is also giving us advice
Yes.
indirectly, which is good advice that it's important before you even start your business to consult an immigration attorney, especially if you want to. If you are, if you want to file a green card for yourself as an entrepreneur, or you want to file a green card or a non-immigrant work visa for your employees, it's important to know some things which, then you cannot change. Perhaps something needs to be done at the time of inception of your company, right? Which then will then be very difficult to do once it's incorporated, etc. Then you have to make changes. So it's a good idea. For example, in an L1 situation, if you're incorporating your company in the US, before you incorporate, you have to first ask the attorney what kind of company you need to incorporate. It doesn't matter, which state you incorporate in. What is the organizational structure of the company? Who owns the company? What is the ownership divide in the company? Who owns it? What percentage of shares are owned by the Indian company, or what's owned by the US company? So all that is done at the inception of the company. So it's important to speak to an immigration attorney before you start the process rather than doing it midway. So at the visa stage is really midway. So you should do it in the beginning.
Right, right. Thank you so much, Rag, for that very interesting question and indirectly giving us advice as well. And also Prashanthi for seconding Rag and explaining it further for us. So, Caroline, Werimu, I'm sure this is a very interesting question, but we will take this up after the break. It's now time for a quick break, actually. So, friends out there, if you want to contact Attorney Prashanthi directly, you should definitely give her a call and contact her. And her number is displayed on the screen. Her number is 212 354 1010. Once again, I repeat, 212 354 1010. And also you can email Prashanthi at reddyesq.com. And to get to know more about Prashanthi Reddy and also the law offices of Prashanthi Reddy, go visit this website, reddyesq.com. And folks, don't go anywhere because we will be talking further on the major hurdles in US immigration and how can you overcome these challenges, only on Immigration and Jobs Talk Show with me, Napasa Pradhan.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone, and welcome to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and very happy to have you back. This is the second half of the webinar we're having today with attorney Prashanthi Reddy, and it's really lovely to have you with us today, Prashanthi. And today's topic of discussion is major hurdles in U.S. immigration and how can you overcome the challenges. So far, so good, and it's been very interesting this session. And we also took up a question from the audience. Rag, thank you for your question once again. And I was saying before we went off of the break that we will take up Caroline's question. So, Prashanthi, I think we'll just go for it, okay?
Sure.
Caroline is asking on YouTube. Hello, my name is Caroline. By grace of God, I am DV 2025 selected. My education certificate has my name as Caroline with a Y, while all other documents, birth certificate and PP, has my name as Caroline with an I. Please advise.
I don't see an issue with this. It's not something that can't be fixed. You just get an affidavit. I mean, they're going to obviously follow your birth certificate. I'm presuming that would be the correct document. Just your educational documents that have the wrong name. So you can always submit an affidavit from, your parents or people who have known you throughout your life that your name is this and this. And, at the time of whatever that you enrolled in school, perhaps the name was misspelled. An affidavit should be sufficient to overcome that. But for a DV visa lottery, especially, it doesn't matter what your educational documents say, because you don't necessarily have to submit them. You just have to submit your birth certificate and your
Okay.
passport, etc. So I wouldn't worry about it.
Okay. So, Caroline, first off, congratulations for winning the DV lottery 2025. And there's nothing to worry about. I hope Prashanthi's advice was good for you. If you have any further questions, we're here for a little more time. You can drop your question in the comments. Thank you. All right, let's move on now to another question from the audience. This is Noreen. I am a foreign educated RN and on a visitor visa. Will hospitals sponsor me? What are the options?
Yeah, great question. The problem with filing a H1, so the main work visa is the H-1B work visa. Unless you're from Canada or Mexico, when you have the TN. If you're from Australia, then you have the E visa that you can use. But otherwise, for everybody else, it's basically the H that you have to use. And the hospitals, if they have to sponsor you, they will have to, sponsor you on one of these visas. Narrowing it down to the H visa, they could also sponsor you on a green card directly if you're not from India or China. That could help as well by if they can file a green card in EB2 or EB3, but that might take some time. So in the interim, I don't think the filing of the green card directly will help you start working immediately. So they would have to sponsor you for some kind of a work visa. So for the
Okay.
H1, the problem is that if you're working as a nurse, the licensing requirement for nurses in most of the states in the US are an associate's degree, not a bachelor's degree. And since the job has to require a bachelor's degree in order to apply for a H1, you may not qualify for a H1. There are some exceptions. APRNs, so advanced practice nurses, require a bachelor's degree to get a license. So if you're working as an APRN, you'll be able to get a H1, and of course you have to find a sponsor. But there are two issues here: the immigration issue, and the issue of filing a sponsor. So at least the immigration issue will be resolved. Also, sometimes if you work as a specialized nurse, such as a nurse in the cardiac unit or nurse in the emergency room, it's a 50-50% chance of getting a H1. Sometimes you might. If you're able to show, if the hospital is able to show that they only hire nurses with bachelor's degrees. But otherwise, seems to be a presumption that a nurse doesn't require a bachelor's degree, because to get a license, you don't require a bachelor's, but only an associate. And in the industry, if it seems common to hire a person who doesn't have a bachelor's degree. So these are some of the issues that you might face.
Okay. So Noreen has an update telling us more about her. I am from Pakistan and have passed NC Lex. I have only 4 months left on a visitor visa.
Right. Yeah. So, you'd have to go with the H if someone is able to sponsor you. And whatever I said about the H1, you have to overcome those issues.
Okay. All the best, Noreen. And Caroline says, thank you. I appreciate for your assistance. Thank you, Caroline, also. Thank you. And let's move on, Prashanthi, before we go on to more questions from the audience. If you could, given the rise of the encounters at the US-Mexico border, maybe if you could tell us what immediate policy changes or legislative actions are necessary to modernize the US immigration system and meet labor market needs. I mean, from your point of view.
Yeah, so the US-Mexico border has been a big issue, and that's a big immigration problem. Since we're talking about immigration problems, we have to talk
Yes.
about that
We have
one,
to.
though
Yes.
So I think I mean, there are a lot of organizations, nonprofits that have done research into this and have come up with some solutions. None of the solutions are obviously 100%, because it's a problem. People want to come to the US. They take great risks for themselves and their families to come to the US, because some of them who are coming legally, it's fine, but people who don't have a way of coming legally try to come illegally into the US. And so it's difficult to stop that flow of population from coming across the border. Though, there is a wall, there is CBP, there is border enforcement, border patrol, etc., etc. But all of that, because the border is so huge and people are willing to take any amount of risk to do it, because of the problems that they have back home, whether it be economic or it be political, or it might be that they have, they're fearing for their lives, whatever the issue might be, they're desperate, right? So it's difficult to stop people from coming in. But there are some recommendations that, might work. For example, expand CBP capacity. So CBP is Customs and Border Protection. So if you increase the number of officers and then the capacity to process asylum seekers, so people who have a legitimate concern, if you have more border patrol officers, they can come in legitimately and try to seek asylum rather than trying to cross the border illegally and getting into trouble. They're in the hands of these sharks, these people who take a lot of money and promise that they can help them cross the border illegally, and then we've seen so many immigrants die that way, because these people don't care about what they're doing. They only care about the money. They don't care about the safety of the passengers that they're escorting across the border. So having more immigration officers, CBP officers, can definitely help. Increasing the resources for US Border Patrol so that they can improve humanitarian processing, transportation of migrants, overcrowding, of buses that are used to ship migrants. For that, they need more money. So increasing the resources that they have, maybe establishing a center for migrant coordination, establishing a separate governmental organization to help coordinate, the efforts that the federal and the state and local authorities are doing to help support these newly arrived migrants. This will reduce the impact on local communities. So local communities will not be disturbed. They will not be, homeless people. They will not be, maybe immigrants using up the local resources. Then the local communities get upset, because they're impacted. So to lessen the impact on the local communities, establishing a migrant coordination body can help. Grow federal support for case management alternatives to detention, so that everybody does not have to be detained, because there are only so many detention facilities. Maybe release people from detention as soon as possible. Maybe use trackers instead, so that people can the authorities can track you and bring you to court if required. Revamp the entire asylum processing itself, because asylum process has become so backlogged. So it's important, I think, to revamp the entire system and change the system so that the processing is faster, quicker, more efficient. A big, huge issue with USCIS is their backlogs, right? Clearing the backlogs. Immigration courts have so much backlog that it takes them a year to get their first hearing. So maybe, clearing up the backlogs so that, other people don't have to go through the courts, and they can just use prosecutorial discretion to, take them out of the courts, people who don't need to go through the courts, and open up the court calendar for asylum cases. So there are many, many things. Fund the right kind of counsel, provide free immigration counsel for people who need it. Increase the way of legal immigration for people to come in legally by increasing maybe H-2Bs, like, seasonal workers, agricultural workers. US needs them. So maybe make that easier so that, your borders are more secure and people don't come in illegally. So they can come in legally by applying in their own countries. Because that kind of, those workers are needed anyway, right? The unskilled workers, the skilled workers, etc. So these are a few ways that the backlog can be. I mean, the ways that you can stop the rush of people coming in at the borders.
Yes. And very rightly mentioned. I mean, the backlogs, some dates are still stuck up to 2012, and it's a long gap. I mean, I'm sure more than a decade. And we also had the pandemic and many other natural calamities, even. Who knows, many lives were even lost. So I don't know how, but some filter process is definitely much needed. So thank you, Prashanthi. And I'm sure, if we talk about the many ways, we will keep brainstorming and the whole day may pass by and this 1 hour may not be enough. But thank you, Prashanthi. Yes.
You're welcome.
Also, I mean, the recent updates with Kamala Harris, potentially leading the Democratic ticket. Also, her being an immigrant, a daughter of an Indian and an African. What legal challenges do you foresee in the 2024 election with regard to immigration, through your point of view?
I am going to be very quick about this because we're running out of time, and I do want to take some questions.
Sure.
There have been a lot of questions in the audience. So, and again, this is a topic which can be another topic for an entirely new topic, right? So, I am excited that Kamala Harris is leading the Democratic ticket. I will be worried if Trump is elected. Simply, I don't care about people's political views but from the immigration point of view, it is something to worry about if the Republicans come back into power. So that's my main concern, because they will make getting visas more difficult. They will make getting green cards more difficult. They will make getting H-1s more difficult, like they have done, like Trump has done in his previous 4 years.
Yes.
And the Republicans are also saying that they intend to do it. So they have made their intent very clear. So we will definitely face a lot of legal challenges where USCIS is concerned, where all the other agencies are concerned. And we will have to go litigate a lot more, I think, if Trump comes back, because he will try to do everything possible, constitutional, unconstitutional, to close the gates and allow less people in and make it more difficult for people who are already within the US also. So I think a lot of lawsuits will be filed. That's what I envision if the Republicans come back into power. And people will face a lot of difficulty, but nothing is permanent and there's always solutions for every problem. So let's hope we'll be able to help those people that will face the problems if that happens. That's why we're here as immigration attorneys.
Absolutely. And I do hope to see good changes in the immigration field as well. All right, let's move on now quickly to the questions. And this one is related to what we just spoke about just now. Caroline asking again, will Donald Trump affect green card in Africa in case he becomes the next president of USA?
Donald Trump will affect green cards everywhere in the world because Republican Party has an anti-immigration stand. They're very clear about what their stand is with reference to immigration. So doesn't matter where you come from. If you are a non-immigrant seeking to immigrate to the US, you will have a more difficult time.
Thank you. Thank you, Caroline, for that question also. All right, moving on to this next one. This is from Hussein, also on YouTube. I got my ETA 1998 approved by DOL now. I-140 is under review from February 2024. EB3 visa for other workers category once approved. I-140, what are the chances to get visa from consular or embassy stage? Sorry, I mean my punctuations may not be so right.
It's okay. AB3 visa for other work categories once approved. So if you have, looks like you're outside the country then because you're asking about consular processing. If you're EB3 and you're outside the country, it's going to take a long time because if you, depending, of course, I'm presuming you're Indian national, but if you're not an Indian national, then just look at the visa bulletin for all other countries. EB3 is still backlogged. So you have to look at the dates that they're working on. And if the dates remain current, and then once the I-140 is approved, if you're outside the country, you'll be able to file your immigrant visa petition. And that process takes about 10-12 months. And if the visa numbers continue to be available at that time, you'll be called by the consulate for an immigrant visa interview, and you'll be given a green card if the priority date is current. So that's the process, but it will take some time.
Okay. All the best to Hussein. I hope you figure out what would work best for you. But if you have further questions, you can always comment even after the stream has ended, and even better, contact Attorney Prashanthi directly. Moving on now to this next question, another one from Rag, also on YouTube. Does the rapport with the paralegal at the immigration law firm matter? And do they make or break the case more than the immigration attorney themselves?
Not in a good law firm. That shouldn't happen because the ultimate review is done by the immigration attorney themselves. It has to be in any good law firm and by law as well. Their immigration attorney is required to, if there's a T28, they're required to review the application before it goes out. I mean, having a good rapport with anyone always makes life much easier, right? We know that. From the human point of view, it's always good to have a good rapport with whoever you're working with. Same with us, right? In our law firm, we try to have a good rapport with our clients and develop a personal relationship. So it always has to be both ways. But then hurdles are cleared, misunderstandings are less, and things get much more pleasant and easy. So it's always good to have a good rapport. But I'm not saying because you have a bad rapport or you don't like the paralegal that they have the power somehow to mess up your case. They definitely don't. The immigration attorney should take care of the issue and should file your case properly. And if you're unsatisfied with that law firm, then you should change your law firm.
Thank you. Thank you for taking that up, Farag. Oh, he already says, thanks, Prashanthi and Nipasa. Well, thank you. Thank you for tuning in. And Hussein has an update saying, yes, he's outside the country. He has a Pakistani passport and living in the UAE.
Oh, okay. Okay. So yeah, so then that was the basis of my answer as well.
Thank you. And he says, thank you as well. Thank you. Thank you, Hussein, as well. All right, let's take up another question now. This one is from Reshma. I am facing a lengthy separation from my family due to US immigration backlog. Are there any alternative options or strategies to expedite the process, such as applying for a provisional waiver or seeking humanitarian parole? Can I also explore other visa categories, such as an H-1B or L-1 visa, to reunite with my family sooner?
It would be better if you told me what was your particular case, what status you're. Maybe you have not filed a green card, or you don't have. See, in order to answer your question, I need to know what your immigration case is, what you filed. In general, green cards are taking a long time, but you don't need to be separated from your family because your dependents can come on a non-immigrant dependent visa. So, just give us more information about yourself so we can kind of fine tune our answer to suit, that'll help you. So rather than giving a vague, broad answer, which might not help you, just give us more information about yourself.
All right. Thank you, Reshma. And moving on now quickly to this one is from Chandra. What are the reasons why many individuals who were selected in the first H-1B lottery did not proceed with filing their applications? And does this indicate that the US job market is not doing well, or are there any other factors at play?
I think it's mainly the US. You've answered your own question. It's mainly the US job market not doing well, the layoffs. IT companies, as you know, take up most of the cap cases, and the employers, it's not the individuals so much, but the employers are not willing to file the H1 because maybe they don't see that they'll be able to place the candidates once they come into the US. If the market was doing well, they usually bring in the candidates and they're able to, they've already placed them or they're able to place them pretty quickly into the market. So yes, it is, the job market is the most important factor. I don't think there are any other factors at play here.
Okay. Thank you for answering, Chandra, and thank you for your question, Chandra. And now, last question from the audience, and we will wrap up our show after this. From Ravi. I've been waiting for my priority date to become current for my employment-based green card application, but it's taking much longer than expected. Are there any strategies to expedite the process, such as filing a mandamus lawsuit or switching to a different visa category? Similar to...
So it really depends on what your status is. Are you waiting because your priority date is not available? Then there's not much you can do. You can't file a mandamus lawsuit. But if your priority date is available and your 485 has not been processed for more than 12 months, for example, then that would be a good mandamus lawsuit. So mandamus is basically compelling the government, any government body to do what they're supposed to do. You're compelling them to act within a reasonable period of time. That's what a mandamus is. So that would be a good idea to do. I don't know which category you applied in. If we're talking about the green card, then perhaps if you've applied in EB2 or EB3, you can try applying in EB1. But I must tell you that not everyone qualifies for EB1. It's either multinational executives or extraordinary ability or researchers or extraordinary ability in the sciences, arts, sports, etc. Only they qualify. So you have to see whether you qualify or not.
Okay. Thank you so much. I think with this, we've come to the end of our show, and with all the questions we have collectively, whether from our audience or from my end as well. Thank you so much, Prashanthi, for patiently answering each one of them and making this whole session a very interesting one and an insightful one.
Thank you. Thank you for having me, and I look forward to seeing you next week.
Me too, me too. So thank you so much. And friends, if you have any further questions or want to contact attorney Prashanthi Reddy directly, the details are on the screen. You can call her on the number 212-354-1010 or even email her prashanthi@reddyesq.com. Please note down the spellings. They may be different. And also, if you want to get to know more about attorney Prashanthi Reddy and the law offices of Prashanthi Reddy, definitely go visit reddyesq.com. Thank you, Prashanthi. You have a great day ahead.
You too. Thanks.
All right, friends. And you too, if you want to contact me, you can call me on this number or even WhatsApp me. My number is on the screen, 408-335-6444. And my email address is neep@higheritpeople.com. And to get to know more about us, definitely go visit www.higheritpeople.com. And I would love to say thank you to each one of you for making this webinar a more interesting one. Thank you for your questions, and thank you, Rag, Hussein. Thank you, Caroline and Noreen, and all you folks out there for your very interesting questions. And I'm happy to tell you that I will be joining you with another webinar and another important guest in another hour. So at 2 p.m. EDT, don't forget to join me for another webinar. It's going to be another interesting session. And thank you so much for now. And don't forget to subscribe to our channel. We are Immigration and Jobs Talk Show, not only on YouTube, but also on Facebook, on LinkedIn, and also on Twitter. So thank you so much for now, and have a great day ahead. See you shortly.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at neep@higheritpeople.com or visit our website www